Good morning, Mr. Mybeck. Good morning, everybody.
Good morning, Chairperson.
Good morning, Mr. Kikaba.
Good morning, Chair.
Good morning.
Morning, Chair.
Thank you. Good morning, Mr. Solomon.
Good morning. Good morning, Chair.
Thank you.
Morning
Thank
to you.
Thank you. Thank you. The oath you took on Thursday, Mr. Kikaba, will continue to apply today. Thank you. Mr. Mybeck.
Thank you. Good morning, Mr. Gigaba.
Good morning, Mr. Mybeck.
Could I ask you please to turn to bundle 7A,
Yes.
to exhibit BB 24,
Yes.
and if I could ask you please to turn to page 129. It's Mr. Mklangu's affidavit. Or in fact, it's 996.129.
Just repeat the page number.
996.129, Chair.
Okay.
Yes.
I just wanted to ask you a few questions in relation to Mr. Mklangu's affidavit before we finish off on him. At paragraph 106, he says that the core functions of the minister entailed overseeing the performance of the SOCs that fell under his responsibility and exercising shareholder power in respect of those entities. The latter function involved the appointment and removal of directors of the DPE-related SOCs. Would you confirm that?
Yes, among others.
And then he says at 107, thus my duties as the special advisor to the minister included advising the minister in respect of the decisions he was required to make in the discharging his core functions, including the appointment and removal of directors amongst other functions. Would you confirm that?
Yes. Of course, there was a process, Chairperson, to this. The advisors were part of that process.
So I then wanted to come to that process, Mr. Gigaba. I think you will find that at page 996.133 at paragraph 120, where Mr. Mklangu sets out that process. He says at 120.1, applications or nominations would be received from the public by departmental officials, ministerial advisors such as myself and the minister himself. I just wanted to take you to 120.4.
Yes.
Something that you spoke about, I think, on Friday. 120.4, based on the assessment of the skills gap in a particular board, the legal and governance unit, together with the unit responsible for the SOC, would prepare skills matrix. Do you confirm that? I think you spoke
Yes.
about that on Friday.
Yes, I confirm it.
I could ask you then to have a look at paragraph 120.6, please, at page 996.134. At 120.6, Mr. Mklangu says the DDGs and the special advisors would then settle on a list of candidates. I would then take this list to the minister for his consideration. This ensured that the minister's views were taken into account before an official memorandum was submitted to him by the department to approve recommended candidates. Would you confirm that?
Chairperson, I would note the official process would emanate, I think, as I outlined in my submission. I'm not sure whether it's just, if you just bear with me.
So, Mr. Gigaba, just to locate you, this is in your main bundle. It's the full affidavit of
Yes.
Mr. Mklangu.
Yes.
your response to Mr. Mtlangu is contained in a different bundle that we looked at on Friday, where you responded to particular sections. I can
Yes.
take you there, but as I recall, you weren't called upon to respond to this particular section.
Because what the process, Chairperson, would entail is that the department would initiate, because they would know which board members or which boards are due for rotation, at which point the department would prepare the skills matrix, the report of assessment of the boards and of the boards collectively and individually, and would initiate the process. To the extent that my advisors would bring certain issues to my attention that were still within the board, within the departmental process, that was not part of the process. It would be informal briefings to me, but it didn't happen all of the time or most of the time.
I'm sorry, just take one step back. I missed a sentence you made. You want to look at your affidavit?
Yes, please.
Okay, Mr. Maibek will
Yeah,
help
let me
you
just,
find which bundle.
Mr. Gigaba, let me take you to page 996274. This is where you respond to the affidavit.
996.
996.274.
Okay. Please don't forget the points you were making, because there is one that I missed, so I want to take you back.
So this is your response to Mr. Mtlangu, but you'll see that it doesn't deal, it's not a criticism, with paragraph 120, because you weren't asked to respond to it, it doesn't seem, in the 3.3 notice.
Sorry, Chair, I'm still trying to get to.
But you may set out somewhere.
Mr. Maibek,
Yeah.
you are well ahead of both of us.
Yes.
Just tell us the page again, 996.
274.
274, yes.
274, okay.
So in I
Yes,
think
I've got
from
it.
99627.279,
Yes,
paragraph 8.5,
yes.
I
You set out the process,
set out the process.
all right?
Now, as I said, Chairperson, there was no, in the formal process, there was no requirement that the advisors should take the list and bring it to me, for me to apprise myself of the list, so that I could make submissions before the board, before the department finalizes the board nominations process. That would happen occasionally. It was an informal part, just to keep me abreast maybe of certain things which they thought were important, and then they would rely on me responding to those issues. But the formal official process of the department took place right from the department until the department would present a submission to me. So there were, if I'm not mistaken, 2 or 3 ways in which this happened. It would either be a submission which contained the rationale, the argument, and the names proposed, or if we were preparing for an AGM, we would, in the course of discussing the connotated agenda of the AGM, then as part of that, as we go from item to item of the connotated agenda, we would then get to the board nomination process, and then the department would start by outlining, this is the board that's outgoing, this is the report assessment of this board. These are board members who are either completing their first term and are due for reappointment, or who have completed a second term and must be retired, or who have completed a first term but for certain reasons emanating from the board assessment report, we recommend that they should be retired. Then we would look at those, and then they would say, these are board members that we are recommending. These are candidates that we are recommending should fill in the gaps that are being created, so that we would say the following are being retained, the following are being nominated. Now, that is a formal process of preparing for an AGM. Obviously, exceptions would happen if vacancies happened in the middle of a term or in the middle of a year, maybe as a result of natural attrition or as a result of resignation, in which case, if it was really absolutely important, we would have to look at that 1 or 2 vacancies to fill them in and take them to cabinet. But the official process did not require that advisors should, as part of that process, approach me with a list of people whom I think need to be included on the board.
And so is the difference between what Mr. Mahlangu is saying about the process and what you are saying simply that what you say occurred unofficially and not as a norm, just or sometimes?
Yes.
What he says occurred as part of the formal process. Is that the difference between the two of you?
Exactly, Chairperson.
Okay, all right.
Thank you. If you go back to 20.6, just to pick up on the chair's point at page 996134, so the last sentence, this ensured that the minister's views were taken into account before an official memorandum was submitted to him. Now that official memorandum is the decision memorandum. And that you see reference being made to at paragraph 120.9. The specific sector unit and legal compliance would then prepare a decision memorandum with the motivation for the appointment. And then at 120.10, the minister would either approve the list with or without conditions. And then, as I understand it, Mr. Gigaba, what flowed from that is that on the strength of your approval, the department would prepare a cabinet memorandum. Is that correct?
Yes, that is.
And that would then
process,
serve
yes.
before cabinet.
Yes.
And we've seen various examples of these decision memorandums and cabinet memorandums. I think when we started with your evidence,
Yes.
we dealt, for example, with the appointment of Mr. Sharma, etc.
Yes.
I then just wanted to take you to one other thing in this affidavit, and that relates to, and just to get your comment, it relates to a meeting that Mr. Mahlangu had with Mr. Damas and Ranesh Gupta. That you see at page 996.174. Now, you see at 278, he says, insofar as the meeting between Mr. Damas and Ranesh Gupta is concerned, it arose out of a specific context. And then at 279, he explains, and I'll paraphrase, that one of the companies owned by the Gupta family owned a farm somewhere in Mpumalanga, and it had coal deposits. The Guptas had rights to mine this coal, but certain environmental complications arose. And this had implications for them and the supply of coal to Eskom. And then at 280 over the page, you see at the last sentence, it's on this basis that Mr. Gupta requested that I organize a meeting between him and Mr. Damas. You see that?
Yes.
Now, I just wanted to ask you about that, and I think the chairperson may have raised this issue on Friday. Why did Mr. Mahlangu have to be involved in meetings of this sort? I mean, why did Mr. Gupta not simply arrange the meeting himself with Mr. Damas?
As I say, Chairperson, as I responded on Friday, Mr. Mahlangu might have wanted to understand what was being discussed so that if there was any reason for him to alert me as to some of the issues that were being discussed, he would do so. Because as he said in at the opening of his affidavit, I had asked him to manage these relations because I did not want them to get out of hand. So if there was anything that he needed to raise with me, which would require me either to talk to the CEO involved or the chairperson of the board, or talk to, if necessary, to say to him, Mr. Mahlangu, please tell these guys that, look, this cannot be done for the following reasons, then he would have to do so. I think he just wanted to understand what was being discussed and what would be the outcomes of those things, and certainly not in order to influence the outcomes or create the impression that I was involved. Insofar as I understand, well, I don't remember how this issue was resolved, and so I don't think he did bring it to my attention. I think the matter ultimately required the Department of Environmental Affairs if there were environmental implications involved.
But isn't the impression created that you are involved because your own special advisor is at the meeting and in fact sets up the meeting?
I think he does explain in 282 that he did not lure Mr. Dames to the meeting. He did not know, he knew of the meeting in advance and agreed to it. It was the first and only time he did this, and the purpose, as I outlined before the commission, was not to create the impression that I had any interest in the matter or that the matter had to be resolved in any particular way. Chairperson, let me set this out. This was not the only meeting, and as Mr. Mahlangu and I on Friday explained, there were many other such meetings. In other meetings, I took a more forthright approach in trying to resolve those issues because we were dealing in those instances with organizations and we needed to deal with issues of a policy nature insofar as specific SOEs or all SOEs are concerned. I made reference to the legal, the accounting, auditing, and the advertising stroke marketing professionals, in which case he facilitated meetings, Mr. Mahlangu, and involved me in those meetings. But insofar as individuals were concerned, he did not involve me, and he only attended just so that he understands what was being discussed, as I have said. And there were many other instances, Chairperson, where, in addition to the ones I have cited, where we would have been involved officially as the department in trying to resolve issues of dispute. But all of those issues were not involving individual business people trying to get business from the SOEs. Insofar as these are concerned, as I stated last week, it was only to create accessibility, but Mr. Mahlangu's presence in those meetings was not to influence those meetings, because to the extent that I can understand, he did not make any inputs in those meetings in favor of the business people concerned.
But wasn't this a pure operational issue?
I think, Chairperson, I've responded to this. It was a pure operational issue, but it happens even today. Business people request meetings with various leaders of entities or even departments. There are instances when they come to you as a minister and you say to them, I can't, they would meet us at various levels and they say, can I meet with you? I want to discuss this thing. And you say to them, it's not my issue. It's a matter of the department. I can refer you to the DG, meet with the DG, talk to him, hear what the DG says. He will outline to you whatever you need to understand. In democracies, and South Africa is no exception, you can't create a buffer between business and government. That's why, in part, government established at one stage the CEOs Forum, where out of concerns by business that the economy was not growing, it was in the midst, we were in the midst of a global economic recession. It was affecting the South African economy. Our economy began to decline. A CEOs Forum was established to ensure that CEOs can talk to government on matters which also involved policy, which policy would be in favor of business. Now, in some instances, arising out of those initiatives, Labour would also say, but your meetings with the CEOs is tilting economic policy in favor of business, and therefore we also want a forum where we would also be able to state our views. Now, the issue with such engagement is that it's dynamic and in some instances quite fluid. But the understanding among all those involved is that you do not intend to take a decision out of such engagement that may or will be out of the PFMA and other existing legislation which guides how procurement and supply chain issues operate. So even if it was an operational matter, but you try as government to ensure that you can assist business where you can. I had occasions where I met with the board of Investec on several occasions, and various other companies for that matter. Or in some instances, I would refer those business people to the officials in the department to meet with them. The understanding, I reiterate, was that no decision will be taken which undermined or contravened the PFMA and other supply chain and procurement processes in government and other relevant existing legislation.
See, Mr. Gigaba, I suppose I just want to make this point. On the face of this, Mr. Gupta didn't want to meet with you. It wasn't where he required ministerial intervention. He didn't even want to meet with Mr. Mtlangu. It says at 280, it was on this basis that Mr. Gupta requested that I organize a meeting between him and Damas.
Absolutely, Chairperson. And that's the point which I have been making. That's the point which I've been making, that as government, we from time to time have to assist business to meet with relevant leaders in the organization so that they are able to state their issues. And the understanding arising out of that is that there will be no decision taken which contravenes the PFMA, the supply chain management process, the public procurement process, and other existing legislation. This is the point which I am trying to emphasize. It is not me. I said earlier that I did not want to be the one who facilitates these meetings. And to the extent possible, when somebody raised these issues with me, because I don't have time to be facilitating meetings and looking at the diaries of leaders of entities or departments, I would ask my advisors to arrange those meetings and to go ahead. In this case, Mr. Mtlangu was doing what I had said he needed to do in order to manage relations, but he understood what was the clear instruction provided to him. And that is why he says in 282 that there was no influence put to bear in the meeting, and even though the meeting ended the way that it did, Mr. Mtlangu says that is it 282? He says that it was the first and only time that he went with Damas to the meeting because of how the meeting ended, and he realized, as a result of the instruction I had given, that such meetings should not result in anything untoward. He then, after that, did not arrange such meetings.
Sorry, Chair, I see you took off your mask, which is usually a sign of you wanting to say something.
Well, sometimes I want to say something and then I decide not to. But I want to ask only when you have finished on this point. So I give you a chance to exhaust what you have on this point.
I just want to then raise two other things. You talk about paragraph 282.
Yes.
Could I just ask you to have a look at 4 lines from the bottom of 282? At the meeting, Mr. Gupta raised his complaints. Mr. Gupta was usually blunt and forward in the manner of expression.
Yes.
This did not sit well with Mr. Damas.
Yes.
He understandably found it rude and insulting.
Yes.
And then at 283, during this conversation, Mr. Gupta also complained that Eskom discriminated against the TNA and favoured established newspapers. Although the meeting was tense, the tension eased as the meeting progressed. See that?
Yes, I see it.
Do you have any comment on that?
I was not in the meeting, Chairperson, so I don't know whether it is or did not.
Well, let's go back to the point that Mr. Mybeck was asking you about and the one that you have explained comprehensively. I do have difficulty with the notion that there was a need for Mr. Mahlangu to attend these meetings between Tony Gupta and SOE CEOs and so on. We talk about Kona, talking about Mr. Dames and so on, in order to hear what was being said and report back to you. So, because I asked the question, these were operational matters. I say, Tony Gupta wanted to see the CEOs, as Mr. Mybeck says, not you, not your advisor. Why didn't your advisor simply say, one, Mr. Tony Gupta, you are entitled to approach the CEO and CEO's office and make direct arrangements. And if he agrees, the two of you will meet. I have nothing to do there with that. If subsequent to that meeting, you need to see the minister can say, see me, and I hear what you have to say. But that meeting where you want to see the CEO of a particular SOE, it's between the two of you. The minister doesn't have to hear anything about it unless one of you has a reason to want to talk to him arising out of those issues. Well, why was that not the correct approach?
Chairperson, Mr. Mahlangu could have opted for that approach, but he and there are 2 instances we're talking about here. Maybe there could be 3. I'm not sure. It involved Mr. Kona, it involved Mr. Dames, and I can't recall, because there were 8 SOEs in the portfolio. I can't recall if there were other CEOs who also had a similar experience. But
yeah, there might not have been. It's important to say, at least my recollection is those 2.
Exactly,
But
out
of
of
course,
8.
as you said, he did facilitate other meetings that might not have involved Tony Gupta, but involved other business people and so on. And my understanding of what you were saying is it's along the same lines, you know.
Yes.
So the principle was the same, his involvement. But you can deal with it.
Thank you. It's important also, Chairperson, to put on record that insofar as the SOEs are concerned, I think it's 2. It's these 2 CEOs out of 8. Now, and I say, as I repeat, Chairperson, we could, with the benefit of hindsight, say he shouldn't have been there. I don't know the extent to which it was happening in other areas. I don't know the extent to which it is still happening even at the present moment. And so it also would be important to establish the extent to which it is still happening, the extent to which it happened in the past, and even prior to 2010, because there would have been instances when it happened. Business people come to, or would come to where the ANC NEC was having meetings, request to meet with ministers. Sometimes the DGs would also be present, even prior to me being a minister. There were instances when I made example, I think if not on Friday, then it must have been on Thursday, when one business person decided to write to the public protector protesting that Minister Dlamini Zuma did not want to meet with them to discuss an operational matter at Home Affairs. I don't recall how that issue was resolved, but it was based on their experience or expectation that they would be thus assisted with the facilitation of the meetings and discussions. The principle was always that no decision will be taken out of such engagements which would contravene the supply chain management, the public procurement process, and other existing legislation insofar as these issues are concerned. I think there was an instance when I was at Home Affairs when I tried to facilitate a discussion between the Department of Home Affairs and the department insofar as the fire blade private terminal was concerned. And my view was, here is a proposal which has been placed before us. Let the department now talk with the people involved. And that's why at the end of that meeting, the decision was that the Director General must conduct due diligence, finalize the specs for this, and engage further with this company insofar as the supply chain management process is concerned. We did not take the decision at the meeting itself because I understood that I, as a minister, had no jurisdiction over tenders, contracts, and the supply chain management process in government. And that is why you say, then DG, you go ahead and do this and ensure that the process is followed to the letter, consult with other relevant departments. Now, it would then be necessary, Chairperson, again, to make a proposal in this instance that is going to be all-encompassing so that there is better understanding of how such issues should be dealt with, because insofar as I could recall, they were being dealt with from the perspective of each department as it went along without there existing an all-encompassing comprehensive framework for how do you engage with business people who have complaints, and there are many who have issues that they wish to raise, who have queries they want to raise, and they use whatever opportunity they get for them to be able to raise those issues. And insofar as you, as the minister, are concerned, or insofar as I, as the minister, were concerned, I did not want to be involved in taking the decision there. I would say, you go talk about this, whatever decision you arrive at, that then is the matter between the two of you.
What you say to the proposition that, in effect, you were, as minister, attending those meetings through your special advisor, In
No,
other
as-
words, you were not physically there, but he was representing you there. What do you say to that proposition?
As I have said, Chairperson, I was not there. And Mr. Mahlangu understood that he is undertaking these engagements in order to remove me from presence. And the understanding with the CEOs, and that's why I raised this even in one of the meetings between the chairs and the CEOs of the SOEs in our portfolio, that should anybody come to you, and I made example of the fact that people come to me and say to me, man, the president has said I must come and say this to you. And I would say to them, well, the president is my employer. If the president wants to give me an instruction, he would call me, not you. He would not tell you to come and give me instructions. I was not appointed by you. And in some instances, I would call their bluff and say, let me call the president and find out. And they would immediately recoil. That no, he didn't say do this. He said, I must come and talk to you. I made that example to them and said, in the instance that somebody comes to you, either together with my advisors or comes alone and says, I had said they must come and talk to you, please bear in mind that I did not give an instruction as to how this issue should be resolved. You have a responsibility to follow the processes and procedures existing in your organization and as provided in the Public Procurement Policy Framework Act, as well as the Public Finance Management Act. Because in the end, you are the accounting officer. You will have to account for this decision. And how you account for it, you can't say that the minister made me do it. I did not make you do it. But understand the environment in which we operate or operated. And the SOE environment is very difficult in that regard, in that there are many people with interests, global organizations, global companies and domestic companies, business people, individual and collectives who seek these types of platforms. And you need to establish a very clear framework as to what decisions can be taken and what it means when somebody comes to a CEO saying that I have spoken to the minister and they referred me to you. So, Chairperson, in my opinion, that would be an interpretation, but it would be a wrong interpretation in the sense that I had spoken to the CEOs, and that is why none of them says, I therefore did this as a result of presuming that the minister was in support of this.
But you see, Mr. Mahlangu makes it clear in one of his affidavits, and I don't know if it is this one, that whatever interactions he had with Mr. Tony Gupta, they were in his capacity as your legal advisor or special advisor. I think he says somewhere he was not acting in his personal capacity when he interacted with them. They were not his personal friends. Now, that, and then of course, I think one deduces from that, if Mr. Mahlangu doesn't say so expressly, that when he was attending these meetings, whether it's with Tony Gupta and Mr. Kona or Tony Gupta and Dames, he was not there in his personal capacity. He was there because he was your advisor. And obviously everybody who was in those two meetings knew that he was your special advisor. And obviously it would be reasonable for them to think that, I'm now talking about the CEOs, to think that he would report back to you. Would you quibble with that?
Chairperson, Mr. Mahlangu would not have been given this responsibility by me to insulate me from these engagements had he not been my special advisor. So I gave him this responsibility. understanding the role that he had to play in my office, and gave him a further instruction as to how he should conduct himself. And that's why in his affidavit previously, he says at all times he conducted himself professionally. So that's the first principle to establish here. Secondly, the leaders of our SOEs understood, not only in regard to Mr. Rajesh Gupta, but in regard to every other person who came to them, that this was the manner, the approach they needed to take on those issues. Because in the end, even as Mr. Mahlangu would have organized those two meetings, or others with other organizations or individuals, the manner in which these issues would be resolved would have to take into consideration, because I made it very clear, Chairperson, no ambiguities about this. Because as I say, when I spoke about this, I spoke about it at length. I even made reference to how people approach me. And I made it clear to them that please follow the supply chain management process, because there is legislation existing. That is why the issue of Fireblade actually surprised me, to claim that I had approved through verbal agreement that Fireblade should operate. It surprised me, because that's not how I understand the Public Finance Management Act and the supply chain management processes arising thereof. In the end, whatever decision has to be taken which has financial implications is not taken by the minister or by influence of the minister. The minister is not an accounting officer, neither in the department over which they are minister, nor in SOEs over which they are shareholder representatives. The accounting officer has to take a decision which has fulfilled all legislative requirements in terms of supply chain that would have had to be approved by the board.
Mr. Mybeck.
Thank you. Could I take you to another affidavit, please? Could you go to bundle 11? And if you could turn
Just a moment. You've gone to bundle 11. I'm still on 7A.
And could you turn bundle 11? There's a flag 15.
15.
And then perhaps I could ask you to turn to page 942.1.
9.
Sort of midway into that divider.
942.1. Okay. Yes, indeed.
Now, this is the affidavit of the Managing Director of Fundutsi, Mr.
Yes.
Ernest Nekovambe.
Yes.
You see that?
Yes.
And we know that Fundutsi were appointed by National Treasury to conduct certain investigations and produced a series of reports that are featured in this inquiry. There's just a few things I'd like to ask you in relation to this affidavit. Could you please turn to page 924.13?
Wait. 924 or 942?
942.13.
I'm there.
Right at the foot of the page, at paragraph 78, Mkolo stated that Minister Gigabe introduced an informal way of board appointments, and further that there was no framework or policy in place. Now, who is Makolo?
Ms. Mkholo was an acting DDG, was a DDG Legal and Governance in the Department of Public Enterprises when I was there, appointed during my tenure.
And that we see from the top of the page, correct?
Yes.
There's a schedule setting out at paragraph 72 the various individuals who served during your tenure, and it then reflects her as an acting DG. What do you say to her, or to this paragraph, that she stated that you introduced an informal way of board appointments, and further that there was no framework or policy in place?
Chairperson, ministers don't often arrive in departments and change existing policies. There was a policy of how boards were appointed when I arrived, and that policy in large measure prevailed. When I became minister, I'm not sure whether paragraph 78 is related to paragraph 75, in which paragraph 75 it is said that Minister Kigaba did not approve the memorandum, and his rejection was supported by the following statement: such a presentation should be prepared and a date set. Now, this was in relation to my arrival in 2010, and a memorandum was brought to my attention. And this was during a time when I was receiving briefings. And my view was, a matter of this magnitude requires me to be briefed verbally. You present the memo, you brief me, you allow me to engage with it. Because if I want to ask questions, who do I ask if I am sitting with a pile of papers in front of me? If I want to understand, why are you suggesting this? Why is this a framework a proposal there? I need to ask the people who are drafting this so that they enlighten me, because I am new in the department. And in actual fact, I was new in the environment of public enterprises. I had served for 6 years as Deputy Minister of Home Affairs. At Home Affairs, we did not appoint boards for companies of the schedules of the SOEs. And even where there was maybe the immigration board appointed, that was the responsibility of the minister. I only had to note the submission. And that is why I propose that prepare such a presentation and set a date for it to happen. And that happened. We had a discussion. I refute the claim that there was an informal way of board appointments and there was no framework. In my firm understanding, when I arrived, there were certain boards in which some board members would have served for 9 years or more. That includes the board of Eskom, that includes the board of, can't remember which other board, but there were instances where board members would have served for periods of 7, 8, 9 years or even more. And the decision taken officially during my tenure was that no member of a board would serve at most for longer than 2 terms of 3 years each. So we regularized that each board member would serve for 3 terms. At most, you would receive a
2 terms of 3 years each.
Yes, which means it's 6 years in total.
You said 3 terms.
Oh, sorry. I meant 2 terms of 3 years each. Yeah, or 3 years per term, which would be a total of 6 years. With the provision that in the instance that you are not performing in terms of the board assessment. So we also regularized board assessments on an annual basis. So as we went to the AGM, there would be a board assessment. It was regularized. And that board assessment would indicate to us whether somebody has taken over more board positions, because one of the things we did was to insist that you must not serve, I can't remember on more than how many boards? I don't know whether, I can't remember whether it was on more than 3 or 4 boards, so that you are able to give your time to the SOEs, because they were important drivers of our infrastructure rollout. They need board members who've got time, who are not just embellishing their CVs, but who are very involved in the work of our SOEs. So we introduced a number of frameworks that and policies that ensured that the process was formalized. So it's not true that I introduced an informal way of board appointments. Actually, what is an informal way of board appointments? I don't understand what that concept means, an informal way of board appointments. But the board appointments process was very formalized. It involved the department. It originated from the department. It involved engagement at their level, including checking the CVs, collecting the CVs, checking the suitability of those people, their eligibility to serve on the boards, until it served before me. And I think I explained earlier today how these then would be dealt with. If by informal they mean that I would have said, in instances, instead of just giving me a memo, come present this to me. Let me understand your rationale. Let me understand what you are suggesting here. Because even in how you prepare for AGMs, I insisted on attending all AGMs of the SOEs, including the ones I had delegated to my deputy. I insisted that I want to attend them, because in the end, my deputy becomes my proxy, because as the minister and the executive authority of the department, I am the shareholder representative. I'm the one who reports to cabinet. Now, I insisted that I would attend them, even if on occasion I would not make the shareholder statement, but would leave my deputy to make it. But I would be there and ensure that the decisions taken have the full approval of the shareholder representative, and would insist that instead of saying to me, we're going to an AGM, we meet at the AGM, you just give me a board pack, let the department come and present to me so that I understand what decisions need to be taken, and we deal with board appointments and other issues, the confirmation of auditors or rotation thereof, in those discussions. I thought I was engaging as the minister with the top officials in taking these decisions, unaware that somebody might have viewed it as an informal way. But they should have said to me that, Minister, that this becomes viewed by us as an informal way of doing the work, of deciding on boards. But in the end, they came, we sat, we discussed with them, we agreed, there was consensus. Nobody would feel that I've been left out in terms of my views, and then that's how we proceeded.
Mr. Maivek, I just want to ask a point that's not directly in line with what you are questioning Mr. Gaba about, but it arises partly from what you have said. You just said that you would have wanted the department to make presentations to you as the shareholder representative, so that you could report back to cabinet. What was the way of reporting to cabinet and the president about the state of SOEs during your term? In other words, would there be written reports that you as the minister, or regular written reports that you would have placed before cabinet or the president to say, this is the state of Eskom, this is the state of SAA, this is the state of Transnet, so that over the 5 years of your term, you are able to say, I kept the president informed or the cabinet informed of what the state of these SOEs were. So I'm interested in that because one of the questions that arises for me in different contexts is how it was possible that a number of these SOEs that we are dealing with here, Eskom, SAA, Transnet, DENER, how it is possible that they could go down the way they seem to have gone down, and with a lot of corruption happening, affecting their finances, without something that seems effective being done to arrest the decline. So, and I wonder whether it would just be a matter of the relevant minister, or whether the relevant minister would be keeping the cabinet aware and the president aware, and they would have had opportunities to see that things are getting worse in the various SOEs, corruption is rising, irregularities are rising, and they would have had an opportunity to assist or intervene or grapple with the problem. So what was the way? Would there have been some written reports, or were they just verbal reports? What was the way of communicating to cabinet and or president the state of challenges in the various SOEs?
Chairperson, there are no reports that you submit on a monthly or annual basis to cabinet on the state of SOEs. When matters of SOEs serve before cabinet, it's usually with regard to either appointment of boards or applications for government guarantees or recapitalization, when the National Treasury, together with the relevant ministry representing the shareholder, would then come to cabinet on those issues. So if it's a matter that involves SANRAL and the GFIP, the Gauteng e-tolls, it would be the Department of Transport and the National Treasury. If it involved overall guarantees that would arise from the Minister of Finance's budget process as they brief cabinet on the fiscal framework. Now, so there are no reports that go to cabinet that say, even after AGMs, at the AGM, the relevant minister would receive the report on the annual financial statements, in which report you then deal with the finance report, the audited statements, which would raise irregular spending. It would raise the issues about the salaries and long-term and short-term incentives, what profits have been made, and so on. Even those don't serve before cabinet, except when we would have gone to cabinet to request cabinet to consider taking a decision on the salary scales of SOE CEOs and CFOs, the board members, as well as the long-term and short-term incentive issues, which were quite damaging on the finances of the SOEs. So, what then? How then that gets dealt with subsequently is after the report of the Presidential Review Committee, which was chaired by Ms. Pierre, and when she became Commissioner of Police by Mr. Mashinini. In that PRC, Presidential Review Committee, it 715, or that report identifies 715 SOEs. The Minister of Public Enterprises has oversight over only 8. There are 715 SOEs in the country, existing at national, provincial, and local levels. And some of the public entities, even though they are of the form of SOEs, have not declared themselves or been declared as SOEs. Creates a dilemma in that there is no institution in the country, single institution, which has oversight over all these SOEs. And therefore, Cabinet doesn't have a full view of its SOEs, how they are performing, what's their asset value, what are their liabilities overall, how much are they spending in terms of capital investments, and what are their operational expenditures, what is the figure of their operational expenditure. It doesn't have a view, an overall view of what is happening in that regard. What the PRC report then suggests is that government must establish an SOEs council, which would be a council of ministers, because the Minister of Public Enterprises, who is the custodian, and is viewed in the country as the custodian of our public enterprises, only has oversight over 8. The Minister of Transport has 11 plus SOEs in their portfolio. Then there are others in energy and so on. And some of these enterprises are of a commercial nature, others are non-commercial, others serve a public value, like PRASA, even though it's commercial, but it has more of a public value in that its clientele are ordinary South Africans who live in townships and rural areas, who use the public railway system, and therefore regularly government will have to subsidize these SOEs. So that is the dilemma. Now, there is no report, therefore, Chairperson, which I would have submitted, other than anecdotal issues which relate to board appointments, guarantee framework application, and something else which we might be reporting about, the appointments of CEs and other executive directors in the SOEs. And those reports will not assist you very much. Though, when you look at all of them, they will give a sense of the board appointments over the period from 1994, but it will not explain to you, Chair, that when 1994 happened, most of our SOEs had been told that they would be privatized, including Transnet. And therefore, for a long period, Transnet did not invest in new rail capacity and locomotive capacity, because they were told they would be privatized, and therefore their finances began to dwindle. If you look at Eskom, the same would apply to them. From the outset, they knew that they would be either privatized or a private competitor would be introduced. Eskom did not invest in new electricity generation capacity. As a result, when 2008 happened, we found ourselves experiencing load shedding, and began at that period to commission new power stations, the contracts of which were entered into in a rush, because the country was already experiencing load shedding, and because of that, those contracts were weak. They favored the global original equipment manufacturers, and with the delays in the completion of construction, those delays have resulted in cost overruns running up to billions of rand because of the delays and the type of contracts that were entered into, and the failure to appoint project managers on site that would manage both the contractors, the primary contractors, the secondary contractors, and labor. That's why at Medupi, you had these several, I think 2 or 3 prolonged strikes, because there was no one on site on behalf of Eskom and the contractors who was managing the relations between the contractors and labor. So those are difficulties which have been there, which hopefully the appointment of the SOE's council is going to help to resolve, because it has a mandate. The minister unfortunately looks at operational issues insofar as SOEs. Their oversight, in as much as it is strategic and is expected to be strategic, is also operational, narrow. The SOE's council has that much more broader oversight, which would be able to look at a whole range of policies, because the Department of Public Enterprises has its own governance framework, which it has established. But other departments, provincial tiers and municipalities, which also have SOEs, have different governance frameworks. Even we have different governance frameworks. In addition to which, there's a litany of legislation impacting on SOEs. The Companies Act, the PFMA, King Code of Governance, and a wide range of others. Some SOEs have got establishment legislation, other SOEs don't. They just simply exist, and their governance is dependent on the framework which would have been crafted by the shareholder department. So all of those issues, Chairperson, impact on the SOE environment and how it operates, and they create, therefore, the loopholes that you see in many of our SOEs. If you look at what they are expected to do and what, in the end, they are able to deliver.
Okay, no, thank you. That's very important. I mean, part of what we are looking at is how strong or weak were oversight mechanisms for SOEs, because the weaker the oversight mechanisms and structures over the SOEs, the easier it seems it would have been for people who wanted to loot the SOEs to do so without relevant structures picking this up. And then maybe that's why we are where we are with the SOEs. So part of what the Commission is looking at is how strong were the oversight mechanisms? Why were these things not picked up on time? And that's where the question arises from. Okay, but what you have said is helpful. Mr. Maybeck.
Thank you. If I could take you please to page 942.14, paragraph 79. Maholo further stated that the informal way introduced by Minister Gigaba resulted in almost all names in respect of board appointments originating from the minister's office. You want to comment on that?
I was not aware of this, Chairperson, and to my understanding, as I've stated it, the names, the candidates for boards emanated from the department. There would be a few instances where I think it would refer to their names, which I spoke about, Ms. Chichima Ponya, Professor Zanele Mngadi, and a few others, where I would have said to the department, look at these as well. But even those had been brought to my attention by my advisors. They would not have emanated from me directly. And so to the extent that I think here, what Ms. Moholo is talking about is the engagement which was there between my office as well as the department in how the names originated.
Well, she's actually talking about Mr. Mhlangu. If you could go to paragraph 83. The said board members' motivations for appointment, now not just the names, but motivations for appointment to the SOC boards were sent by Mhlangu to Minister Gigaba, Matona, and Makolo. At 84, Makolo indicated that it was not Mhlangu's role to send motivations for board appointments to Minister Gigaba. Want to comment on that?
And 85, we could not find any indication that Minister Gigaba requested Mahlangu to provide candidates and or motivations
Yes.
for board appointments. I think 85 is important too, Chairperson.
Sorry, Mr.
But-
Gigabe, can I just ask you to direct yourself firstly to the issue of Mr. Mtlangu?
Yes, I think, Chairperson, it would have been important to engage him on these assertions so that his understanding is established. Because to my understanding, he would have not had a responsibility to develop the full names for boards. That responsibility would have had to lie with the department. And up until now, this is what I thought happened.
All right. So if we could have a look at one or two other aspects of this affidavit. Could I ask you please to turn to page 942.24. If I could direct your attention, and this is a section dealing with the appointment of the SAA board in 2012. I could direct your attention, please, to paragraph 134. On 30 August 2012, Palesa Nkomo, now who was she?
She was a special advisor for economic issues, on economic issues, yes.
Also in your office,
Yes.
sent an email to Minister Gigabe and copied Mtlangu. In her email, Nkomo raised her concerns in the manner in which the proposed SA board was compiled. And it says, Nkomo stated, "Dear Minister, I'd like to confirm that the finalization of this list was not consultative. Here are my comments to SIA 2 days ago, and he had ignored them. He has changed the list every day and did not include people with expertise. In the final list, he has refused to include the following people who have the expertise and will add value to the MRO consolidation at a later stage." And then she lists certain people. At 1:35, it's recorded in her email to Minister Gigabe, Nkomo indicated that Mtlangu had missed all the deliberations on SAA diagnostic report. Nkomo further indicated that she did not agree with Madizela should seat on the SAA board, as it would be interpreted as double dipping by cabinet. Then at 1:36, based on Nkomo's reaction to the proposed list, there may have been a lack of transparency in the manner in which the SAA board members were nominated and finally approved. This is Mtlangu's list. 137, this is evident from the concerns raised by Nkomo to Minister Gigabe regarding the lack of consultations by Mtlangu when compiling the list for SAA board. At 138, in his response to our written questions, Minister Gigabe indicated that he does not know why Nkomo raised objections that there was no consultative process. 139, Mr. Gigabe further stated that he didn't recall the above instance, given that he did not want to micromanage the appointment of board members, as it could have created an impression that he had an interest. And at 140, Minister Gigabe further stated that as far as he was aware, there were sufficient internal processes within the department to consult, and when there were concerns regarding consultation, he would refer the issue back to the process. Do you have any comment further on that?
No, there is no further comment, Chairperson, on this. I think what I stated here, that I wasn't aware, one, I didn't want to micromanage the process, and two, I wasn't aware there was no sufficient internal consultation process, because my understanding, Chairperson, was that at all times, the names emanated from the department. I would have been happy if the DG had come to me to say that, Minister, actually these names have not emanated from from the department. Then I would have intervened at the time.
So you accept that this list on the face of it didn't emanate from the department, it emanated from Mr. Mtlangu.
I don't accept it, Chairperson, because I wasn't aware of it. This is one view on the matter. There could be other views on the same matter. So it's an assertion that I can't just willy-nilly accept. You know,
You can neither accept or dispute, is that right?
No, I can, yes, I can neither accept nor dispute,
Yeah,
yes.
you don't know
That's
about it.
yes.
All right, well then let's look at what it says towards the foot of page 942.25, the appointment of Mr. Ntani, something we've already looked at. I can just run through this quickly. If you go to 942.26, on 11 September 2012, Mtlangu sent an email to Mr. Gigaba titled Motivation for Ntani. In his email, Mtlangu wrote, and then the email is quoted. If you go to 144, on 12 September 2012, Mtlangu sent an email to Mr. Gigaba titled Further Thoughts. And if you have a look at 146, the second sentence attached to Mtlangu's email was a document titled Dr.Docs. The said attached document was a one-page summary of Ntani's work experience. And then you see at 147, the document further indicated the following in respect of Ntani, his passion for building businesses, etc. And then if you go to 149, during our review of the attached document, we noted that the document was created on 12 September and last modified by Ashu. Possibility exists that Ashu is Ashu Shwala. I've already asked you about this. Do you have anything to say about that?
Well, I wasn't aware again of where this, because Chairperson, as I say, I left these processes to be run by the department. I did not want to keep interfering at every moment of the board appointment process, because, as I say, I didn't want the department to presume me to be having an interest in the issues. So even if my advisors came to me to say, these are people we recommend, I would say, take those names into the department's process and let them be dealt with in that process before you bring them to me.
So he's not just putting forward a name, he's actually writing or presenting you with a motivation for appointment.
Even in that case, Chairperson, it's immaterial whether he provides motivation, because even if you were to say to me, appoint Mr. Maibek as a board member, whether you provide motivation or not, I would say take this issue to the department, let it be dealt with there. The name of Mr. Maibek, if it passes muster in the departmental process, then it would return back to me through the normal routes that are established.
And then you'll see at 151 that on the 12th of September at 8:33, Mtlangu sent a second email to Minister Gigaba titled Revised Motivation. And then at 1:53, the second document was last modified by Ashu on 12 September. You see that?
Yes, I see that.
And then at 1:54, it records a response by Mr. Mtlangu to the effect that he didn't have any knowledge that Mr. Shwala was involved. But I just wanted to pick up on something that you mentioned earlier, and that is that some of the questions that we have should be directed to Mr. Mtlangu. I just wanted to point out to you, and he says this on a number of occasions, you see it in this affidavit. 155, Mtlangu further indicated that he was unable to respond to our questions on specific board appointments. He stated that, quote, in my view, these board appointments or rotations are confidential and legally privileged. The same applies to the legal advice or notes that I prepared for the then minister during my time as his special advisor.
So that will be in what bundle? So that I can direct my attention to it as well while you are presenting us.
942.28.
Oh.
As the same
paragraph
matter.
155.
Right.
This is not an attorney-client privilege. This is Mr. Mtlangu being asked questions about appointments and his interaction with you, and saying that they're confidential and legally privileged. It's part of his job.
I presume that to be his response.
Yes.
Yes.
Mr. Maipek, I wonder whether Mr. Solomon can still hear us. I see there is some signal challenges there. Mr. Solomon, can you hear us? Is not answering. Are the technicians working on it? Okay. Okay. I don't know whether he would have an objection if we continue to whether we should stop.
Could I request a comfort break though, Chairperson?
Oh.
Thank you.
Chairperson, the
5 minutes.
technical staff asked if they could have 5 minutes to restore the connection, if possible.
That coincides with the request. Can I also request somebody to switch on the heater here? Okay, let's make it 10 minutes because 5 minutes can be quite short.
Thank
We'll
you.
take a 10 minutes break. We adjourn.
Hello, Mr. Solomon.
Yeah, I'm here.
Okay, we apologize for that. It was a network-related error, but we're back now.
Okay, thank you.
All right, thank you.
Okay, let's continue.
Thank you. Mr. Gigabe, if I could ask you to have a look at page 942.29
I'm on it.
and go to paragraph 163. It
Yes.
records there's no evidence that probity checks as provided for in the 2008 handbook or the subsequent DPE board appointment framework were conducted on Tani in 2012 when he was appointed to the SAA board. You want to comment on that?
Chairperson, I presumed that this had been done.
And in fact, perhaps we could turn back.
Would the decision memorandum, as I understand this document to have been called, not deal with such things? In other words, to say, with regard to this candidate for appointment, we have checked his or her academic qualifications or her claims about business experience or his or her claims about connections with India or whatever. Would it not deal with those things to make sure that you are aware what background checks had been done? Or would it simply say background checks have been done without telling you exactly what has been done?
Chairperson, it would not. It would not go into that detail of explaining that the probity check had been done. To the extent that it served before me, I would have presumed that it had been done in the back process.
Mr. Myback.
Yes, thank you. And just incidentally, if you go back to page 942.20, we know that Mr. Essa was appointed to the board of Broadband Infraco. It says at 119, in his response to our questions, Mr. Gigabe indicated that Mr. Essa's appointment on the Broadband Infraco board was done in accordance with the processes of the department. But again, it's recorded that the finding of Ndutsi was there is no evidence that a thorough vetting process was conducted on ESSA in 2011. Any comment on that?
No comment, Chairperson. I presumed again that this would have been done. I think the Funduzi report was completed in 2018 or 2019. In 2011, when 2011 or 2012, when the appointment was done, insofar as I'm concerned, because the board appointments did not originate from me, I would therefore have presumed that all the people being recommended had been checked.
And then if I can ask you please to go back to 942.29.
Yes.
At 167, towards the foot of the page, we recommended in our final report that DPE should consider investigating whether Mtani was strategically placed at SAA to ensure that SAA closes down the Mumbai or Johannesburg route to make way for Gupta-linked airlines. 168. In his response to our written questions, Minister Gigabe indicated that he was not aware of any influence which Ashu Shwala, Gupta family, and their associates / Salim Essa may have had on the appointment of board members at the various SAE boards. Do you have any comment on those two paragraphs?
If you go to paragraph 167, Chairperson.
167.
Yes, paragraph
Yep.
167, yes. I wouldn't be sure of this. Perhaps it might have been in the minds of the people who might have nominated him, but my understanding is that the decisions with regard to closing the Johannesburg-Mumbai route had started prior to 2010. And it had gone through various executive directors at SAA and through various boards of SAA. With around 2010, the new CEO of SAA making it very clear that SAA had no intention to pull off the Mumbai route. Between 2010 and 2014, there was no instruction to SAA to pull off the Mumbai route because that was the discussion of the airline, which would have moved from the airline, from the MANCO management committee to the board, from the board to the minister. At the time, the decision on shutting down routes or pulling off routes which were not financially viable would be taken by the executives, recommended to the board, and then sent to the minister for final approval. The 2012 turnaround, long-term turnaround strategy then came to the conclusion that that process was protracted and not very helpful to the airline in terms of taking decisions on routes. And therefore, the recommendation of the long-term turnaround strategy was that the decision on routes would have to be taken by the board instead, because if it comes to the minister, it delays the decision, the airline continues bleeding on the routes, and the minister doesn't have the capacity, or the department doesn't have the capacity to evaluate the viability or not thereof of a particular route. This had to do with a number of other routes. But insofar as the Mumbai route is concerned, I had said earlier that in 2010, the new CEO of SAA said they would not pull off the route. In 2011, it seems that the MANCO subsequently decided to pull off the route, but the board said no, don't pull off the route. Rather, let's explore partnerships and cooperation which would optimize the route for the airline's clients who would have been traveling from Asia to South America, Sao Paulo in particular. So I'm not sure, and I think it would be necessary to test the veracity of this claim that Mr. Nethani was appointed to ensure that the route is shut down. Of course, the board of SAA in 2015, if I'm not mistaken, decided to pull off the route. I was Minister of Home Affairs by then, and I was no longer involved with SAA, but I think it would be necessary that the veracity of this assertion be tested with board members that were there at the time as to why they pulled off the route. My understanding is that SAA continued bleeding on the route. Its finances, not only in relation to this route, but in relation to its operations and as a going concern, were quite weak. And I think there was a period of more than a year, of about 2 years, if I'm not mistaken, when SAA was not able to go to an AGM because the auditors had raised serious concerns with regard to the going concern status of SAA. And so a number of routes would have been affected in that instance, not only the Mumbai route, but other routes in Europe and elsewhere. It seemed that a number of long-haul routes of SAA were affected. So to what extent this assertion by Funduzi is true or not, I really cannot tell. All I'm saying is there is a broader context that needs to be looked at, and it would be necessary to then engage the board members who were there at SAA in 2015 when the decision was taken to understand the rationale and the ManCo that was there at the time, so that they can explain why they took this decision.
And then, Mr. Gigaba, could I ask you please to go to page 942.143.
143.
So, Fundutsi asked you a series of questions in the process of preparing their report. Do you recall that?
Yes,
And you responded by way of your attorneys, then Chabalala attorneys.
yes.
And that response commences at 942.143. I just wanted to ask your comment on one thing which I identified. If you go to page 942.154,
Yes,
you were asked, if you go to the bottom of the page, to paragraph 4.11, under the heading Relationship with the Guptas, you were asked, do you have any relationship with the Guptas? And your answer was no.
yes.
Is that correct?
Well, I think I did explain earlier. Perhaps the question was a little bit ambiguous, because previously I had explained my relationship with the Guptas in Parliament. I explained them here, that it was just a social relationship. So when I said no here, I probably meant that there is no relationship beyond social and just cultural, as I had explained.
So what you could perhaps have said is that your relationship was social and cultural.
I could have said that, yes.
So as I understand it, just to end off on that issue, you considered yourself to be a friend of A.J. Gupta.
Yes.
And in fact, you must correct me if I'm wrong, one of the reasons that you felt comfortable with Mr. Mklangu intervening as between you and the Guptas is because it then avoided the need for you to deal with A.J. Gupta. Is that correct?
Let me rephrase the answer to your question, because it's leading in a particular direction. Chairperson, not that I felt comfortable in Mr. Mahlangu. I instructed him to manage the relationship so that I did not have to find myself extending beyond my social relationship with Mr. Ajay in the instance, because they are business people. I knew them to be business people. And I didn't want, for instances to arise which would cross the lines and extend the social relationship into what now would appear to be a business engagement. I didn't want that to happen.
So I think the point is that your friendship was close enough so that you didn't want that.
Yes.
And as I understand your evidence too, you surmised that perhaps he saw it the same way, and that was the reason, I think you surmised, why Mr. Mklangu would then have dealt with Rajesh Gupta and not A.J. Gupta. Do I recall your evidence correctly?
Yes, probably, yes.
And which of the other Gupta brothers did you know?
I knew all of them. Well, there are three. I knew all three of them, and I would have met them on several occasions, including when I was there for the cultural activities, when we met at TNA SABC breakfast programs, at some of the programs of the ANC, and even at I think they hosted once or twice South Africa of the Year award, and I would have met them there also, because I was a guest, among others.
And, I mean, are you able to put your finger on what caused you to foster a friendship with A.J. Gupta, but not with the other brothers?
I don't know. I mean, it just, There is no particular reason. He's just the person that I used to talk to. Probably him, I think, as an elder brother to the two. He's the one that I just used to talk to. There was no specific reason that I like this one, therefore I will foster a relationship with him.
And then Mr. Ashu Shwala, did you meet and know him?
Mr. Ashu Shawla, I would have seen him on several occasions, but just he would greet and go. So I did not have any discussions with him.
And would you see him, for example, on those occasions when you went to Sahara Computers?
I don't actually recall whether I had seen him there. I don't recall if I had seen him there. He's not somebody that I saw that much. I mean, there's quite a lot of people I've met over the years, but I do recall that I have seen him.
And then, as I remember your evidence, and please correct me if I'm wrong, in relation to Mr. Salim Essa, your evidence, as I recall, was that the first time that you met him was when you were introduced to the Broadband Infraco board. Is that
Yes,
correct?
I think so.
And did you then have occasion to meet him after that?
Except when we were at Broadband Infraco, I don't recall other occasions.
All right.
Well, let's go back to that question and your answer at page 942.154, where you were asked, do you have any relationship with the Guptas? And you said no. I can't remember how you described that question, but I think you described it in a way that suggests that it may have been vague or something, but it seems to me to be quite straightforward. Do you have any relationship with the Guptas? Is that not a very straightforward question?
It could be, it's a matter of interpretation, Chair. It's a matter of interpretation. I think perhaps I could have expanded as I've expanded during the sessions of this commission.
You see, because when they say, do you have any relationship with the Guptas, they are not saying business or personal or anything. They just want you to indicate whether you have any relationship with, you had any relationship with them of whatever nature. You accept that. That's what the question requires.
It's a matter of interpretation, Chair. I'm sure if they were also specific, I would maybe have responded specifically because they left the question vague.
But look at it now. Leave out for now how you might have interpreted it at the time you answered the question. Look at it now. Do you not accept that it is straightforward?
No, Chair.
Why do you say it is not straightforward?
It's not. A relationship could be anything, from business to,
Yes.
to
Yes,
anything.
yes.
And my sense was that's what they were asking.
Yeah.
And that's why I have explained before the commission my social and other relationship with them. But I made it very clear from the outset that there was no business or commercial relationship.
Yeah, you see, my difficulty is interpreting any relationship to be a reference to a business relationship when the question is quite open. That is my difficulty with your interpretation.
The family chairperson is known as a business family. In Parliament, I had explained my relationship with them in the same way that I've explained it here at the commission. My reading of this question was that it was vague. It had asked a number of issues which had to do with SOEs, the business dealings of the family, and that's probably why I responded in this emphatic manner. But the intention was not to hide anything, because if that was the intention, then I would have still gone ahead even at this commission and not disclosed.
Yes, but you see, if you turn over to page 942.155, the top question there, that question says, if the answer to the above is yes, and we know your answer was no, if the answer to the above is yes, what was or is the nature of the relationship with the Guptas or the associates? So I want to suggest to you that if you thought that any relationship, the reference to any relationship in the question at page 942.154 was directed at a business relationship, when you came to this question, you would have realized that, oh, depending on my answer in the previous question, they want to know the nature of the relationship, which is business or friendship or whatever, and that you would then have realized and gone back and said, yes, I did have a relationship. It was a friendship and not a business relationship. But the answer that you gave to the question at 942.155 was, the question has become academic and falls away in view of the answer given in paragraph 4.10.1 supra. What do you say about that?
No, I take the point the chairperson is making.
Yes.
Yes, that I should have read this and therefore clarified that my reading of the previous paragraph of the previous question was not what was meant, and therefore I should have gone on to explain here as this other question is now asking, or was asking.
Mr. Mayberg?
Yes, I just wanted to make one point. Of course, when I asked you in these proceedings early on about your relationship with the Guptas, you took us back all the way to when you were the president of the ANC Youth League, correct? That's when you started sketching it.
Yes.
All right. Could I ask you please to turn to another file? And that is to Transnet Bundle 8. And could you please go to page...
I'm sorry, Mr. Mayberg. And Mr. Kikab, I don't want to interrupt you, but there is something in my mind, and in all fairness, I think I should put it to you so that you can clarify it. I may be wrong, but I think that the impression I had got from maybe some of your affidavits that you have delivered to the Commission, as well as maybe your earlier evidence, I think it had given me the impression, rightly or wrongly, that your position was that you were not close to the Guptas. But I do know now that I think either on Thursday or Friday, you did say quite expressly that Mr. Ajay Gupta, you were friends with Mr. Ajay Gupta. I do know that much earlier than that, you did say that you had visited their residence several times. I think that's the word at some stage that you used, and that you said the visits, some of the visits related to cultural events, but you also said you went there to socialize as well. So I'm just saying, I just want you to clarify, I may have had this wrong impression. Certainly, recently, I think you made it clear that no, with regard to Mr. Ajay Gupta, you were friends, And you did say you had visited the residence a number of times, several times, to attend cultural events as well as socially. But somehow I have this impression, and I just want you to dispel it if it was a wrong impression that I gathered.
Chairperson, there isn't an affidavit which has asked me that question or which has posed that issue to me. I think in all the affidavits, I have dealt with specific allegations which related to a number of issues, board appointments, the 1064 fleet locomotives, and a whole range of other things. I've not had to respond to the question directly as it was posed here in the commission. And so what I was doing in the commission was to respond to the question pretty much for the first time to a direct question. Did you know them? What was the nature of your relationship? And clarify that it was not dealings, it was a relationship, it was of a social and cultural nature, and it was confined to Mr. Ajay, and did not entail all the allegations which were made by some of the previous witnesses, two of the previous witnesses, and so I had to clarify that. But it was the first time that the question was posed to me in that fashion. So in the affidavits, I have not had to respond to it, except to the point, except in the point on the Fundudzi report, which I say I probably should have answered more directly and should have read the 2 paragraphs that were asking me about it as one question, so that I can clarify it. But I've also indicated that in regard to that, I have provided a more elaborate response on several days, actually, that have been appearing before the chairperson.
It may be that, in particular, I got that impression, and I say nothing more than that it may have been an impression. It may be that I got that impression from your responses to Ms. Mngoma's affidavits and maybe an evidence. And I'm not saying it was a direct question or anything, because I think I got the impression that Ms. Mngoma was saying you and the Guptas were very close. You had a very close relationship, but that from your side, you were creating a gap or some distance without saying, I didn't know them, I never went to their residence, acknowledging that you did go there, but that there was that tension between your version and her version. She on the one side putting up things that suggested that the two of them, you and the Guptas were very close, but that your response sought to create some distance without saying you had nothing to do with them. Maybe that's where I got that impression. What do you think about that impression in regard to the two versions? Is it possible that maybe it's a question of she is saying you were this close and you are saying, no, not that close, but not as close as you say I was?
Chairperson, Ms. Mngoma alleges that at a certain period, she says, I went to the Guptas more than
20 times.
20 times.
Yeah.
Then goes further in the same breath to say, I would go there every Monday before going to Cape Town and return there every Thursday, Friday, or Saturday. upon returning from Cape Town. I indicated that if there were 52 weeks in a year, you're talking about 104 times, no longer 20. She says that on several occasions, Mr. Ajay would call me and we would discuss things. I say that's not true. She says that at some point, I was not picking up his calls, and I asked the question, if my phone rings and I don't pick it up, how do you know who is calling? She says that they gave me a car, which was in her name. I say there's no such a car. So I'm saying, Chairperson, that perhaps it's the Chairperson's impression that, or let me rephrase and say, the Chairperson's impression that Ms. Ngoma's version and mine are vastly different is correct. Let me state, Chairperson, that, knowing someone, even if you socialize with them, doesn't make them close to you. Doesn't mean that when I have customary functions at home, that I invite them. It doesn't mean that they are involved in the nitty-gritty of my life. There are people in South Africa who are my close friends. And those are people I would claim are close to me. And there are people I know. There are people I know that I would socialize with from time to time. Doesn't make those people to be close to me. When I say I know you, I can visit you, or I visit you, that doesn't certainly mean that you are close to me. So yes, I knew them, and I got invited to some of their social or cultural functions, but that certainly doesn't mean that we were close to the extent that Ms. Ngoma was alleging.
Well, I would what you have just said about closeness apply to you and Ajay Gupta as well? I would have thought that you saying you were friends meant he was closer to you compared to the others, and that you may have been close, except that on your version you make it clear that the friendship had nothing to do with discussing businesses. It was personal.
Closeness would apply in that case too, Chairperson. As I say,
Yes.
there are many people I know.
Yeah.
It doesn't make them close to me. There are many people I can socialize with, or I do socialize with. It
Yes.
doesn't make them to be close to me.
Yeah.
I think when you unpack the word close, it means that you know the nitty-gritties of my life. And I know the nitty-gritties of yours. We can talk. We are comfortable to share a number of things in our conversations. This didn't apply in that case.
Okay, all right. Mr. Mybeck?
Yes, thank you. I want to take you then to the affidavit of Ms. Mzamela. You find that affidavit at bundle 8, starts at 247.
This bundle that we're using just now, Mr. Mybeck, can it go away?
Yes, it can, Chairperson.
Okay.
And if I could take you then forward to page 252, please.
Are we doing quite well in terms of our pace, Mr. Mybeck?
I don't think we're doing well, Chairperson.
Okay, at least that tells me something. Okay, all right, let's continue.
Thank you. At paragraph 12, Mr. Gigaba, Ms. Mzamela says, my experience of the approach to governance under the then Minister Gigaba's tenure was different. Under his tenure, there developed a very grey line on what would ordinarily be the board responsibilities and duties management's responsibilities and duties and delegation. Let me deal with 13.2. No proper protocols were followed for engagement with the organization, or rather, the established protocols were ignored, and individuals who ordinarily would not interact with the organization were now playing a lead role on matters normally reserved, in brackets, as per the delegation, close brackets, to management of the organization or the board. Specifically, the involvement of the then Minister Gigaba's advisor, Mr. Siyabonga Matlangu, was significant and unprecedented. You want to comment on that?
Chairperson, Ms. Mzimela should explain how many times I engaged with the board and how many times I, as the minister, engaged with management and how. During her tenure, which lasted, I think, until 2012, though I might not exactly recall, when I needed to meet the board outside the framework of the AGM, a special meeting would be convened, as is the norm in SOEs, because the minister is not a board member. And if the minister seeks a meeting with the board to discuss an issue, then a special board meeting is convened and the agenda item to be discussed is placed forth, so that the board prepares for the briefing to the minister. That was not undermined, it was not compromised, it was not reversed. I don't recall engaging as the minister with MENCO of SAA, not in a formal way, except when I would have visited their offices and they were showing me. Now, if Ms. Mzimela was alleging that I should not have come to SAA, I'm the new Minister of Public Enterprises. I want to visit Airways Park to see how, where are they based. It's an SOE in my portfolio. It's one of the important, as I arrived, they've applied for a bailout, and so I want to come and see where they operate. I remember Ms. Carolas had also invited me to come to view their their simulation for aircrafts and pilots. So when I visited there, that of course is partly informal, but it's a formal visit by the shareholder to the head offices of the entity over which they have oversight. I have a right and every duty to do so. And I'm sure my predecessors would have done the same and my successors would have done so. So what Ms. Mzimela seems to be suggesting is contained in paragraph 13. So paragraph 12 is in every possible way, not just an exaggeration, a distortion. Because she doesn't then proceed to say, this is then how Minister Gigaba then bled the lines insofar as both responsibilities and duties, as well as management responsibilities and duties. She then goes in paragraph 13 to explain what the problem she is talking about. And that, I think what she's saying is that the involvement of Mr. Mahlangu was significant and unprecedented. I think they should have informed me, because I do not think, except on 2 occasions, when Ms. Carolas, who was the chair of SAA, indicated to me that I was not happy with Mr. Mahlangu's conduct in a particular instance, where she says I then reprimanded Mr. Mahlangu in her presence. I can't recall the second instance, where they might have brought to my attention their discontent about him, which I would have dealt with. But this significant and unprecedented involvement was not brought to my attention. I could only rely on what I knew and what they would have brought to my attention, not what I did not know.
So I might touch on some other aspects of what she says about Mr. Mtlangu a little later, but let's go please to page 262.
Before that, Mr. Myberg, I note, Mr. Kigaba, that what Ms. Mzimela says in paragraph 13 that you referred to just now may well be seen as consistent, and I want you to comment on that, as kind of consistent with what Fundutsi or the managing director of Fundutsi said in the affidavit that we dealt with earlier, said I think Ms. Makobo, is it Makobo, from the Department of Public Enterprises, said about you, or the position you took about the policy and policies and framework that were there in the department for the appointment of board members. In other words, as I understand what the managing director of Fundutsi was saying, is that they were told by Ms. Makobo that there had been existing policies or frameworks for the appointment of board members, but when you came in, you sought to ignore those and deal with matters in an informal way. What Ms. Mzimela says here seems to me, and maybe you might say that's not justified, seems to go along the same lines when she says no proper protocols were followed for engagement with the organization, or rather the established protocols were ignored, and individuals who ordinarily would not interact with the organization were now playing a lead role on matters normally reserved to management. I just mentioned that because it's a thought that came to me when I was reading it. Do you want to say something about that thought?
Yes, thank you, Chairperson. I think I explained with regard to Ms. Mohobo.
Yes, you did.
That I didn't understand what was meant by an informal way of engagement, because I explained the outline that one, I did not change. She can't point to any decision by me to change the 2008 protocols. And secondly, that where I personally engaged with the department on board appointments and asked them to rather present to me directly, would have been in instances where I wanted to engage with the submission so that they can explain as the people who would have originated it. You see, Chairperson, you could say, somebody could come to the chair and say, the cabinet process is informal if it is in a meeting, that a formal process for cabinet is to circulate cabinet memos and expect ministers to write down their responses. Now that is formal. But a meeting is a formal process where records are taken by the people who are supposed to take those records. That is a formal process. It cannot be regarded as informal. In this case, where there is reference to established protocols ignored and individuals who ordinarily would not interact with the organization were now playing a lead role on matters normally reserved to management of the organization or the board. I have responded in 2 ways. That one, I never changed any protocol insofar as how I, as the shareholder representative, interact with the board. Ms. Mzimela can't point to any such instance where there was a directive from me, because I reserved the right to change the protocols if need be. I did not. And continued to engage with the board in the manner which is established, which I thought, as I was briefed, is established norm in terms of governance. But the minister can't just simply call the board. If you want to meet with the board, the department would write a letter to the company secretary, a special board meeting would be convened, an agenda item would be tabled, and then you engage. Now, I think what Ms. Mzimela is referring to here is these individuals who would not ordinarily interact with the board or management, and whose involvement she claims were significant and unprecedented. And I think they should have brought those to my attention. In part, that is part of why, when I spoke with the board, I said with the chairs and the CEOs of the SOEs in my portfolio, I said to them, guys, ladies and gentlemen, please, when you hear anything from anybody who claims to have spoken to me or to have been directed by me to meet with you, please do not just simply comply. If you do not check with me, just ensure that you follow the supply chain, public procurement, and other legislative processes that pertain to those issues, so that you don't find yourselves gullible to people who come brandishing my name without my knowledge, or simply by having spoken to me and I said to them, go talk to the relevant people.
Thank you. Mr. Mabek.
Yes, thank you. I'd want to pick up at page 262 and deal with the Mumbai route. There were, of course, two meetings that you were involved in, the one on the 10th of January 2011 and the other on the 14th of April 2011. To start by dealing with the January meeting. But can I just ask you, before we get into the detail of the meeting, this Jet Airways, what did you know about Jet Airways?
Nothing.
Who were Jet Airways? Where did they come from?
They sent a request for a meeting. They said what the meeting was about. I did not want to meet with them, and that's why I invited SAA to that meeting, so that the version of SAA would be put on the table, because I was new in the portfolio, and here is an airline that makes all sorts of claims. I didn't know about this, and so I thought, let SAA come so that they put our perspective as the South African government on the issue that was being canvassed by Jet Airways.
So we will come perhaps to this later, but in the time of Ms. Carolus and Minister Hogan, Jet Airways had also sought to arrange meetings which they refused because they considered it to be an operational issue. Why did you become involved in this?
Chairperson, the first reason is that here they were not only raising an operational issue, they were proposing what they presented as a win-win solution, a cooperation agreement. Now, in that regard, I felt, let's have a discussion, let me hear what this is about, and then the matter will go back to the relevant people who are supposed to deal with it. But secondly, there were a number of other instances, Chairperson, where the shareholder would get involved. You know, somebody would say the appointment of a strategic equity partner for SAA, which was announced last week, is an operational issue. It was not announced by the board of SAA or by the, it was not announced by the business rescue practitioner. It was announced by the minister representing the shareholder. Why? Because the airline is in financial distress. It's undergoing business rescue. And SAA has had that problem for the longest of time. Even as I arrived as the Minister of Public Enterprises, they had applied for a bailout, and secondly, there were already a public debate about whether SAA should not be privatized. Minister Kigaba, are you going to shut SAA down? They've been receiving a lot of bailouts. They are hurting the national fiscus. Now, here is an issue involving the airline on a route which we considered strategic at the time, as South Africa was a member of the BRICS bloc. And so, without saying to them, this is the solution, I had a right to meet the parties concerned and listen to them. And as I responded in my, I think must be my January 2021 affidavit, I listed a number of instances where I interacted with various parties or partners of SOEs in matters which someone would have regarded as operational, but which we as the shareholder thought were important. I met with the unions on the strike in Medupi. The Eskom board could have said to me, this is operational, minister, stay away from this. But the protracted strike was hurting the country and the capital investment which was being undertaken at Medupi. I met with the global equipment manufacturers of that are the primary contractors at Medupi and Gusile. The Eskom board could have said to me, no, minister, this is an operational matter, stay away from it. But it was hurting the national fiscus, the image of the country. It was hurting the credit rating of the country and of Eskom. It was hurting the ability of Eskom to raise money from the capital markets. It was necessary for me to call the contractors and say to them, I want this matter resolved. And in meeting with them, the various SOEs concerned would have known that I am not doing so in favor of the contractors, but I am doing so that issues are resolved in favor of the SOE, which is an entity in my portfolio. And that is why I participated in this. That is why on no occasion in these meetings did I ever say that resolve this matter in the following way. I kept saying, find an amicable solution, resolve this way so that we rescue the balance sheet of Eskom and of SAA, and SAA doesn't bleed on the route. So if you ask, Chairperson, why did I feel the need to meet? Ministers are not the same. Ministers are not the same. Their approach to issues is not the same. But what binds all of them is their common commitment to the entities of the South African state which they are overseeing. And in this case, I had the interests of SAA, the best interests of SAA at heart, on a route which they were bleeding, on a route in which they were bleeding financially. And the issues that were being brought to my attention, just as I had arrived, required me to say, let us meet, let me understand. It would have been wrong of me to have gone to that meeting without SAA being present, because then I would not have known what is the version of SAA, nor would I have provided SAA with an opportunity to be there to state their own version in the same meeting, so that we know how we resolve this issue and we move forward. And actually, there was no intention on my part that there should be any resolution in this meeting, because I considered it to be an opportunity for me just to listen.
So you were appointed as the Minister of DPE in November of 2010, and this meeting is held very early on the 10th of January 2011. What caused you to prioritize this as something that you attended to very early in the new year?
I did not prioritize it. I received a request and responded to it.
But Mr. Gigaba, this is an issue that had been brewing for some time. And if you look at the evidence of Ms. Carolus, and we'll come to it in time, there had been requests for similar sorts of meetings.
That was what SAA brought to my attention when we had convened the meeting, that they had had this approach prior to this meeting. This was their view as the airline, and as you will realize, their views on the matter continued to change, to evolve. Yeah.
All right, well, let's have a look at paragraph 41. Ms. Msimela says, I arrived on time with Mr. Satoli. He was the chair of the board's Audit and Risk Committee. Ms. Carolus wasn't available to attend the meeting. She says, I arrived on time with Mr. Satoli for the meeting at the DPE offices in Pretoria. On arrival, we were met by Mr. Mtlangu, who was Mr. Gigaba's legal advisor. We were then informed that we were waiting for a representative from Jet Airlines to arrive and join the meeting. We would later be advised that Jet Airways representative had been delayed in Cape Town, and we overheard Mr. Mtlangu stating that they were traveling by private jet to Johannesburg. Were you present in the meeting at this point?
Chairperson, this was on their arrival. As they say, they were met by Mr. Mahlangu, so the meeting hadn't started.
All right. At 42, during the period of waiting, we had the opportunity to meet with Mr. Gigaba. We requested to be briefed on the SAA/Jet Airways relationship. I then proceeded to take Mr. Gigaba through the memorandum, emphasizing reasons for not recommending the cancellation of the SAA-Mumbai route. Additionally, I explained to Mr. Gigaba that Jet Airways owed money to SAA and were delaying in payment and therefore could not really be trusted as a partner. I indicated that any strategic partnership that could be forged with Jet Airways would need to be beneficial for both parties and more so for SAA. The memorandum alluded to the fact that the proposal by Jet Airways to close the route would have no mainstream benefit to SAA. If anything, it would increasingly benefit Jet Airways. Do you want to comment on whether or not that happened?
Chairperson, my reading of what Ms. Mzimela says here is that the proposal which Jet Airways had at that time made, remember, Chair, the discussions between SAA and Jet Airways had taken place. The CEO of SAA in 2004 had met Jet Airways in London. And subsequent to that, there had been signed interline agreements. So there were interline agreements already existing even at this time. That is why SAA says that there was money owed to them as a result of inability by Jet Airways to pay some of the money that was due to SAA arising out of this interline agreement. The nature of this interline agreement, I don't know. The nature of the interline agreements between the two airlines, I don't know, which resulted in Jet Airlines having to pay SAA. Now, what she's then saying is that because they are being owed, and the proposal that Jet Airlines is presenting to them is only beneficial to SAA, they would have a problem with that proposal. And one of the proposals would mean that SAA would only enter into point-to-point arrangements with Jet Airways, which means SAA can fly passengers from Johannesburg to Mumbai and not proceed to Delhi or other parts of India. So when they arrive in Mumbai, they must deliver passengers, and Jet Airways must take those passengers arriving through SAA and take them forward. But on the contrary, what Jet Airlines wanted was to be able to deliver passengers in Johannesburg and perhaps be able to take them to Durban or take them to Cape Town or take them to other destinations which were SAA's routes. Now, SAA was saying the agreement we enter into must either be a point-to-point agreement for both of us, or if it includes fifth freedom rights, the ability to proceed beyond the original major destination, which, for example, in the case of SAA would be Mumbai. If Jet Airlines wanted to not only to land in Johannesburg and drop off, but proceed to other routes, SAA would need a reciprocal right in turn in regard to the Mumbai route. Now, they said this agreement, this proposal which Jet Airlines is making to us is not suitable. Not suitable in particular also because SAA offered an additional advantage for Indian passengers, that upon arrival in Johannesburg, it could then take them to South America, to Sao Paulo. And so SAA wanted a different approach, a different engagement compared to the one that Jet Airlines was presenting. And that is why Ms. Mzimela said to us that, no, the proposal which Jet Airlines is presenting to us is not suitable, it's not conducive in our opinion. It would only benefit them and not us.
So, Mr. Gigaba, do you accept that Ms. Mzimela conveyed to you what she states at paragraph 42?
Yes, she did convey
Right.
it, yes.
Let's go to paragraph 44. We waited for over 2 hours before the meeting finally proceeded with all the relevant stakeholders. Isn't that a long time for a minister to indulge a party? 2 hours.
I don't recall how long did we wait.
If she says 2 hours, Mr. Gigaba.
It would have conflicted with my program. So I don't think it was 2 hours.
Well, how long was it?
I don't know. This was 2011, Chairperson. I don't have my diary with me today.
Did you respond to this affidavit? Maybe you said in your response, do you recall whether you, because one of the features I had the impression was strange was that you as the minister and the SAA delegation could be kept waiting for so long, and that this could be tolerated. So if you did respond, it would be, because she certainly said her evidence was that it was a very long time, and I think she said 2 hours even in oral evidence. Or maybe you would have remembered if you responded in a different way. Mr. Mybeck, do you have a recollection?
Mr. Gigaba did respond. He deals with this, the Mumbai route and the Jet Airways meetings at page 572 of the same bundle.
572. Yes.
There's no reference there to the,
Yes.
To the duration.
to the duration.
Yes. Well, was this affidavit a response to Ms. Mzimela's affidavit, or was it in general?
The purpose of the statement is recorded at 562, paragraph 4. The purpose of the statement is to supplement my preliminary statement submitted in response to Ms. Simela. So there is another
Statement.
there's another affidavit which you find commencing at page 538. And there you'll see that Mr. Gigaba also deals with the Mumbai route, chairperson, at page 547. And he deals with the meeting on the 10th of January at page 550.
It looks like that there is no reaction to the time. Yeah, I may be wrong, but from what I've looked, from what I've seen, it doesn't look like there is a reaction to the time. Okay. But you say
We would not have waited 2 hours, Chairperson.
you say you would not have waited 2 hours. What's the maximum you think you would have allowed to wait?
It
May have depended on your program, but
depended on my
nevertheless,
program, Chairperson.
you know, do you think you would have waited a whole hour?
I wouldn't
Maybe
know.
you wouldn't know.
I wouldn't remember.
Yes, because I thought Ms. Mzimela was rather emphatic that it was quite a long time, and maybe 2 hours.
Yes, and we'll come in a moment to Ms. Corralis's affidavit. She says that the delay was reported to her.
Yeah,
All right, well then, can we carry on
yeah.
at page 264, paragraph 44? We waited for over 2 hours before the meeting finally proceeded with all the relevant stakeholders. During the time that we were waiting for the Jet Airways representative, I received a call from Advocate Sandra Kutsia, who at the time was employed in the SAA legal department. Advocate Kutsia then informed me that there was a gentleman from Jet Airways who was in possession of an agreement and who was demanding that it be signed because SAA had agreed to cancel the Mumbai route. I advised her to stall because I had no knowledge of this agreement, and we had not even commenced with the meeting with Mr. Gigaba and the representative from Jet Airways. Do you want to comment on that?
I was not aware of this gentleman at SAA, and this would have been improper, given that we had no meeting, and the meeting we were going to have was going to be for me to listen to understand what the issues are being that are being brought to us by Jet Airways are. It could be, I think, as I said earlier, that prior to 2010, the previous MANCO of SAA had agreed to pull out of the route. That when the new CE of SAA took office, I think around February 2010, she then indicated that they had no intention. So the new CE had then decided that no, we're not pulling out of the route. Instead, we are prepared to pursue win-win cooperation. So what these people from Jet Airways may have been doing was to approach the meeting on the basis, one, of not knowing what it entails to meet a minister in South Africa, that I don't take decisions of that nature on behalf of the airline. Secondly, they may have come on the basis of understanding, of a previous understanding. And that is why they would then have been told that, no, wait, the issue of pulling out is not on the table. In actual fact, you are here, you requested a meeting with our minister, you come, you brief our minister, and when you finish briefing our minister, he will decide how we move forward in that regard.
So you say they might have been under the impression that it was a done deal?
Based on a decision which could have been taken before 2010, before I was even Minister at Public Enterprise.
And they knew they were meeting with you on this day, I take it?
Yes.
I see. Then at 46, eventually the Jet Airways representative led by Mr. Goyal arrived and we went into the meeting. Present in this meeting was myself, Mr. Satoli, Mr. Gigaba, Deputy Minister, Mr. Ben Martins, Mr. Mtlangu, and there were other DPE representatives. Mr. Goyal commenced the meeting by running through his CV, etc. Go to the last sentence. He proceeded to arrogantly state that SAA should get rid of the route because they had a better product that would be more suitable for the market. You remember that?
Yeah, the man was quite arrogant.
So, Mr. Gigaba,
That's your recollection as well.
Yes.
why did you not put a stop to this meeting? I mean, here these people are 2 hours late. Man comes in, he behaves arrogantly.
Chairperson, as I say, I don't think the meeting was 2 hours late. And when you've agreed to a meeting, perhaps we may not be the same. You know, I will listen to you even when I don't agree with you. I don't have to just stand up and walk out simply because I don't agree with you. I will listen to you, and when you finish your presentation, I will take my own decision. Ultimately, Chairperson, the decision is mine. Your approach to the meeting, your arrogance in that meeting, this was not the first time we met arrogant people, not only in SAA, but it happened even after this. I had similar experiences in my previous experiences, and not on any occasion would I simply stand up and leave, even when I have attended meetings where people have pulled out guns and placed them on the table. We continued with those meetings.
All right. Then it goes on to say, he attacked SAA for delaying the closure of the Mumbai route, specifically the current management for being stubborn, whilst previous SA management had already confirmed that they would ensure that the route was closed. I then pushed him for the name of the individual from SAA who had agreed to the closure. He then reluctantly mentioned Mr. Chris Smythe, who was the acting CEO before I took up the position. Mr. Smythe was also the person whom had canvassed the closure of the Mumbai route to the board. Mr. Goyal continued to seemingly instruct everyone present about how the process should be taken forward. I experienced Mr. Goyal's address at the meeting synonymous to him addressing his executives. At that point, Mr. Martin stepped in, as he seemingly did not take kindly to Mr. Goyal's instructive tone. He said something to the effect that, quote, "We are here to assist, but don't tell us how we should be doing things in our country," unquote. Do you confirm that?
Yes.
And then at 49, Mr. Gigaba was silent throughout the exchange. Mr. Goyle apologized and the meeting continued. Mr. Gigaba's contribution to the meeting was to indicate that he would like SAA to set up an urgent meeting with Jet Airways to discuss potential cooperation between the airlines. Mr. Gigaba gave no reason why the meeting was urgent. I did not consider it to be a matter of urgency, especially when the terms presented were to the detriment of SAA. I did not understand why Mr. Goyle was being afforded special attention by the ministry. Do you want to comment on that?
Chairperson, I never said that they should set up an urgent meeting. I said they need to set up a follow-up meeting to discuss the issues which they were raising, because Ms. Mzimela's own admission was that they wanted a win-win solution, that they were pleading on the route. They would want a win, they would prefer a win-win solution, but they were certainly not going to pull out of the route. Chairperson, you could by now be discussing something different, that you know, you knew the route was bleeding. You knew the airline was struggling on the route. You knew there was a proposal. You knew that the airline was willing to discuss a win-win solution, and you sat back and did nothing. Doing nothing is not good governance. Doing nothing is not good governance. But saying, let's explore solutions, without prescribing what solutions ought to be sought. And that's all I did. We need to have, you guys, and I directed them to have a follow-up meeting. I said, you must continue having a follow-up meeting. You need to find one another on this issue. You need to, as she says, to discuss potential cooperation, because SAA itself had said that they were willing to explore a win-win solution on the route, because they were obviously pleading. In routes of this nature, there is a number of options which could be explored, because the problem with, you know, if you take the route itself, SAA must take passengers from Johannesburg to India and also take passengers back from India to Johannesburg. It can't fly an empty metal from Mumbai to Johannesburg. Now you have two airlines, both of which are affiliates of the Star Alliance. They are flying the same route. Now, in those instances, you would usually say that perhaps on the following days, we will cover the route. So we fly on Monday night, and then we return on Tuesday night. You fly on Wednesday night, and return on Thursday night. But you among others, you would explore those options, and you would explore options for onward travel upon arrival at the point of destination. There's a number of options that could be explored, and you agree to establish one portal for the booking of tickets, or whatever other mechanism which ensures that in the end you do not fly empty seats, but you are able at any time that you take your flight on air to have fully occupied seats to the point of destination and on return. So these were all the options which could be explored. We didn't, as the department, say explore the following options. We just said to them, we hear you, the deputy minister has intervened and called you to order. Now, let's end this. You go and have further discussions, because previously you are approaching us on the basis of an agreement or commitment which had been made by an acting CE, Mr. Smythe. But there is a new CE now at SAA, and that CE is saying from their perspective, they are not willing to pull out of that route. And therefore, it means the proposal you are presenting to SAA is not acceptable. you now need to discuss on the basis of a proposal which would take the best interests of SAA and place them on the table and find an agreement which addresses the interests of both airlines on an amicable and on an equitable basis.
So if I understand, the only thing you don't agree with at 49 is that you said there should be an urgent follow-up meeting.
Yes.
Now, Mr. Gigaba, why did you keep quiet whilst this gentleman, Mr. Goyle, was busy attacking?
But my deputy spoke. He's a deputy minister.
So I'm not asking you that. I'm asking
No,
why did
but
you
I'm
not
responding to it. If the deputy minister intervenes and speaks, he is speaking also on my behalf.
All right.
Well, I think Mr. Mybeck's question is really this. You were chairing the meeting based on what Ms. Mzimela was saying.
Yes.
And this man was busy behaving in a completely unacceptable manner and attacking the management of your SOE. Why is it that the chairperson of the meeting wasn't the one who intervened? Why did it have to take the deputy minister to intervene? Because it creates the impression that the deputy minister may well have been waiting for the chairperson to put a stop to this, but when he realized that the chairperson wasn't putting a stop to this, he intervened. Why didn't you stop these people quite early and say, you are not going to come here and behave like this? This is unacceptable. If you want to talk business, SAA and we are here, but you are not going to be allowed to behave like this. Why didn't you do that?
I am not accustomed to interjecting people while they are talking, Chairperson. And it was not my practice, my way of chairing meetings. So I would let you speak, and then I would call you to order once you have finished. The deputy minister couldn't wait and interjected, and when he did so, I did not stop him. And when he finished interjecting and calling the person to order, I then supported him in that regard.
You supported him?
The deputy minister.
So what did you say?
I supported the deputy minister in what he had said. I reiterated what he had said and insisted that the meeting should be conducted in a professional way, in a manner that is respectful of all the parties involved, including myself in particular as the minister and chairperson of the meeting.
Maybe we should take the tea break now, Mr.
Yes, thank you,
Mybeck.
Chairperson.
Let's take the tea break. It's about 29 minutes or 1:30. We'll resume at 1:45. We adjourn. Okay, let's continue.
Thank you. Mr. Gigaba, we were just finishing off on the meeting of 10 January. I just want, in fairness to you, to take you to your affidavit at page 551, at paragraph 38.
Yes.
It's where you record, as you've stated, that actually I had during the said meeting called him to order in that regard. Is that then in the context of what Mr. Martin said and you concurred with him?
Yes.
And then if you go over the page to paragraph 39 at page 552, you record that I was silent during the meeting because I was listening to what was being discussed, which is courteous. I did not want to be perceived as taking sides. It's therefore mischievous to suggest that my silence meant anything more. You didn't want to be perceived as taking sides, you say?
It's my view, as I have said, Chairperson, that when I chair meetings, I would sit and listen to the person talking and only respond thereafter.
All right. We go then back, please, to page 267, and if we can deal with the events, or in fact 266, let's deal with the events in the immediate run-up to the 14 April meeting. Ms. Mzimela says that at paragraph 50, as per the request of Mr. Gigaba, SAA and Jet Airways then scheduled a follow-up meeting. That meeting took place on the 24th of January. At paragraph 52, Jet Airways persisted that SAA cancel the route and code share on them. SAA had indicated that this was not negotiable. And then at paragraph 53 at the end of the meeting, the two entities were not able to find consensus. Ms. Mzimela then goes on to say that on 11 April 2011, she wrote a memorandum to the DG, providing him with an update on the discussions we had, as she put it, with Jet Airways. Two sentences after that, the proposals put forward by Jet Airways were not commercially viable to SAA. And then we get to the meeting on the 14th of April 2011. Now, why did you call this meeting, Mr. Gigaba?
It was to receive a briefing from SAA on what had transpired subsequent to our previous meeting, and on SAA and Jet Airways, on what had transpired since our previous meeting.
Well, Ms. Mzimela had written to your DG a memorandum which set out the position, correct?
Yes, sir. And it's also important, Chairperson, to reiterate that on certain occasions, a memorandum doesn't set out and answer questions you might have to the pieces of paper that are sitting in front of you. That it's necessary to call people, sit before you, and you engage with them and understand what the issues that they have set out in the memorandum are. It seems from this account that the SAA management wanted not only a hands-off shareholder, they wanted a shareholder that simply disappeared, that just wasn't there. It was my discretion to convene meetings with our entities, and I exercised that discretion. That doesn't mean that we would force them to take any decision that was commercially unviable for the entity.
So Ms. Mzimela says at paragraph 56 at page 268 that around 14 April, the chairperson and I were requested to attend an urgent meeting with Mr. Gigaba in Cape Town on less than 24 hours' notice. Ms. Carolus was unable to attend given the short notice. She goes on to say the Minister's office called in the afternoon to request our urgent attendance the next day to the meeting in Cape Town. They had said that this meeting was very urgent and needed to take place immediately. But what was the urgency?
Well, since the minister is part of his office, I don't know why my officials would have said it's very urgent, and why the meeting would have been convened at such short notice. I think it was just an admin issue.
Do you have, do you accept what Ms. Zimela says in terms of what she says they were told by your office? In other words, do you accept that they were called at short notice?
I
The
cannot.
day before and then had to be there the following day, but you say there must have been an admin issue within your office, or do you say, no, they were not called at such short notice, they were given enough time, or are you saying, I actually don't know how much time they were given? If they say they were given that little time, I don't have a basis to dispute, but this is what I know should have been done by my office. Whether they did it or not, I don't know.
That's correct, Chairperson, because I wouldn't know when the invite was sent to them, and certainly if they were unable to attend, they would have indicated that unfortunately neither the CEO nor the chairperson or any board member for that matter is able to attend. I think that's why we were able to accept it, that the chairperson can't attend, but there's another board member standing in for the chairperson. But as to as to when exactly the meeting was called, I wouldn't really be aware, as the chairperson correctly says.
Mr. Member?
Yes, thank you. And then she goes on to explain at paragraph 57 that given that Ms. Carolus was not available, arrangements were made for her, that's Ms. Mzimela, to attend the meeting together with Mr. Docker.
Yes.
At the end of 57, it is recorded the Minister's office had not provided us with an agenda, but merely requested that we fly to Cape Town for an urgent meeting. Do you have any comment on that?
I would have expected them to have been provided with the agenda.
And then at paragraph 59, Ms. Mzimela explains that she then attends the meeting together with Mr. Docker, and present at the meeting are, amongst others, yourself and Mr. Mthlangu. At paragraph 60,
And Ms. Raisibe Lepule, Professor Vusikumete, Mr. Matuna, and other departmental
Correct.
personnel, yes. I think it's important to also indicate.
all right, those are DPE personnel.
Professor Kumete was my economics advisor at the time, before Ms. Nkomo replaced
Well,
him.
in terms of the agenda, was there an agenda that you had approved for that meeting with SAA?
I would have said, Chairperson, I mean, if you consider the fact that the DG was in Cape Town, the Ms. Lepule was the DDG for Transport Enterprises, they would have been called and told why they are being called to Cape Town, and I would have expected that the SAA leadership would also be informed.
But is that answer to the fact that you can't remember whether there was or you had approved an agenda, but that's what you expect should have happened?
The agenda would have been approved, Chairperson. And I think, again, I don't know what the communication arrangements between my office and SAA would have been, because I would have expected them to be informed that this is what we're here to discuss.
I just want to go back. Do you accept that this meeting was set up at less than 24 hours' notice?
I think I've responded to the chairperson just a few minutes earlier, chairperson.
And your answer is you don't know.
Yes.
But you
All right.
expected that the SAA should have been given more notice.
Yes. And if they were not able to attend, they would have indicated that, no, sorry, we're not able to come.
All right. Or did you know that Ms. Carolus was unable to attend this meeting?
I think I was informed.
When?
This was in 2011, chairperson. I cannot recall the details of when exactly was I informed of unavailability.
Well, can you remember whether it was before or after the meeting took place? Or
I
was
think
it before the meeting or at the meeting?
I just said, chairperson, I cannot recall. I cannot recall whether it was before the meeting or at the meeting.
At paragraph 60, Mr. Gigaba indicated at the start of the meeting that he had several items that he wanted to cover with us, but first he wanted an update on Jet Airways stroke SAA discussions. This surprised me because updates had regularly been provided to the transport team at DPE. I then commenced to provide the same update already provided on several previous occasions, that the Jet Airways relationship was not beneficial to SAA. It simply did not make commercial sense to enter into the proposed code-sharing arrangement. I indicated that the team had been open-minded in finding a workable solution to the partnership without much success, as Jet Airways' focus was not geared towards a commercial code share partnership, but still intent on getting SAA metal off the route completely. Before I could even conclude my briefing, Mr. Mtlangu angrily intervened. You want to comment on that paragraph?
Chairperson, I certainly would not have said that there are several issues to discuss if there was one issue on the table. And it would surprise me why the CEO of SAA would not want to provide an oral briefing to the shareholder, regardless of the fact that she would have written to the shareholder on several occasions, because it's important to keep the shareholder in mind. You know, one of the things that are important about such matters, Chairperson, is that, you know, they sometimes get discussed at bilateral levels of between countries because they impact on economic and trade relations between countries. And it's important at any given point in time, as the minister who would attend those bilateral meetings, either at ministerial level or should the heads of state and government meet, it's important for one to be able to provide a detailed briefing, which would even be able to explain if a relationship is unable to be established, the reasons why such is the case, because it could very well be that what was an obstacle for SAA could be brokered by another party, sometimes at the level of minister to minister. If I may use an example, when the Department of Home Affairs agreed on new visa regulations in 2014 and announced them in May, the government of China had given the Department of Home Affairs 3 visa facilitation centers in China. But after much discussion between the departments, after I visited China And upon my meeting with my colleague, we agreed to extend the visa facilitation centers in China, I think to about 5 or 6. The same had applied in India. I was able to broker an agreement. So it could very well happen that what is unattainable for the entity interacting with its partner or potential partner could be brokered by another partner, maybe by the senior politicians when they meet and discuss to say, let's do this in the following way, and then we instruct the junior partners to then go and implement the agreement or the framework that we have outlined. To me, there was nothing untoward in asking SAA to provide an oral briefing to me and explain what the challenges they were confronted with entailed. Now, the angry intervention by Mr. Mahlangu, I do not recall. What I do recall is him saying that what was needed was a non-adversarial approach to discussing the issue that was being discussed. But I don't recall this angry intervention.
So you say that Mr. Mahlangu was calling for a non-adversarial approach?
That's what I recall him saying.
Yeah.
But an angry intervention on his part, I do not recall.
Well, let's go to what it is that Ms. Mzamela said happened.
I'm sorry. This is in relation to the briefing between SAA and yourself, isn't it?
Yes.
But why would Mr. Mahlangu say to SAA, why would he call for a non-adversarial approach to SAA? Because as I understand it, SAA had not been adversarial or aggressive towards Jet Airways. It's Jet Airways who had been aggressive and adversarial to SAA.
I was not raising it, Chairperson, in relation to the meeting, this particular meeting, when we were still talking to SAA. I'm just saying my recollection is that he had called for a non-adversarial solution, but I don't recall his angry intervention.
Okay, Mr. Mybeck.
Thank you. So let me deal with paragraph 61 and 62 together. He, Mr. Mahlangu, said Ms. Mzamela, berated SAA for wasting time and taxpayers' money on the Mumbai route when there were RDP houses and toilets to be built. I attempted to continue with the logic SAA was applying in protecting the closure of the Mumbai route. However, Mr. Mahlangu was hearing none of it. He continued his rant and then became personal in stating that he had a problem with executives who fail to do what they are told and continuously present analysis only and do not understand issues of international importance. Paragraph 62, Mr. Kigaba failed to reprimand Mr. Mahlangu on his unacceptable rude behavior. As a result, I lost my temper and told Mr. Mahlangu in no uncertain terms that I will not tolerate anyone disrespecting me, as I strive to always be respectful of others. I informed him that he could not talk to me in that manner and attack me personally. We were engaged in business discussion. Mr. Kigaba remained silent throughout this incident. Comment on that?
Chairperson, it happens in the nature of discussions that people become heated, they talk in a heated manner towards one another. And as I say, I had come from an experience where there had been plenty of this. I didn't think that anybody needed to be babysitted in conversations, especially given the fact that these were all senior and very experienced people, that however robust they may have been towards one another, that we would be able to find a solution. My duty is to listen to you and sift through the noise and understand what are the issues that are being said, and thereafter be able to provide a summary to the discussion.
But the role that Ms. Mzimela describes here as having been played by Mr. Mahlangu appears to me to have been quite unacceptable for an advisor to the minister. I know Mr. Mahlangu seems to take a different approach in his affidavits, but my expectation would be that Mr. Mahlangu's role was generally to speak to you, advise you, and then what approach you would take based on his advice or not based on his advice is a different matter. Otherwise, he had no, as they say in legal language, he had no locus standi at this meeting, and except insofar as he was given that by you. He had no right to be at that table at that meeting, except insofar as you said, as my advisor, please come. But the role that he was playing, it was as if now he was there in his own right, and he had a particular position. That's the impression I get, and it just seems to me not what I would expect of an advisor. I would expect that even if I might not necessarily say he should not have spoken at all, except to speak to you and advise you, and maybe some people would say that, but the tone and the manner of speaking gives me the impression that this was somebody now who seemed to think that he was at this meeting in his own right. Whereas as I see it, you were the person who had the right to call the meeting and to be there. And he was only there insofar as he was your advisor. You know, otherwise he could not claim to be entitled to be there and to speak. Actually, if you said, keep quiet, he would have no basis to challenge that and say, well, I'm entitled to be in this meeting and I'm entitled to speak. He couldn't say that. So his role to me seems to be different from your role, from the role of Ms. Mzimela and people like that who occupied certain positions. But I have some understanding of Ms. Mzimela's attitude or position towards Mr. Mahlangu's tone and approach in that meeting. Do you want to say anything about it?
Thank you, Chair. I had spent 14 years, Chairperson, as a member of the National Executive, 6 of which years I was a Deputy Minister. I had attended many meetings with ministers, and advisors spoke. They spoke forcefully, they spoke persuasively, you know, in meetings of this nature, because they are viewed as internal meetings. You gauging different opinions, you're trying to understand from different angles. They would speak in meetings of the minister with top managers of the department, and in some instances they would speak even in sessions which were minister to minister, you know, to bring different perspectives from their expertise. Their views are not regarded as final. Their views are regarded as a contribution to the meeting, and ultimately everybody understands that the ultimate decision is that of the principals, and that's what my experience on this would have been, and that's why Mr. Mahlangu, Ms. Nkomo, and others would have spoken, and even during the times when I was a Deputy Minister, the advisors to the ministers in many of our meetings would also be allowed to speak freely.
May well be that it's not incorrect. I was just saying my expectation was different. Yes, Mr. Myback?
Yes, thank you. I just want to go to paragraph 61, though, the last sentence. It's recorded that he stated, Mklangu, that he had a problem with executives who failed to do what they told and continuously present analysis only and do not understand issues of national importance. Now, surely, Mr. Gigaba, that's beyond the pale. For an advisor to say to the CEO of SAA,
Chairperson, an opinion is only that. It's an opinion. I am the principal. The decision is mine. When you state your opinion and you say you are not doing what you are failing to do what you are told to do, what are you told to do? Let's go back to the decision of the meeting of the 11th of January, which had said, go discuss, find a win-win solution if you can. And SAA comes back to us to say, we are not able to find a win-win solution because we are owed money. The party with whom we are negotiating is arrogant. They want a solution which favors them. And so we are not able to find a solution. So Mr. Mahlangu's opinion was just simply his opinion. And did not represent the view of the meeting or the shareholder, because insofar as I was concerned, SAA had done what I had asked them to do. They had come back to say we're not able to find an agreement. And in my view, as I said previously, that when there are disagreements in negotiations, it doesn't mean that if we disagree today, then it's over. We could disagree today, and then the other party goes to think about what has been disagreed upon, and upon reflection or consideration of the facts presented by the other party, they then change their mind to come back and say, in actual fact, we are able to compromise, or we want to table another proposal. But this was just simply Mr. Mahlangu's opinion, not a representative opinion either of the minister or the DG or the meeting itself as taking place at the time.
Of course, the picture that seems to emerge in terms of that meeting with the Jet Airways representatives, and this one is that, or maybe seen to be that, at the meeting with Jet Airways, Mr. Gopal was his surname?
Goya.
Goya, yes, yeah.
Gopal, Mr. Chairman, if you're thinking of Gopal, you may be thinking about the one, I think, on Commercial Street in Durban.
Well, I haven't been to the center of Durban in a long time, but maybe. The impression that may be seen to be emerging may be that at the meeting with Jet Airways, Mr. Goyal was putting pressure on SAA to agree to their position, namely to withdraw from the Mumbai routes. And you were quiet when certainly the SAA delegation expected you to say something much earlier than you may have said. At this meeting, on what Ms. Mzimela is saying, it seems that it was your advisor who was pushing them towards, or putting pressure on them to agree to Jet Airways' position, because you are saying, as I understand you, you understood that SAA had done what you had asked them to do, to have a follow-up meeting with Jet Airways, they had had discussions, no agreement had been reached. From what you are saying, I gained the impression that your attitude was there was no blame to be laid at the door of SAA for the fact that no agreement was reached. But Mr. Mahlangu's attitude seems to be different. Otherwise, one wouldn't understand why he is saying he had a problem with executives who fail to do what they are told and continuously present analysis only, because that seems to be directed at saying that's what you SAA management executives have been doing. You have been told to do something, you have failed to do it, you keep on presenting us with analysis. So I'm saying to you, it could be seen as he was putting pressure on the SAA executives to agree with Jet Airways in this situation. What would you say to that understanding of Ms. Mzimela's evidence in relation to Mr. Mahlangu?
Chairperson, let me first refer you to the same bundle, page 551.
Yes,
which was my affidavit,
yes,
on paragraph 38,
yes,
where I say, actually I had during the said meeting called him to order in that regard, which I've spoken about.
Then you're referring to Mr. Koyam?
Yes.
Yes.
And then I proceed to say, in the wrapping up session with our delegation, I clearly indicated to the team that they had to do what was in the best interest of SAA, that I would take advice from them. There would have been no doubt whatsoever as to what I meant by that. So that's the first thing, Chair, that in respect to the forcefulness of Jet Airways that SAA must pull out of the route, my view was, do what is in your best interest. I will be advised by you as our team, not the others. Now, secondly, Chair, the issue of executives who keep presenting, who continuously present analysis, did not, I don't want to say did not arise, because what SAA was now presenting to us was not analysis but report. If they were presenting analysis, that would be one thing, but they were presenting a report. We have tried to talk, these guys are standing to their initial version, and therefore we are not able to agree with them. And so
Did they
to
not
me,
provide an analysis of the discussions, maybe?
even if they did provide an analysis, Chairperson, but the fact of the matter is that they were presenting a report. So we were no longer dealing with an analysis. Perhaps prior to the meeting of January, we would have been dealing from our angle with a report analysis. But at this stage, we were dealing with a report. And if you analyze the report, but what you are analyzing, you are providing an analysis to the report. And there is nothing else you can do. Excuse me. There is nothing else you can do when a report is being presented that says that we are not able to find an agreement, because what we seek at this meeting, Chairperson, if I may just elaborate a bit further, Mr. Daga had informed us that the previous MANCO of SAA had proposed withdrawal on the route. But
That's Mr. Smythe.
no, Mr. Daga. This meeting of April was attended by Mr. Daga on behalf of the board
Yes,
instead of Ms. Carolas.
yes.
So when he made his, it could be, sorry, Chair, now I get what
Yes,
you are asking.
yeah.
It could be that he was referring to Mr. Smythe. Then he says the board had disagreed and was of the view that SAA should seek cooperation without disadvantaging the airline. And he gives a broad analysis of what had happened, of their perspective as the board, which was that they need to look at the route not only from the point-to-point view of connecting routes, but they needed to look at the route not only from the point-to-point perspective, which I was outlining earlier, India to Mumbai, Johannesburg to Mumbai, Mumbai to Johannesburg. But he said their view was that they needed to look at this from the point of view of connecting onwards. In India, as in Johannesburg, because if you travel to India, you have an advantage of being able to travel to different parts of Asia. If you travel to Johannesburg, you have the advantage of being to connect to different parts of SADC and even at other parts of Africa. Now, in that regard, SAA presented a view, according to Mr. Daga, that in addition, SAA has an advantage of taking passengers from India to South America. So the board was concerned that jet airlines were not prepared to discuss with SAA in good faith. And that is why they were of this very firm view that we are not able to find an agreement with jet airlines, but we will not concede to the proposal that we need to cancel the route.
Mr. Murphy.
Yes, thank you. If we return to paragraph 62 at page 269, do you accept that Ms. Zimela lost her temper and told Mr. Mthlangu that she considered him to be disrespecting him? Her, rather.
Much as I don't recall the incident, I think I don't recall the incident. I can neither accept nor deny that she lost her temper. I said earlier, Chairperson, that in my opinion, in meetings, people sometimes lose their tempers and speak harshly towards one another. And I don't always interject to prevent them from being robust in engagement. So if this is what Ms. Mzimela put as her version about Mr. Mthlangu, it is her version.
Well, it seems that must have happened because it's common cause between Zimela and Mthlangu that a few days after the meeting, if you look at page 270, headed paragraph 62.1 at the top, Mr. Mthlangu telephoned her to request a few minutes of her time. He then takes the train to OR Tambo and they have a meeting where he apologized.
I don't know, Chairperson, if Mr. Mthlangu also agrees to this version. But if he did apologize, then it's good for him.
But obviously it would also, if he accepts this, it would mean that
The incident
then he
happened.
must have behaved unacceptably at the meeting.
Yes.
Yes, but then it raises the question why you didn't intervene, Mr. Garber.
I have explained, Chairperson, I think on more than 3 occasions now, why I allowed the discussion to continue. The duty of the minister in chairing a meeting of adults is not to keep intervening and protecting people who are having robust opinions on issues. They talk, you chair the meeting, you then decide, after they've spoken, you sift through the noise and decide how you resolve the issues. If somebody feels that this point was harsh on me, then they raise it with you and you talk to the relevant person. But I took the conversation in the context of a conversation. In the end, what was going to resolve the issue that we were sitting and faced with, we were sitting to discuss. was not the anger, the robustness, and interjections of the individuals concerned. It was the facts that were being put or that were put before us, and that is what the chairperson would look at, and not who was angry and therefore try to intervene and stop people. I have sat in many meetings where even guns have been pulled before. We've not run away, we've not abandoned those meetings, we've continued, discussed and resolved the issues.
Chair, would you not accept that part of the duty of anybody chairing a meeting is that those who participate in the meeting speak and act, do not speak and act in a disrespectful manner to others?
Absolutely,
Why, in
Chairperson.
other words, they can be robust,
Yes.
but that doesn't give them a license to disrespect other people participating in the meeting.
Absolutely, Chairperson. And the issue of disrespectfulness, therefore, could also be a personal opinion. Some people are much too sensitive, others are not sensitive at all. So you may think that someone has been disrespectful towards you in how they raise their point, only to find that that is only your opinion of how events happened. Others had viewed this as a robust engagement, which was not disrespectful, which ultimately achieved results, because the one alleged to have been disrespectful did not, after all, force their way into the agreement and resolution of the meeting.
Mr. Mybeck?
Yes. Let's go then to paragraph 63. Mr. Dakar, who was perturbed at how the meeting was degenerating, addressed Mr. Gigabe and told him that he was concerned at the direction the meeting was going. Mr. Dakar also told Mr. Gigabe that he did not understand why Mr. Mtlangu took the view which he had expressed, that he believed SAA, especially Ms. Mzamela, was sabotaging the potential arrangement between SAA and Jet Airways. Mr. Dakar categorically stated that the executive had done extensive work around the analysis of the closure of the Mumbai route, and the board was satisfied with the quality of that analysis, hence they resolved to not cancel the Mumbai route. We flatly refused to be bullied by Mr. Mtlangu. You want to comment on that?
Three things, Chair, arise out of this paragraph. The first one is that Mr. Daka was perturbed at how the meeting was degenerating is Ms. Mzimela's personal opinion. When she goes further in the next paragraph to quote or to refer, to paraphrase Mr. Daka, she does not say Mr. Daka at any stage expressed a view that the meeting was degenerating. After all, the meeting continued until the end. And after all of this robust engagement, the meeting did not collapse into chaos. And the third point I wish to state is that the final paragraph where Ms. Mzimela says they flatly refused to be bullied by Mr. Mahlangu is again her opinion, which binds Mr. Daga. But in how she paraphrased Mr. Daga in previous sentences, she doesn't say that Mr. Daga had said or accused Mr. Mahlangu of bullying them. What Mr. Daga did in the meeting was to direct our attention at how the executive had conducted itself professionally in conducting extensive analysis of this route and the proposal which was sitting before them, and that he disagreed with Mr. Mahlangu when he said that he believed that that SAA was sabotaging the potential arrangement between SAA and Jet Airways. In the end, what SAA was presenting to us was an outcome of their own analysis of the proposal which had been presented to them by Jet Airways. And therefore they were saying, herewith is the report which indicates from our perspective that Jet Airways is not negotiating with us in good faith.
So there are key aspects of this paragraph that you dispute in relation to what Mr. Dakar said.
In relation to look, I don't know whether I'm disputing them or I'm just simply saying that Ms. Mzimela presents, so I'm saying, Chair, that
You're making certain observations
yes,
on them.
I'm saying the chap that Mr. Daga expressed these views that drew attention to what the SAA Manco had done and their view as SAA representing both the board and Manco. But I'm saying that the other aspects are Ms. Mzimela's personal views about whether Mr. Daga thought the meeting was degenerating or that he had said they are refusing to be bullied by Mr. Mahlangu.
All right.
Of course, what Ms. Mzimela does say at paragraph 63, Mr. Daga said, you know, because you have made the point of distinguishing between Ms. Mzimela's view of what Mr. Daga may have thought and what Mr. Daga may have said. What she does attribute to Mr. Daga is that she says Mr. Daga did say that, did express the view,
Yes.
or did say that Mr. Mahlangu had expressed the view that SAA, especially Ms. Mzimela, was sabotaging the potential arrangement between SAA and Jet Airways. In other words, as I understand this, Ms. Mzimela is saying one of the things that Mr. Daga said at the meeting is, here is Mr. Mahlangu, who is accusing SAA, particularly Ms. Mzimela, of sabotaging a potential agreement with Jet Airways. At least that part, she does make clear it came from Mr. Daga. Okay.
Yes, Chairperson, and I also have referred to it.
Yeah, okay. Mr. Mybeck.
Perhaps I can just take you back to 62.1.
Of course, I'm sorry, Mr. Mybeck. Of course, this was quite a serious thing for Mr. Mahlangu to accuse SAA and Ms. Mzimela of, to say something that you as minister had said SAA must explore with Jet Airways. Mr. Mahlangu was saying, in your presence, Ms. Mzimela and SAA were sabotaging, because what you had expressed on your evidence at the previous meeting between Jet Airways and SAA, which you chaired, was have a follow-up meeting, try and see if you can reach agreement. I will take advice from you, SAA. But here now, your advisor is saying at this meeting, in effect, according to what this paragraph says, it says your advisor accused SAA and Ms. Mzimela of sabotaging an agreement. Because I think your position was, if you can reach agreement with Jet Airways, that's fine.
Yeah.
But if you don't reach agreement, I will take advice from you. But this accusation says, in effect, you have a CEO who is trying to sabotage an agreement here. So this was quite something serious, you would agree?
It was something serious, Chairperson. Which I did not take serious because the advice that I sought from SAA, I had received. And how the meeting is then concluded and what happens going forward is then based on my understanding and appreciation of the advice that SAA has brought to me as I had asked them to do. Any other thing was just a personal opinion of the individual who was talking.
Mr. Maida.
Yes, I just wanted to perhaps take you to page 552, where you deal with the meeting on the 14th of April, in paragraphs 41 to 47. You will notice, Mr. Gigabe, that you don't dispute at all Ms. Samela's rendition of what Mr. Mklangu said and how he behaved, or about what Mr. Dakar said. Would you confirm that?
Chairperson, when I responded to the submissions or affidavits of Ms. Mzimela, I responded to issues which I thought were material, important for me to respond to. I did not seek to respond to sentence by sentence. What I regarded as important are issues which I responded to in my affidavit, and I am glad that I have got the opportunity through the chairperson to then respond further and clarify further on sentence or paragraph by paragraph, sentence by sentence assertions of Ms. Mzimela and other witnesses. So to the extent that in my own affidavit I would not have responded sentence by sentence, it is not because I considered those to be true, it is because I lifted up from their affidavits things which I thought were significant for me to respond to.
Well, what you were invited to respond to was from paragraphs 56 all the way to 68, dealing with the events of the meeting. That in terms of the 3-3 notice.
Chairperson, I responded to issues which implicated me, with the expectation that Mr. Mahlangu would be able to respond to issues which implicated him. I did not expect or think that I was being invited to respond to matters which implicated me, Mr. Mahlangu, and any other person. So insofar as the matters which implicated me, I responded to those issues. Insofar as to whether I kept quiet in the meeting or not, I responded to that. And as I say, I lifted issues that I thought were important for me to respond to. I did not expect that there was a prescription as to how I should respond to the affidavits which were presented before me. I also had an expectation that I would be invited to this session where I would have opportunity orally further to respond to any questions in terms of which I might have omitted certain issues in my written affidavits.
Now, perhaps I could take you back to 62.1 at page 270. I admitted to read to you the last sentence of that paragraph.
I'm sorry, 270. Page 2, is it?
Bundle 8, page 270, Chairperson,
Yeah,
270.
Okay, all right.
That paragraph that's numbered 62.1.
Yeah.
This is what Ms. Mzimela had to say about the apology. She says, he personally apologized to me for his bad behavior and informed me to the effect that at the end of the day, he was just doing his job and acting on instruction. Comment on that?
There was no instruction. There was no instruction, Chair. And I think I have responded to this again. I've responded to this. There was no instruction. If there was an instruction, it would emanate from Ms. Mzimela that there was this instruction, or I myself would have said so, or this instruction would have emerged anyway. My instruction was simple.
All right,
Go
then-
talk to these people, find out if you can reach an agreement, and come back, report to me.
At
Well, I
paragraph-
understand that sentence that Mr. Maibek has referred to refer to an instruction to Mr. Mahlangu. So in other words, when he says he was acting on instruction, I understand it to refer to an instruction to him rather than an instruction to SAA. I don't know whether you understand it differently.
Chairperson, I understand it to mean exactly that, but then I would only be schizophrenic to give one opinion to SAA and give another to Mr. Mahlangu, because by so doing, I would be ensuring that there is no, I myself now would be ensuring that there is no way forward. The important instruction here to understand is the one that says, explore the possibility to cooperate and come and report to me. And there is no other instruction which I gave after that, because had I given any instruction after this meeting of April, I would then have gone all out to ensure that my instruction is actually carried out. By Ms. Mzimela's own admission, the last time she met with me on this issue or heard from me about it was at this meeting of April 2011.
But isn't he saying that he's apologizing to her? We know, at least on her version, what offended her. Isn't he saying that I was instructed to say what I said?
By who?
By you? Or who else would have
doesn't say
instructed?
that.
Well, that's
doesn't
what I
say
was
that.
also.
Well, who else
well,
would have
that
instructed him?
That is what I was also saying. Well, to say, when I read that sentence, my understanding is that he's talking about an instruction to him, and I would imagine that the only person who could give him an instruction that he would, in accordance with which he would act or speak at such a meeting, could only be his minister. So,
Chairperson, with all due respect, Chairperson, I would not give anybody words. I would not put words into anybody's mouth and ask them to go say them in a meeting against any individual. If I wanted to talk to Ms. Mzimela, I would have spoken to her. If I wanted to talk to the chairperson of the board of SAA, I would have spoken to her. I would not have given instruction to anybody to go be rude to anybody. That is not correct.
But Mr. Gigaba, I mean, what would you say to the proposition that Mr. Mahlangu was doing your bidding while you kept quiet?
That would be an incorrect proposition, Chairperson, because again, then I would be providing conflictual signals. On the one hand, to say to SAA, do what you must do, advise me, I will take advice from you. And on the other hand, say to Mr. Mahlangu and Mr. Mahlangu alone that go be rude towards this CEO of SAA, try to force her to concede to this. But in the end, you know, it's not only the CEO of SAA who takes a decision or who would take a decision on these issues. It is the MANCO, it is the board. Remember that at SAA, there are various executives who deal with routes. There is a commercial executive, a commercial director at SAA, and others who deal with issues of this nature. And then the board itself would be the final arbiters on issues of this nature before a recommendation is made to the minister. So you can bully the CEO all you want, but unless you are able to bully the entire board, you are not going to get any result. And if I, as the minister, had wanted any particular outcome, I would have had to adopt a different approach which engaged the board in this regard so that it delivers the outcome which I would have wanted. And I would not have taken a seemingly hands-off approach that said to SAA, arrive at a decision that's in your best interest and advise me so that I know how to deal with this issue going forward. And then, after the meeting, you see, the mistake of reading sentence by sentence and disconnecting each sentence from the entire process that arrived at the fact that Ms. Mzimela says she doesn't recall beyond April 2011 her discussing this issue with me or having a meeting with me to discuss this issue, is that it then leaves you clutching at straws, unable to get the full picture. Because in the end, the decision to move out of the Mumbai route was taken not during my tenure, it was taken in 2015 when I had left the Department of Public Enterprises.
All right. So let's see if we can finish this off before lunch. At 64, Mr. Gigaba responded and stated that he would still like SAA and Jet Airways to try and find each other. He then asked Jet Airways personnel to be invited into the meeting. Jet Airways individuals had evidently been waiting to be invited into the meeting. No further discussions took place at this point, except for introductions. It is my assumption that the earlier meeting, it says, and how, I presume should be, had not played out, or how it played out did not go according to plan. I beg your pardon. The meeting was closed without further discussions taking place, except Mr. Gigaba's directive that the DPE DG, Mr. Matona, would coordinate further discussions between the parties. Any comment on that?
The meeting, Chairperson, had been briefed, including by the board member, Mr. Daga, that the SAA board was still interested in a number of solutions on this route. As I have said, one of those solutions was connecting routes. They were interested in SAA optimizing passengers from Asia for the route to South America, and they were concerned that Jet was not prepared to discuss with them in good faith. And that is why I then said to the DG, because as I say, Chairperson, we must not miss this point. The fact that we may be, when we are negotiating, the fact that we may be disagreeing now doesn't mean that the disagreement is permanent. Both airlines were bleeding on the route. It was not only SAA. Perhaps that's the point that we failed to make. It was not only SAA that was bleeding on the route, Jet was bleeding on the route. And that's why Jet was so anxious to benefit from the route at the expense of SAA. We didn't want that to happen. But we were conscious of the fact that SAA was also bleeding on the route, and SAA did not want to get out of the route. It was important that South Africa should be able to fly to Mumbai, India, to Beijing, China, to Sao Paulo, Brazil, and to Moscow in Russia. These were BRICS countries. So it was in our interest that we should be able to take passengers to those countries, and that we should be able to optimize on those routes. And that is why, whereas we did not want to just agree with Jet that we will pack our bags and leave the Mumbai route, you are the ones who are going to bring people from India to South Africa and take people from South Africa to India. we thought it would be better to find a solution. So that is why in the end I said, DG, can you talk further with these people so that the issues that SAA have raised, that they believe Jet Airways is unwilling to concede to or understand, at your level as the DG, can you try to facilitate an engagement further so that we can get an agreement in that regard? So the view that this meeting, or the assumption by Ms. Mzimela that the earlier meeting had not gone according to plan is actually incorrect. The meeting had gone according to plan. We had received the report that we wanted, and we had understood, even from the point of SAA through the mouth of a board member, that they were still keen on finding a solution on the route. And therefore, if the DG could assist to facilitate that solution and deal with the obstinance of Jet Airways with regard to what SAA wanted, that would have been beneficial to us, because what would not benefit South Africa or SAA was to fly empty metal either from Johannesburg to Mumbai or from Mumbai to Johannesburg, because you have two airlines from these two countries that are trying to cannibalize one another on the route and duplicating the route, taking passengers from one another, and therefore both of them ending up as losers. Because in that case, SAA would eventually, given its weak balance sheet, would eventually have to get off the route, because they would arrive at the conclusion that we are flying empty seats, and so this route is of no benefit to us.
I could ask you then, I'm going to skip forward. There seems to be some detail here that's not in dispute. So let me take you to paragraph 77. One of the things that struck me the most, says Ms. Mzimela, about the Mumbai route discussions was that when Mr. Gigaba took over, DPE became very involved in the detail of the Mumbai route and in ensuring that the SAA and Jet Airways deal materialized. We were never called to the DPE to discuss any other code share arrangement, despite many other challenging routes. Code share discussions with all other airlines were pursued and managed by the commercial department. To comment on that?
That is because no other airline sent a direct request to us. Had they, we would have also done the same and met with SAA. And I think, Chairperson, the context is also quite important. Beginning of 2011, we had just arrived. And so we found ourselves having this meeting, these two meetings, and after that we never had other meetings. I think it's important to complete Ms. Mzimela's paragraph 77 to say no further engagement was also had on Jet Airways with Minister Gigaba, as she had said in a previous paragraph, because we then, besides the fact that no other airline had approached us with regard to facilitating discussions on these routes, we also then never pursued these discussions. But it's important because Ms. Mzimela left SAA in 2012. It's important to say there were discussions in around 2016 or so between Qatar Airlines and Dubai Airlines with the Minister of Finance on a code share agreement between SAA and these airlines. I think on the South Africa Dubai route or on some other routes. So what Ms. Mzimela says here only suffices to explain her own experience ending in 2017. But subsequent to that, there were instances
And in
where
2012.
in 2012, thank you, Chair.
Yeah.
Thank you. It suffices as it relates to her tenure, which ended in 2012. Subsequent to that, when SAA had now been transferred as an entity under National Treasury, there were discussions which involved the shareholder with other airlines to the same effect. And those discussions also did not yield any conclusions. Because it was felt, I don't know what was the exact nature of those engagements, but they did not yield any conclusions in the manner that those airlines may have been proposing.
All right, and then at paragraph 78, from documents I've been shown by the Commission's investigators, it appears DPE and Jet Airways were in direct communication discussing issues relating to the Mumbai route, I beg your pardon, which would ordinarily have been dealt with operationally by the commercial division of SAA. And then she refers to certain letters in that regard in paragraph 79. And then perhaps I could just read to you paragraph 80. This kind of interaction was very odd. The DG's office had no business discussing operational issues with potential operational partners. The role of the shareholder is to provide strategic overview and not involve themselves in operational issues. The discussions Jet Airways were having with DG should have been held with the SAA executives. Comment on that?
Just two things. One, I think the DG may have been talking to them to try and get more information pursuant to what I had asked him to do, to see if he can assist in brokering an agreement. What SAA chairperson does not dispute is the fact that they wanted an agreement on that route. Not that they don't say we did not want to pull out and it ends there. They do admit that we wanted an agreement, and what stopped us from reaching an agreement with Jet Airways was the fact that Jet Airways was not negotiating with us in bad faith, and that's why I asked the DG to assist them. The second point, Chair, that I would like to make is that in as much as this was an operational matter for SAA, ultimately the decision on routes is a shareholder decision, or was a shareholder decision. And that is why the long-term turnaround strategy that was drafted in 2012, I think adopted in 2013 or in 2013, that's why it suggested that the shareholder needs to get out of having to be the final decision maker on routes. Because yes, besides that, it's an operational matter. It delays decision making for the airline to decide whether to pull out of routes or not, if it still has to do an entire assessment that will be sent to the Minister of Public Enterprises, and then the transport enterprises plus the teams that deal with finance still have to do their own evaluation of issues which already would have been evaluated and assessed by the airline. So that was to solve the problem. But the important point which I'm making, Chair, is that the DG would have been pursuing the mandate I had given him, given the fact that SAA had also indicated that they don't just simply want to stay on the route. They are interested in a solution which would be a win-win solution between them and Jet Airlines, so that they also could eke out some benefits from the route.
Chairperson, I see that it is lunchtime.
I sensed earlier on that you would prefer that to finish this affidavit before we take lunch. Maybe, depending how long that might take, maybe we should try and do that if that's
Yes, well,
convenient.
I suppose I just have one or two questions. If I
Yes.
might just quickly finish this.
Yes, let's do that.
Ms. Mzamela then goes on to deal with Mr. Nhlangu. And she says that at 82, Mr. Mtlangu, he was at SAA regularly, which was very unusual for a ministerial advisor. Mr. Mtlangu had a particularly keen interest in SAA procurement, and she refers to an IT tender. And then at paragraph 84, she refers to another meeting that Mr. Mtlangu convened in relation to the procurement of legal firms. And at 85, she says that Mr. Mtlangu regularly accused her of not being a team player because she insisted on everything being in writing. Do you want to comment on any of that?
Chairperson, with regard to 82, I was not aware of this. And certainly, as I had said, my view was I'm not getting myself involved in any procurement processes of SOEs. I was not in business. I still am not in business, even as we speak. So I was not aware of this. And so this will go to the IT tender. I didn't know anything about this IT tender. The airline aviation system, I didn't know anything about it. Yes, then the issue with regard to legal firms. I think what Mr. Mtlangu did, he picked it up, I think, from different people who would have been talking to him, and subsequently proposed a meeting between the two black lawyers organizations, BLA and NADEL, which took place at my offices in Pretoria. And we had a discussion with them, on the basis of which we then engaged with the Chairpersons Forum, which was a forum of chairpersons and CEOs of SOEs, where we had a discussion about legal and other professional services, because it was not only legal services that were complaining that black firms are not getting, one, that they were not getting sufficient work from SOEs, two, that the amount of work they would get would be trivial compared to the amount of work that would go to big white-owned legal firms. Now, we then discussed not only in relation to the legal profession, it was accounting, it was also advertising and marketing agencies, and took a composite view. That's with regard to legal issues, to legal firms. And then Mr. Mtlangu not being a team player, I think that is Ms. Mzimela's opinion, with which I can't engage, because she's expressing her own opinion. Whether she's right or not, I think it could be in relation to how they interacted with him. And so she's expressing her own opinion. But I think the area that I wanted to speak strongly at was the one of the legal firms. And even then, he would not have been expected to directly involve himself in procurement issues, not only of SAA, but of SOEs broadly.
Thank you, Chairperson.
Okay, let's take the lunch adjournment. It's 1:05. We will resume at 2:05. We adjourn. Okay, let's continue.
Thank you, Chairperson. Good afternoon, Mr. Gigaba. Could
Good
I
afternoon. Yes, thank you.
ask you, please, having finished Ms. Mela's affidavit, could we go to Ms. Kutsia's affidavit? That you find in bundle 8. And let me ask you to go to page 8. So this will be in tab 1.
Mr. Mybeck, for what it's worth, I just want to mention to you that the witness who was supposed to start testifying at 3, other arrangements have been made. He's not going to testify today, but there are others who will testify later.
I understand there's witnesses starting at 4.
Yes, if we can start at 4, that would be good. But I think the priority is to finish with Mr. Ikaba. So
We'll certainly get as far as we can,
yeah,
DCJ.
yeah. What is your sense at the moment?
We've still got a long way to go.
Is that so? Yeah.
As you know, Mr. Solomons is available until 5.
Yes,
So
yes.
whatever happens, I don't suppose we can go past that.
Yeah, no, we can't go past that. We can't go past that. If we can't start, if we haven't finished with Mr. Kigaba by 4, we probably could continue, maybe up to 4:30, maybe up to 5. But let's see.
Thank you, Chairperson.
Okay.
Mr. Gigaba, could I ask you to go to page 12? There's really only 2 paragraphs that I want to raise with you.
I'm sorry, you said it.
Bundle 8, page 12, Chairperson.
I don't have it here.
It's the same bundle that we were in before lunch that contained Ms. Mzamela's affidavit.
Oh, I'm sorry. And what's the page number?
Page 12. Mr. Gigaba, paragraph 17 and 18, you would have seen this. Ms. Kutsia deals with this telephone call that she received from someone who said that they were coming to sign an agreement. This is on the 10th of January 2011. When I was leading your evidence in respect of Ms. Mzamela, we dealt with this call. She gave evidence about what was reported to her. I don't suppose you've got anything that you wish to add to this version of Ms. Kutsia, which I've already put to you, albeit indirectly.
No.
There is then one thing I'd like to deal with in your Rule 3.4 application in relation to Ms. Kutsia. Could I ask you please to turn to page 35?
Is that 85?
35.
Okay.
And could I ask you to have a look at paragraph 21? You say in the second sentence dealing with these 2 meetings, after all, during that time, and I'm not sure if it has changed, in the MOI, all decisions on routes and code share agreements had to be presented to the shareholder for approval. Is that correct?
Yes.
So were you referring to an MOI that was in place at the time, in 2011?
Yes.
Do you have a copy of that?
I asked for it, I didn't get it.
Right. And as you understand it, it provided that decisions on routes and co-share agreements had to be presented to the shareholder for approval.
Yes,
Is that right?
sir.
Is that correct?
Yes, sir.
So as I understand that, would it then be for management to decide the issues and then for the shareholder to approve?
Yes, sir.
Could I then ask you, there are 3 of these affidavits that go together, Mzamela, Kutsia, and then Carolus. Can we go to Carolus? Ms. Carolus' affidavit, Ms. Gigaba, you find in another file, in Transnet Bundle 11. Ms. Carolus' affidavit you will find at tab 13. The affidavit itself, or statement itself, commences at page 809. If I could take you please to page 820. Paragraph 31, Ms. Carolus says, in SAA's dealings with the department subsequently, Mr. Mklangu continued to appear in meetings often completely unrelated to legal matters, without the minister. He was often the most vocal person, whilst departmental officials were silent. For example, Mr. Mklangu played a particularly prominent role in the efforts to get SAA to redirect spending on an emergency newspaper, The New Age, as well as our interactions with the minister and with the department relating to the Mumbai-Johannesburg route. Do you have any comment on that?
As I've responded earlier, Chairperson, that insofar as issues that did not relate to the discussions that we were having, I was not aware of these and they were not brought to my attention.
All right, and then if we can go to paragraph 41 at page 822. Here, Ms. Carolus is dealing with the Mumbai route, but under the tenure of Minister Hogan, your predecessor. She says at paragraph 41, during their efforts to get SAA to abandon the route, my office at SAA received several calls requesting that I meet with the president of Jet Airways. As with all requests for meetings, I asked the office to inquire what it was in connection with. I was told over the page that it was to discuss the Mumbai route. I asked the office to indicate that such discussion is best broached through our usual channels in management. This was the appropriate procedure since the board only considered routes when management presents proposals for consideration, and then only if it is a deviation from those agreed at the annual strategic planning session. I asked the office to refer Jet Airways to the CEO and to inform them that the board would be happy to discuss route proposals from the CEO in our normal course of business. I want to comment on that. Of course, Ms. Carolus was at the time the chairperson of SAA.
Yes, Chairperson, I think she's referring to board procedures. I was not a member of the board of SAA and I was minister, in which case my approach to meetings and which meetings I accepted did not depend on how SAA had established within itself as a corporate, how it would deal with issues.
And then perhaps of more direct relevance to you, at paragraph 42, it was then brought to my attention that the president of Jet Airways would seek to, quote, escalate the matter to the minister, unquote. I cannot recall who brought this to my attention. It is highly unusual for one competitor in the market to make such an approach to SAA, let alone the minister. As a courtesy, I immediately informed Minister Hogan. She felt that it was out of her remit as the shareholder representative to discuss deviations from routes with third parties before proposals were processed through SAA structures. You want to comment on that?
Well, I guess by the time of Minister Hogan, one of the things which they were raising, if one goes by this submission by Ms. Carolus, was a deviation from the route. At my time, or during my time, it was not a deviation from the route. They were proposing a partnership with SAA, part of which could involve, according to their proposal, SAA completely withdrawing from the route, which they were told was not going to happen. Now, secondly, Ms. Hogan was Minister of Public Enterprises for a period of just over a year. In the experience after she had left, when SAA was in the National Treasury, 2 airlines escalated proposals on code share agreements to the shareholder, and they were met with and discussed with. So all I'm saying is, what happened, Ms. Hogan's experience was within a time period. What happened thereafter was not confined to my experience, but it also happened when SAA was in the National Treasury, and the Minister of Finance then, which was not me, met with those, if not both of them, but one of them. But the issue of code share between SAA and Qatar Airways and Dubai Airlines was considered during that time.
So, Mr. Gigaba, perhaps I can just ask you a slightly broader question. In your time, how did you draw the line between the board's authority and your authority? How and where did you draw it?
That was governed by the King Code, it was governed by the PFMA, it was governed by the Memoranda of Incorporation, which would clearly spell out what are the responsibilities of the minister. Now, I don't know with regard to what issue is this question, because it is quite broad, so broad in actual fact that it would require me to get all the relevant documentation from the time so that I am able to provide a substantive response to this. But if the question intends or infers or intends to ask about code share agreements or routes, I think I've explained this quite adequately and very repeatedly, Chairperson, that these issues at the time required the minister to approve them, that it was the long-term turnaround strategy which proposed that they should actually fall within the remit of the board so that speedy decisions are taken which could save the airline loss of funds on the routes which are considered financially unviable.
But as I understand it, you've accepted that it was for management to determine a change and for you to approve it.
Chairperson, if the word approve means the minister is the final authority on the matter. So the board is in actual fact making a recommendation to the minister. The minister reserved every right to say, I don't approve. And that's why I said last week that Cabinet, in discussing the long-term turnaround strategy and the challenges experienced on the India and particularly on the Beijing route, was of the view that perhaps, and I think the issue was raised then by the Minister of Tourism, was of the view that government could perhaps have to consider the possibility of subsidizing the routes, which from the point of view of the airline were financially unviable, but from the strategic view of the country were considered strategic. Now, I have indicated that one of the challenges with the route to India was the landing slot in India, and the same applied to the Beijing route. And the reason why SAA, soon after launching the route, I think, to Beijing in 2013, wanted to immediately get out of it, was because the route was financially unviable, because the landing time in Beijing was quite awkward for travelers who could wish to travel onward, either within Southeast Asia or within China itself. And that's why Cabinet said, besides negotiating, I remember that the issue of negotiating the landing slot in Beijing was raised not only at the level of the officials. It was also raised at the level of ministers. It was raised at the level of presidents, the heads of states of both countries. And the issue was, how do we ensure that this route becomes financially viable, because it was of strategic importance to South Africa. If you want to benefit from the hundreds of millions, I mean, if I'm not mistaken, by 2018, China was reported to be sending about 800 million tourists abroad. And the discussion in South Africa was, how do you benefit from these hundreds of tourists, even if you didn't get all 800 million, but if you got 100 million of those, the tourism sector in South Africa would do well. So all of these decisions, all of these discussions are not mere technical bureaucratic matters which must be handled at the level of the operators of the airline. They also belong within the remit of the political decision makers. And that is why at the time, the view was, if the management of the airline recommends that the airline pulls out of the route, it must make a recommendation to the minister. But the dilemma was, the department took long to decide on these issues, and therefore the LTTS recommended that no, these decisions must be taken by the board of the airline. But cabinet was saying, wait a minute, if the route is strategic for us and the airline, based merely on financial considerations, decides to pull out of a route, is it not necessary that the airline should make a recommendation to cabinet through the relevant minister that cabinet should subsidize the airline for its operations on that route? And the question was, how much would such subsidies be? So there was a whole range of discussions taking place. So I think it would be very, very narrow to argue that the decision was a decision of the airline, because then we need to debate, what does approval by the minister mean? Because if you say the minister must approve a decision, it means that the minister is not a rubber stamp on the matter. It means that the minister reserves the right to say, I don't agree with the recommendation of the management. I suggest that the airline continues operating. Rather, I'm going to seek financial assistance for the airline to continue operating on that route.
I could take you, please, to page 8.
I take it you accept that in that event where the minister or cabinet, for strategic reasons, take a different view and say the airline should continue with the route, I take it that the subsidy that you're talking about, that would have to be put in by government, would have to be of such an amount that the continuation of the route by the airline must be economically viable.
Indeed, Chairperson.
Because you can't expect the airline to continue on a route that is economically not viable, just because it's strategically good for cabinet.
Indeed, Chairperson, and that's the context in which the issue of subsidy arose.
Okay.
But it was not, let me hasten to say, that decision was not taken.
Yes, yeah.
It was not taken, but it was an issue that was being
Discussed.
raised and discussed.
Yeah.
The point that I was emphasizing was the point of the approval.
Yeah.
Because the approval means the minister is not a rubber stamp.
Mr. Maipek.
Yes, thank you. Can we then go to page 824? So here, Ms. Carolus then deals with the Mumbai route during your tenure. And she deals with the January and April meetings, but we needn't go through all of this because we know that she is relying on reports, principally from Ms. Mzamela, and we've already gone through her evidence. There's just one or two things I'd like your comment on. You'll see at paragraph 45, she says, they reported to me, those were Toli and Mzamela, it's dealing with the January meeting, that upon arrival they were informed that they had to await the arrival of another party. All of them, including Minister Gigaba, waited for 3 hours. Mzimela, you know, said it was 2 hours. You want to comment on that, so far as you can?
Well, I don't know whether I'm not sure, Mr. Mabek, whether you need to really put that to him, because in the context of Mr. Mzimela, he has responded. The only
Can't
difference
recall.
might be 3 hours or 2 hours.
Fair enough. Thank you,
So
Chairperson.
in the light of the time constraints,
Yes.
it's unlikely his answer will be of anything other than what he has said. Am I right, Mr. Skikab?
Yes, indeed, Chairperson.
Yeah.
Thank you.
And then perhaps in a similar vein, at paragraph 47, I just wanted to point out that Ms. Carolus, it's plain from that she hadn't received an agenda for the April meeting, but as I understand it, Mr. Gigaba, your evidence is you would have assumed that that would have been sorted out by the DPE.
Yes.
Then I'd take you please to paragraph 51. There's something I'd like you to comment on here. She says at page 827, we found it peculiar that the minister was so determined to assist Jet Airways and find one another with the Mumbai route, when in fact there was an unnecessary dragging of feet on dealing with other route proposals that were central to SAA Strategy 2. For example, the DPE took unnecessarily long to give SAA permission to close the Botswana route that was making excessive losses. Didn't make sense that we were not being supported to close a route that was making even bigger losses than the Mumbai route. You want to comment on that?
Chairperson, the issue of the, let me start from
51.
from the end and move to the beginning. The issue of the Botswana route, I don't know how long it took to resolve it. I don't even know when it was submitted to DPE. And Ms. Carolus doesn't also indicate when it was submitted to DPE for a decision. I've responded to say that the issue of routes, Chairperson, I keep repeating myself in these issues, which is very important. The issue of routes and the decision it took, you see, that's why it would be wrong, Chairperson, to read the submission by, I think, Ms. Mzimela, that the decision on routes was a decision of the management and board. Because if you read then what Ms. Carolus says in 51, it actually affirms the point I have made. It was the decision of the shareholder. And the reason why the long-term turnaround strategy was proposing that the issue of routes must be taken away from the shareholder to the board and the management was because of the time it was taking. I think it's an issue which needs to be resolved. Because on the one hand, it could take long to resolve. It could be quick for a board to take a decision on the route. But the board is looking after the commercial interests of the airline. The shareholder, on the other hand, is looking after not only the commercial, but also the non-commercial mandates. Sorry, the shareholder is looking at the commercial and the non-commercial mandates of an entity. In which case, the shareholder might feel that even though commercially, the decision has to fall within the airline, but on a route, but how do we then ensure that the shareholder is able to influence a particular decision, especially where the shareholder feels that there are non-commercial interests? I'm not talking about the shareholder representative now, I'm talking about the shareholder as government, where government feels that there is a particular interest in us being able to fly South Africa, to fly directly to Beijing, not through Hong Kong, not through Malaysia, certainly not through Dubai, but to take our own metal, put our flag in the air and fly it to Beijing, because Beijing is a strategic partner for South Africa as a fellow member of the BRICS bloc. So that needs to be resolved, because if failure to resolve that would result in either commercial interests predominating, or it might result in the pursuit of non-commercial interests which would undermine the commercial interests of the airline. Now, coming further back to then the issue that Ms. Carolus raises of what was peculiar about being so determined to assist Jet Airways and SAA find one another. I think I've already indicated that neither Ms. Mzimela, or if I may rephrase, both Ms. Mzimela and Mr. Dag have already indicated that they were interested in a partnership agreement with Jet Airways, but which would not be disadvantageous to SAA and which would not benefit Jet Airways at the expense of SAA. So the issue of why are you being involved, I think becomes unnecessary and pedantic, because at the end of the day, they both are interested in a partnership. They both are losing on the route, and it doesn't help them to say that we're all losing on the route. There is a possibility for a partnership. We can't find agreement with one another, but let us continue making losses on the route. The issue that we were trying to do with our intervention was based on a request which had been brought to us to facilitate the meeting, to ensure that there is a meeting of the parties. I was asked a question earlier: why didn't you do it with regard to other matters? That was in Ms. Mzimela's affidavit. I said because the parties involved there had not come to us to ask us to intervene. And then I indicated that when the parties that sought a code share agreement between SAA and Dubai came to the shareholder to request a meeting to discuss the issues, including taking a stake at SAA, those issues were discussed by the shareholder. Nobody said there's something peculiar about that. In actual fact, it was necessary for the shareholder to do that. And I have also indicated in regard to broader issues which also involved other entities, including Eskom, that the shareholder would have and did intervene to try and resolve issues that were prevalent in those SOEs at that time. And there was nothing peculiar about that. It was the responsibility of the shareholder to do that without prescribing what form of an agreement needs to be arrived at.
But what would be wrong with the shareholder adopting the position that says, management, we have employed you to run this airline and run it profitably or in accordance with the compact, the agreement between the shareholder and yourselves and the board. You run with it. If you fail, you will have to account. If you don't run a proper, don't run it properly, you'll have to account. And we don't want you to complain that some decisions take long because they've got to go to cabinet and all of those things. The only areas where where you need our decision are really only A, B, C, D. What route you run, that's up to you, and must be profitable. You know what the compact agreement says, you know what the targets are. And if anybody tries to come to the minister and says the management is refusing to agree to this, you say, those people, we pay them a lot of money for them to run that airline. If you can't reach agreement with them, that's a problem. Their business is to run the airline. We are not running the airline. So you go to them. Don't come to us. Is that too artificial an approach? And I ask it because one does get the impression sometimes, maybe just from the media, that some of these SOEs don't seem to be given enough freedom to the boards and the CEOs to run the business. There is a lot of, I don't want to call it interference, but certainly matters where the politicians, the government gets involved quite a lot. That might be an impression that is not justified, but that certainly is part of what one gets. So one wonders whether the idea is not to say, look, we must employ people who have the expertise, the experience, and who understand what this government wants. But once we know that those are the people who have appointed, we let them run with it because we know they understand the mandate. And then we will only limit our involvement to A, B, C, D, full stop.
Chairperson, thank you for the question. And it's a question that we need to find an answer to. SOEs are not ordinary commercial enterprises.
Of course.
They are, by their nature, they have got a mandate which extends beyond
Making profits.
Making profits. And because their shareholder is a political entity called the state, they have developmental mandates. And this mandate can be expressed in a whole range of ways. You can ask them to declare a dividend to the state. I think Telkom does that, and at some stage Transnet used to do that, and some other SOEs. Or you could define a developmental mandate so that what they do, even though in terms of their developmental mandate, even though it doesn't emanate from the national fiscus, but contributes towards the aggregate government spend on development in the country. Now, different countries take different approaches. I think the problem in South Africa is that we've had an ad hoc approach in this regard. As I think I have indicated on several occasions, there is no overarching policy framework in South Africa which spells out the ownership responsibility, the shareholder responsibility, and spells out the commercial and non-commercial mandates, and the funding of non-commercial mandates. Because the biggest problem that SOEs face with non-commercial mandates is that they're not funded. And you expect SAA to fly routes, to be commercial, to generate revenue, and you expect it at the same time to implement transformation, to train black pilots, and do a number of other things, which the funding of which is not immediately available on their balance sheet, and you also expect them to fly certain routes. One of the biggest advantages up until a few years ago for SAA was its dominance of the African skies, its ability to fly to different routes in Africa. And the competition for SAA in that regard was Dubai Airways and increasing role being played by Kenya Airways and Ethiopian Airways. But SAA remained dominant, particularly on regional, including on regional routes in SADC. So, if you say to managers that run the airline or run the SOE commercially, yes, they will run it, but the developmental mandate will suffer. What I think countries like OECD countries are doing is to begin to insist, one, on the developmental mandate being clearly, one, they insist on a policy framework which clearly spells out the developmental mandates and the funding mechanism for such developmental mandates, so that the airline doesn't, or the SOE doesn't find itself conflicted as to whether to just operate commercially because you expect a dividend from it, or to also dabble into non-commercial developmental mandates and then accuse them of not being financially viable because they have to borrow money from the left hand in order to provide funding to the right hand. And that becomes the way that other countries have solved this. And I think countries like China and other countries which are member countries of OECD countries have done that. I think Namibia has also done that in its legislation, in its SOE legislation. What South Africa has to do is to also begin to move towards that direction, because it is unfair of us to expect that SOEs will be run only commercially when they are state-owned enterprises. But then the other problem, as I conclude, Chairperson, is that the shareholder governance model for our state-owned enterprises doesn't exist. The Department of Public Enterprises has tried to develop the shareholder governance model, but they have not been successful in concluding it and taking it to Parliament so that it's passed. Because in that way, you will address not only these issues of mandates and how decisions are made, you will address not only issues of governance and resolve the dilemma faced by the fact that there's a multiplicity of legislation which end up duplicating one another, but you will also deal with the issue of the centralization of the shareholder governance framework and the creation of a single shareholder governance framework for our SOEs, which will help them to operate far much better than they are doing or have been doing up until now.
Mr. Maverick.
Yes, thank you. If I could move to a different topic addressed by Ms. Carolus in her affidavit. That's the new age at page 828. She says at paragraph 55, with regard to the New Age newspaper, an initial approach was made to the SAA marketing department and processed through the normal procurement channels. It was finally turned down by the Bid Adjudication Committee, the BAC, because it did not meet the business criteria.
Excuse me.
828, this is of bundle 11.
Page
The same
828.
bundle.
828.
Oh, sure. Okay. And then-
So I think it's the page after
Yes.
the Botswana route. You want me to read that again?
You are
With
on
regard to the
paragraph
new-
55.
You're right? Okay.
Yes.
56, I was called by the then Director General, Mr. Matona, requesting an urgent meeting with me to discuss the matter. At that stage, I had no knowledge about the matter because this is a management matter and outside of the board remit. I indicated that it should be discussed with management, not the board. He informed me that there had been problems with management in this regard. I eventually agreed to meet with him. I got a briefing from Ms. Mzimela on the matter and took her along with me to the meeting because I considered it inappropriate and unnecessary for me to get involved in what was clearly a management decision. At paragraph 57, I was surprised to find Mr. Mklangu at the meeting because we were not discussing any legal agreements, nor was the minister present. I assured the meeting that within our legal and policy prescripts, SAA would be prepared to support a new entrant in the media space to encourage media diversity. But I asserted firmly that, especially as a public entity, we had to adhere to our procurement frameworks. We needed to be able to demonstrate the business case for our expenditure. I further asserted that this was a matter for management to process and not the board. Do you have any knowledge or comment about this?
I have no knowledge of this meeting, but I think it was important for Ms. Carolus to bring the CEO of the airline, and it was important that, especially when they were meeting with the DG of Public Enterprises, and it was important that she outlined that whatever decision they would need to take would have to be taken by management and adhere to their procurement frameworks.
So what is Mr. Mklangu now doing at this meeting?
I don't know.
And then you see at the foot of page 829, the last two lines, we used the media that had proven records of consumption by the targeted segments. It was not in our company's remit to fund the growth of a media entity through the SAA budget. The board did not see the need to discuss this further. Any comment on that?
You're on paragraph 58.
58, right at the bottom of page 829.
Oh yes, no, she's stating their
position.
their position, yes.
Yeah. All right, and then just one other thing on this affidavit. At paragraph 72, says 8 of 12 board directors resigned from the board on 27 September 2012 after a major deterioration in our relationship with Minister Malusi Gigaba. By then, various members of the board had at different times approached me indicating their desire to resign due to the deterioration of the relationship. Want to comment on that?
It was their opinion that the relationship had deteriorated. And I think it became, they justified it by arguing that I had on several occasions called them unpatriotic, which cannot be true. I had utmost respect for boards and would not have gone to call them unpatriotic. If I was reported as such, I think she does indicate that I assured her that I had been misrepresented.
And in a similar vein, in paragraph 74 at page 834, in the third line on the right-hand side, 8 of 12 members decided to resign in protest to the hostility from the minister and his team. You want to comment on that?
It was their opinion again, Chairperson. There was no hostility on my part. As Ms. Carolus continues to indicate, I continued to talk to engage her on various aspects that related to the board. There was no hostility on my part.
So what caused 2/3 of the board to resign on your understanding?
I had gone to cabinet to request rotation for the board. They were due for the AGM. They were due for an AGM, and they had not met the deadline for the submission of financial statements. We were in discussion on a recapitalization framework with National Treasury, which recapitalization framework was finalized just a few days during that time. Unfortunately, a day or two after they had resigned. Now, when I had gone to request their resignation, unfortunately, we were confronted with a leak. I think there were 2 leakages during the time, which compelled me to fly back from Cape Town to Johannesburg to come and deal with those leakages, and that was the SAA board was one of the boards which had experienced such leakages. I cannot recall now who, in terms of the rotation of the board, was being recommended for retention or for retirement. But we were suddenly confronted in the early morning with the resignation of 12 board members subsequent to the leak, and we had to act immediately to try and announce the appointment of the new board. I think we had to do that prior the AGM, the scheduled AGM, because of the unexpected sudden resignation of an existing board. In my opinion, I think they resigned because of the announcement of the leak that happened. It could very well be that they considered the leak as part of what they viewed as hostility. But I want to assure the chairperson, there was no hostility towards that board on my part. And the reason why I came down to try and talk to them was to apologize for the leak and to inform them that we would try to investigate where it had emanated from. But as we all know, leaks happen and it's very difficult to investigate where they emanate from, because the person who leaks information could have come from any angle. And unfortunately, at the time, we were dealing with a number of other leaks. Were not only relevant, not only pertaining to my portfolio, but to other portfolios as well.
All right, well, Ms. Carolus deals with that in her affidavit, the Business Day article at page 73, etc. But let me take you then to her conclusion, if I may, that you find at paragraph 79 at page 837. She says, in hindsight and given the evidence that has emerged in the Commission, it is clear that the board under my chairpersonship was placed under pressure to accede to the demand to abandon the Mumbai route in order to favour Jet Airways. It is also clear now that there was an attempt to favour the new age with SAA's business. Both Minister Gigaba and Mr. Mthlangu exerted pressure on the board and management in this regard. I have no doubt that the board at that time was seen as an obstacle to these attempts to influence its decisions. Indeed, the mass resignation on 27 September 2012 feels more like a constructive dismissal in order to pave the way for a more compliant board. Do you want to comment on that in conclusion?
Yes, thank you very much. It is quite an unfortunate conclusion by Ms. Carolus that she draws here, because throughout her affidavit, she points to no pressure being applied by me to any effect. She doesn't say that I applied pressure in favor of New Age. She doesn't say I applied pressure in favor of abandoning the Mumbai route, but she arrives at this conclusion purely based on hearsay, innuendo, and her own assumptions at the time. She says in her submission that when she had raised issues with me, I had attended to those issues promptly. She doesn't say that I had failed to meet with her when she requested to meet with me. And so I don't understand how and where she then arrives at this conclusion that we had tried to exert pressure on the board and management in favor of the New Age and abandoning the Mumbai route. It is important to note that the Mumbai route was eventually abandoned in 2015, that by Ms. Mzimela's submission, I had not discussed this at all with them since the meeting of April 2011, that I had not discussed with them the issue of the New Age, and the issue that she presents in a submission with regard to the board AGM, which could not take place because they had failed to comply with the submission date of the financials, because the auditors were concerned about the going concern status of SAA, is an issue which is in the regulations, and there was nothing that could be done about that. The mere fact that the recapitalization was provided to them, was provided to the airline after they had resigned, was mere coincidence, because that would have happened regardless of the fact that they had resigned or not. That recapitalization would have been provided, which would have paved the way for the going concern status to be addressed and the AGM to begin to be organized as scheduled.
I wanted just to take you to paragraph 68, please, just to go back. In the middle of 68, it says that the AGM was postponed on a number of times at the minister's behest. Do you accept that?
No, it's a lie. It's not true. The minister does not instruct the postponement of the AGM. The AGM is organized as scheduled. It never gets postponed at the behest of the minister. But the department, which would have been engaging with SAA, would have considered all the issues placed before them, including the fact that SAA had not complied with the submission schedule for the annual financial statements, because the auditors were concerned about the going concern status, since SAA was still awaiting recapitalization as requested from National Treasury. So it was not me that decided that no, postpone the AGM. You couldn't hold an AGM when the going concern status was not finalized.
Well, as you say that you would not instruct an AGM to be postponed, it occurs to my mind that I have had evidence in the context of the Eskom workstream by Mr. Tsotsi, who was chairperson of the Eskom board at a certain stage, as well as by, I think, somebody who was deputy DG of the Department of Public Enterprises in early 2015, or was acting DG at the time. I don't know if it was Ms. Mkobo, who, both of whom said they received calls from the then President Zuma giving instructions that a meeting of the board of Eskom that was scheduled for the 26th of February 2015 should be postponed. So I'm just saying, as you say, you would not give that instruction. I just remember that there is this evidence that has been had in a different context. You don't have to say anything. I just mentioned that it crossed my mind that there was evidence that indicated that the president called to say that board meeting must be postponed. Of course, he has not said anything whether that's true or not, but there are two witnesses who have said he phoned. So, yeah, I'm not saying that I'm doubting your evidence. I'm just saying there is that evidence that I've had.
And in this instance, Chairperson, I wouldn't know whether it was a board AGM or it was a board meeting.
Yeah.
Board meeting you can postpone.
Yeah.
And you know, my understanding up until now, and I will remain with what I understand, was that even a board AGM, I would not call for its postponement. There would be instances when a board requests me to attend a meeting because there are issues they want to raise with me. There are instances when I would request to attend a scheduled board meeting or convene a special board meeting, in which case, as I've explained earlier, a special board meeting would be convened, an agenda circulated, but an AGM does not get postponed or rescheduled by the minister, because there are legal requirements for an AGM to take place during the time when it is scheduled. The only time it does not take place by that time is when there are financial issues concerned or other matters of such a nature that the department would say, on this basis, we suggest that the AGM be postponed. I think I've made an example of SAA that this was not the first or the last time that SAA's AGM was rescheduled. There was another instance, I think, between 2014 and 2015, I can't remember, when an AGM took close to 2 years to actually take place because of the financial position of the airline.
Well, you said a board meeting you can postpone. Do you mean a minister can postpone a board meeting?
No.
Okay.
No.
You didn't mean to say that? Because
No,
that's what
I
you said.
didn't mean to say the minister can. As I
okay.
said, Chairperson,
Yeah.
that's why I immediately indicated that you can be invited
Yeah.
to a board meeting, you can call a special board meeting, or you can request to attend
Yeah.
a scheduled board meeting.
Yes.
But you yourself can't postpone
Yeah,
it.
you can make a request if it was a meeting you were going to attend, I guess, to say, can we postpone it because of ABCD, if you were going to attend.
Yes.
But you can't just phone and say a board meeting that you were not going to attend to say it must be postponed, as
No,
far
you-
as you know.
As far as I know,
Yeah.
Chairperson. Thank you.
Okay. Mr. Maipek?
Yes, thank you. Just to expand upon that a little, at paragraph 69, at page 832, it says, by then there were growing concerns by a number of members of the board about what they felt was outright hostility and or carelessness from our shareholder because they felt he was dragging his feet with the processes to secure the going concern status for SAA. You want to comment on that?
Chairperson, the Minister of Public Enterprises does not sit with a slash of funds that they can avail to any SOE on the basis of it either failing to comply with going concern status or requiring recapitalization. The decision on recapitalization and bailing out an entity rests solely with National Treasury, which would look at how and where it would have to find funds to address such issues. The Minister of Public Enterprises does not sit in their office with such funds. And so the statement that the minister was dragging, the shareholder was dragging their feet with regard to addressing the going concern status of SAA is disingenuous. And the former chairperson of SAA knows it very well as someone who is also quite experienced in serving on boards.
Could I ask you then to have a look at paragraph 71 at page 833? Upon inquiry from myself on 25 September, the minister expressed his utter dismay that his department officials had not dispatched the guarantee letter to SAA yet. He assured me that it was approved by National Treasury and that he would ensure it reached us by the next day. It did not arrive on 26 September 2012. Comment on that?
Chairperson, my assurance that the letter would reach them by the next day was dependent on a number of factors. One of those is the dispatch. The minister, Chairperson, we must not create this sense that ministers are people who write letters, convene meetings, dispatch letters, sit with stashes of money that they can dispatch to SOEs. You have officials that you talk to, and the letter to SAA would have to be dispatched by the department, not by the minister or the minister's office. Ms. Carolus knows this. She knows it very well. But she chooses to apportion the blame to the minister because it is convenient and suitable for her to do so in this regard. But in reality, the procedure that is followed, I would talk to the DG and say, DG, the letter to SAA, why is it delayed? Can you dispatch it? Because I would have received the letter from National Treasury assuring us that the recap framework, the recapitalization framework is approved and the figure attendant thereof. And so the DG would have to initiate the processes from the department to ensure that the letter arrived at them. This letter would have been received by the board of SAA even if they had not resigned. The fact that they chose to resign prior to them receiving the letter is their own fault, it's their own mistake. It has nothing to do with the fact that the letter in actual fact was ultimately received, and that is why the AGM of SAA eventually took place on the date that it did, even though it was now after the date that had been scheduled for it to take place.
Mr. Gigaba, perhaps I can just get your crisp answer. 71, upon inquiry from myself on 25 September, the Minister expressed his utter dismay that his department officials had not dispatched the guarantee letter to SAA yet. Did you express such dismay?
Probably I would have.
Right. He assured me that it was approved by National Treasury and that he would ensure it reached us by the next day. Did you give those assurances?
The assurance was dependent upon the department acting on the dispatch of the letter. Chairperson, I wish to repeat, the ministers do not dispatch letters. They are not their
Yes,
own.
but remember, Mr. Mybeck is simply asking whether you gave that assurance.
Yes,
Whether it was complied with or implemented may be another matter.
the crisp answer is that yes, the assurance probably was given. The events are of 2011, and I didn't keep records of them. And however, it was dependent upon certain things happening, because as the minister, I was not my own dispatch facility.
And then the last sentence, I take it you agree with, it did not arrive on 26 September 2012.
It probably did not. I wouldn't be sure of that. I'm sure we would have to look at the records which are available both at DPE and at SAA.
And then if we go to page 834 and paragraph 74, the fourth line, I've already read to you, 8 of 12 members decided to resign in protest to the hostility from the minister and his team, did not want to face the prospect of being delinquent directors. This, says Ms. Carolus, was reinforced when the letter of guarantee was subsequently sent to SAA by the close of business the next day.
Chairperson, this was simply coincidental. Even if they had not resigned on the 25th, the letter would have arrived on the 26th. The fact that they chose to resign on the 25th would not have prevented the letter arriving on the 26th. And so the fact, its arrival on the 26th had nothing to do with their resignation. It means that the dispatch service was such that it would arrive on the 26th, because Ms. Carolus herself says that she says that they resigned when she said they resigned on the 27th, and the letter arrived on the 28th, the following day. Which and she had spoken to me on the 25th. Now, you know, I would really understand if you're talking about weeks that passed or months, but you're talking about a gap of 3 days, just 3 days. You talk on the 25th and you say the letter would arrive the following day. The board resigns on the 27th. The letter arrives on the 28th. Just 3 days. Only 3.
All right, and then just before we finish off completely on the question of the Mumbai route, could I ask you, please, to turn to bundle 8, back to bundle 8, and to go to page 58.
Yes, I'm there.
And please would you have a look at paragraph 24. Said,
this, oh yes, yes.
Paragraph 24, page 58.
Yes,
I had also indicated that there was no anomaly in me meeting with Jet Airways. In this regard, the Articles of Association applied during my tenure. Paragraph 22.4.2, this is of the Articles of Association, states that SAA would not, without the consent of the Minister, exit from routes and airports, save for instances where the use of diversion airports is required. In order for me to give consent to the termination of the Mumbai route, presumably, I needed to satisfy myself that such would be in the interest of SAA. Do you confirm that?
yes,
And then if you go to page 72, you'll find the Articles of Association and that particular paragraph. Sorry, it's page 93. You'll see there at 93, 22.4, subject to the significance and materiality framework applicable from time to time, the company shall not, without prior approval of the Minister, and then sub 2, commence or exit from routes. You see that? Mr. Gigaba?
I can see 22.4.
22.4,
Yes, okay,
which commence or exit
yeah.
from routes
Yes.
and airports, save for
Yes.
instances where the use
Yes,
of diversion airports is required.
yes,
Of course, SAA didn't want to exit the Mumbai route. Jet Airways wanted it to exit the Mumbai route.
yes.
All right. Could I then take you, please,
No,
back?
but it's important, Chairperson. Remember, SAA is not an entity which existed only in 2010 or 2011. Remember that the acting CE, Mr. Smythe, is alleged to have agreed to the exit on the route, which application had not been submitted to ministers. And Mr. Daga says that the board had not agreed with that. And so the new CEO of SAA came in and stated clearly that they were not going to exit the route. And therefore, sitting before me or serving before me was no application for SAA to exit the route.
All right. Could I ask you then, please, to go back to file 11 and let's deal further with this new age issue. Could I ask you, please, to turn to
Is
tab
that a different bundle, the previous one?
I think you still have 8 and 11, but it is different. To 8, it's going to 11. That's bundle 8 you have in front of you, Chair.
Yes, okay, that's the one you are going to,
I'm going to 11.
going to 11. Okay, I sent it away.
Yes, you can. I'm sorry. So tab 12, please. And if you can turn to page 781. So a statement by Mr. Mafika Mkonazi.
So page what?
781,
Okay,
tab 12.
yes.
Okay, continue.
He says, meeting the Guptas. After I was appointed as chairman, now that would have been chairman of Transnet, in December 2010, I received a call in January 2011 from
Did you say
Tony
781?
781,
Okay, yes,
bundle 11,
yes, okay,
under the heading chairperson, meeting the Guptas.
yeah,
After I was appointed as chairman in December, are you there, Mr. Gigaba?
Yes, 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 I'm there, I'm there.
In December 2010, I received a call in January 2011 from Mr. Tony Gupta, and he informed me that he got my contact details from Minister Gigaba and requested me to meet. What do you have to say to that?
I think I responded to this in my affidavit and said I did no such.
And then, so you said that you didn't provide him.
No. I did not provide Mr. Tony Gupta with details of Mr. Mkwanazi.
But you knew Mr. Mkwanazi's contact details, presumably.
Yeah, but that doesn't mean that I provide it to everyone.
All right, and have you any idea then where Mr. Tony Gupta got Mr. Mkwanazi's contact details from?
Oof, they had extensive contacts and connections, Mr. Chairman. I don't know where he would have got Mr. Mkwanazi's contact details. And certainly one of the things that, you know, I had said repeatedly concerned me was about this name dropping. I was not aware that this meeting had taken place and had Mr. Mkwanazi, I said this in my affidavit, that had Mr. Mkwanazi called me immediately to say that this has happened, I got this call, this person says they got my number from you, I honestly would have said to him, please don't go to such a meeting. And I would have clarified it to him that I had not given Mr. Gupta his number.
Mr. Maibek, remind me, is the position that Mr. Kona made a similar allegation, namely that he was phoned by Tony Gupta for a meeting, and Mr. Tony Gupta said he got his number from Mr. Kikaba?
I'm not sure, offhand,
Okay, all
Chairperson.
right. Maybe I'm confusing. Maybe it's only one instance. This
To
one.
my knowledge, Chairperson, it's only Mr. Mkwanazi.
Only this one. Oh, okay, all right. Yes, continue.
Who's this from? Chairperson, I understand that Mr. Solomon has been experiencing difficulties with the internet connection.
Oh,
We've received if I understand it correctly, my colleague's phone now goes into a blank screen.
yeah.
I'll read to you what the message says. So, Mr. Solomons Jr. has sent a message which says, the chair should please be informed, it says, if the connection is not working. Our client is unrepresented when we're able to hear and interact with the commission. I don't know if Mr. Solomon...
Mr. Solomon, are you there? The screen shows IT, so I guess there must be some problem. Okay, can you hear me?
Yes, Chair, we can. There have been intermittent interruptions.
Yes.
All we're requesting is when that happens, that the chair is advised of those interruptions, so that if needs be, we just adjourn till the connection is restored. But at the moment we can hear, so it's just raising something that had occurred a few times in the past.
Yes, no, that's fine. of course, you know, this technology is good most of the time, but sometimes it lets us down. So
Yeah.
with the interruptions, I think that when we next meet, you should try your best to be here in person so that it doesn't interfere too much. When everything goes smoothly, it's fine, there's no problem. It's just that sometimes these interruptions can end up causing quite some delays. So let's continue today, but I know that you still need to cross-examine, I think, Ms. Mngoma, and I don't know whether with regard to Ms. Mzimela, I think your last position was that probably you would want to cross-examine her. I think that if at all possible, maybe you could make an effort to be here in person so that we avoid the risk.
Certainly, Chair, we'll bear that in mind, but we're prepared to live with the moderate interruptions.
Yes, it's just that when they lead to delays, that's the only problem.
Sure.
Yeah. Okay, all right, let's continue. Thank you.
Thank you.
Thank you.
So as I understand it, what you're suggesting is that Mr. Tony Gupta was effectively name dropping here. Is that what you say?
I think here he was name dropping, Chair,
All right.
because I had not provided him Mr. Mkhona's contact details, neither did I know about this meeting.
So let's just
And I know we have touched on this point, and I seek to do nothing more than just draw some connection with it. To the extent that he may have been name dropping here, that might support the proposition that for him, the presence of your advisor in the meetings that he was having with the CEOs might have served a similar purpose. When he name drops, when he drops your name, I got the number from the minister, your number from the minister. It's like sending the message that one, the minister and I are close, or two, the minister actually wanted us to talk, wanted us to meet, wanted me to talk to you, you know. Now, when he brings the minister's advisor to a meeting, it may be another way of saying, you know, this meeting has got the blessing of the minister. And if he says certain things there, you know, and maybe the minister's advisor doesn't object, it might create the impression that, you know, this person or the minister has no objection. But we've talked about it. I'm just, you know, saying there may be some connection with this name dropping, the attitude, and wanting the minister's advisor to be present at meetings where, on the face of it, the minister's advisor shouldn't be there.
Yes.
You might not be able to say anything. I'm just sharing with you what's going on in my mind when you say this was name dropping. Yes. Yeah. Okay. Mr. Mybeck.
Yes, thank you. I just want to take you through this page. It's not very long. I obliged, says Mr. Mutlangu, and on arrival I handed my keys over to the valet who proceeded to park my vehicle. There's a particular manner in which they welcome you in the house. You take off your shoes, turn left, walk along corridor, whereupon I was met by Duduzani Zuma and a gentleman who introduced himself as Tony Gupta. At the start of the meeting, we discussed what each of us were doing in the economy. Tony Gupta proceeded to introduce himself as a friend of the Zumas, that they own Sahara Computers, they employ over 10,000 people in their operations. I shared that I was looking into a potential property development in KwaZulu-Natal that would cost above R1 billion. References made to Mail and Guardian newspapers relate to this conversation. And then he says, he then explained that he's aware now, that's Mr. Tony Gupta, that he's aware that Transnet has a marketing budget of 1 billion and that they want 30% to 50% of the billion rand budget allocated to the New Age newspaper. I told him that he was talking to the wrong person, as the chair of the board is not involved in procurement processes. The practicalities of how this would be achieved were not explained to me, nor did I bother to inquire. I advised him to follow the established Transnet procurement procedures. Duduzani said nothing the entire time. So this is something that Ms. Carolus has also given evidence about, the marketing budget, New Age budget. Do you have any comment on this?
Chairperson, again, I was not aware of this meeting, and I think consistent with the response I've provided before, that had I been alerted to this, I would have indicated to Mr. Mkwanas that I did not provide the details. Please don't go to the meeting. And I didn't even know that Transnet had a marketing budget of 1 billion rand. So this was improper, and I think Mr. Mkwanas was correct to say that they need to follow the procurement processes of the department. I mean, of Transnet.
Well, there is something that when one reads what Mr. Mkwanas says, Mr. Tony Gupta said here in the third paragraph on page 781, one is reminded of Mr. Themba Basugu's evidence about his meeting with Mr. Ajay Gupta in 2010, I think October or thereabout, where he said, Mr. Ajay Gupta said to him, I know that GCIS has got, I think, 600 million budget. We want all of it, or something like that. So here, it's not all of it, but we want 30% to 50% of it. That's something you can't say anything about, but I'm just saying the evidence of two different witnesses here talking about different members of the Gupta family making similar demands to different people at different times. Mr. Mypack?
Yes, thank you. And then he says in the second last paragraph, I was contacted for a second meeting, and I then requested Advocate Bonga Mahlangu, who was the special advisor to Minister Gigaba, to accompany me. My reasoning was that I needed a witness, and if there was any substance in their allegations with regard to relations with members of Parliament, Advocate Mahlangu would be in a position to relay my position on this strange arrangement with the Minister. Tony reiterated the proposition he had made in the initial meeting in the presence of Duduzani and Advocate Mahlangu. I gave them the same feedback, that as chairman I was not involved in day-to-day procurement issues at Transnet. I then made it clear that I didn't have any interest in seeing them again. You got any further comment on that?
Yeah, Chairperson, I think, as I said in my response on paragraph 7.6, page 788, I was also not aware that Mr. Mahlangu had been invited to this meeting as a witness. And it is my view that Mr. Mkwanas was correct to insist that day-to-day procurement processes must be followed. And it was correct of him to say he had no further interest in seeing them again, because I think this was just improper.
So can you think of any reason why Mr. Mahlangu wouldn't have informed you of this meeting?
I don't exactly know. I don't exactly remember why he would not have informed me.
Would you have expected him to?
Of course, both of them should have informed me.
Did you know anything about the Guptas' attempt to try and secure the placement of business with the New Age newspaper?
I heard about it. I don't exactly recall when, but I heard that they were trying to talk to various entities, various people, various departments to subscribe to the New Age breakfast. But it's not something which was brought to my attention or brought to me to deal with.
Now, this relates to Transnet. I think what I perhaps omitted to ask you.
No, related to Transnet, Chairperson, no.
Okay. But Mr. Mtlangu's evidence, what I was meaning, relates to Transnet. I think I perhaps omitted to ask you, in relation to what Ms. Carolus had to say about SAA, did you ever come to learn about that meeting between Carolus, Mzimela, the DG, and Mr. Mtlangu?
No.
Could I then take you, please, to another affidavit in a related issue? That's at Divider 11, Mr. Pretorius.
Which one is it?
The same file.
Okay.
File 11, Divider 11, I think.
Oh.
Tab 11, right in the front, Mr. Gigaba. And the affidavit itself commences at page 7.
Yes, I'm on it.
Now, perhaps I could, this is an affidavit of a Mr. Pretorius.
Yes.
And he was employed by Eskom as Acting General Manager, Strategic Marketing and Branding.
Yes.
If I could take you perhaps directly to paragraph 35.
Yes, I'm on it.
Did you say page or paragraph 35?
Page 16, paragraph 35.
Oh. Continue.
Says at paragraph 35, I could see no real benefit to Eskom in the business breakfasts. I told Mr. Shaw that in my view, the TNA proposal was not cost effective compared to other options in the marketing mix, and that we had in any event not received a formal proposal. My view was that it made no marketing sense either to sponsor the TNA big business breakfasts or to advertise in the TNA newspapers, particularly because the newspaper did not have audited circulation figures, an issue which I address below. I was also of the view that the cost was too much in comparison with similar offerings. I can then take you, please, to paragraph 36. When I raised these concerns with Mr. Shaw, now he was the Divisional Executive Corporate Affairs, he told me that the instruction to conclude the contract with TNA had come to him directly from Brian Damus, the then Eskom CEO, and the Minister of Public Enterprises, Mr. Malusi Gigaba. You want to comment on that?
I think Mr. Cheu already has commented, and both Mr. Damis and Mr. Cheu have already commented on this. It's nonsense.
Right, well, what is your comment?
My comment is similar to theirs, that this is not true.
At 37, I also told Mr. Shaw that it would be necessary for the proposal because it was a sponsorship to be taken to the sponsorship committee for approval. However, Mr. Shaw told me that the contract needed to be concluded quickly because Mr. Gigaba had already been secured for the first business breakfast on 12 April. It was therefore decided that we should ask the media shop to do the negotiation and procurement of the media. Got any comment on that?
I don't know about the sponsorship processes of Eskom. Mr. Shweu had already said, and I think in an affidavit submitted before this commission, that Mr. Pretorius was not telling the truth in this regard. I gave no such instruction, and in the event that they sponsored a business breakfast program, because I was going to be speaking on it, it's something that they would have done internally without informing me. It's important to state that you know, the business breakfast programs were broadcast live on SABC, which had a very large viewership, and that they were attended by business people from different angles, and they addressed a number of issues, not only pertaining to SOE.
Sorry, I beg your pardon, DCJ. I've just been given a message from the technical people to say that the signal has dropped, and if we could please have a 5-minute break in order to see if it can be restored.
Yeah, it's really giving us problems. No. And then we'll adjourn for 7 minutes, we come back, it's working, and then at 10 minutes, it's not working. Is it fine now? Okay, let's continue. I think I must complain more, it comes back if I complain. All right.
Sorry, Mr. Kikaba, and I interrupted your train of thought. Please feel free to recommence your answer if you would like.
Yes, thank you, Chair. I was saying that insofar as securing sponsorships on the basis that I was going to be addressing, I was not aware of internal processes that took place in that regard. Mr. Chweu had indicated in an affidavit submitted before the commission that I had given no such instruction, and I want to reiterate that. And thirdly, that these business breakfast programs, insofar as they were covered, because the coverage on the New Age newspaper would only follow the live coverage on SABC, which had and probably still has the widest coverage in terms of viewership, and were attended by business people from different angles. And so they would go they would reach out to a large spectrum of people, but that is as far as I got involved in participating in some of the programs, because then the sponsorship issues had nothing to do with me.
All right, could I then please ask you to turn to bundle 8? You can put away that file, Chairperson. And bundle 8, could I ask you please to turn to the affidavit of Mr. Totsi. Totsi at page 760, that's under tab 3. Are you there?
Yes.
paragraph 4.1 at page 761, he says that I was appointed to the Board of Directors of Eskom Holdings, Pty Limited, in July 2011. At the time of the said appointment, Mr. Malusi Gigaba was the Minister of Public Enterprises. I take it you agree with that?
Yes.
I want to then take you, please, to paragraph 6.1. He says that the ANC had its usual fundraising gala dinner on the eve of 8 January, the eve of the 8 January 8 rally in Nelspruit in 2014. Eskom and the SABC were two of the main sponsors, and so the chairpersons of these SOEs were afforded not only the opportunity to address the gathering, but also offered seats at the high table, which consisted of the ANC top six and two of the older Gupta brothers. The table had name tags so that those who did not know one another were able to introduce themselves. This was the first and only encounter I had with these Gupta brothers. I've never got to see or talk to them thereafter. Did you attend this gala dinner?
Yes, I've attended all gala dinners of the ANC January 8th statements, except the one in 2019. Oh no, I think it's 2020.
Then he says at 6.2, I was requested by Tony Gupta to meet him at their Saxonwold residence on some 3 occasions, and once at their Sahara Computers offices in Midrand. He goes on to say that Tony Gupta generally asked me for assistance on matters they were experiencing some problem with Eskom on, as well in situations where they could advance their business interests. Do you have any comment on that?
No.
Now, what I'd like to lead you on, if I may, can perhaps most conveniently be done by me taking you to the relevant extract of Mr. Totsi's evidence, which you find at page 808. Now, just to refresh your memory, Mr. Gigaba, this relates, or the key part of his evidence, insofar as it relates to you, was or concerns the appointment of Colin Majila over a Mr. Stephen Lennon as the acting CEO. And if I could ask you to have a look at page 808, he says in the quote, referring now to his affidavit, "For the most part, my tenure in the board was very smooth until towards the end of the first board term, when Colin Machila was appointed as chief executive from about April 2014. And then goes on to say, quoting another paragraph of his affidavit, 2.3, the instability set in when a whistleblower alleged to the Eskom board through the Audit and Risk Committee that Mr. Machila had not followed correct procedures as prescribed by the delegation authority in awarding the renewal of the TNA media contract. So he was appointed as the acting CEO, and then there was this controversy around the TNA media contract. But he's then asked, can you tell us a bit about Mr. Machila's appointment? How did it occur? In line 22, he says, what happened was that when Brian Damas, who was the substantive chief executive at the time, was going to leave the company, the board then decided on 2 issues. rather took a view on two issues. Let me say, and the view the board took was that first of all, we should not have any of the board members acting as chief executive. And then if you can drop down 5 lines, the right-hand side, the other matter that the board took a view on, in fact, on this one, it was really a decision. And the decision was that the board would ask one of the executives to avail themselves to act in that period. The individual that we asked was a gentleman named Steve Lennon. If I could ask you please to go to page 810. It's over the page. The second line on the right-hand side. The board then instructed me to get the minister's consensus on this matter, as would be the case. And I met with the minister, and the minister was quite content and happy that Steve Lennon should act. Then he's asked who was the minister at the time, and he says it was Minister Gigaba. Chairperson says okay, and then he continues at 10. Yes, this was, I think, around December 2013. Then if you go to page 811, the third line, Dr. Lennon did agree. Chairperson, okay. Tsotsi. And I told him, of course, that the minister had consented to this. And if you drop down, please, to line 19, just before Mr. Damas left, now we know that's in March 2014, I got a call from Minister Gigaba, and he was quite irate. And this was an experience I'd never had with him before, and I was extremely taken aback, and his manner was very surprising. But I managed to calm him down and to have a proper conversation with him. And this was the time when we were about to go to the local government elections in 2014. He was lambasting me or rather for the board to have requested a white man to act, when in fact we were facing, and the ANC was facing an election, a local government election, and this would prejudice. And then at line 10, the chairperson says 2014, I think it was a general election, to which he agrees. And then at line 22, certainly over the phone, and I made it clear to him that I thought that this was not him speaking, that someone had put him up to this. And then he said, I could take you please to page 813, at line 6, witness continues, and I said, this is not you, this is certainly not you, as far as I know you. Someone has put you up to this. So let us just not get into this. If you wish to have a conversation, let us have a conversation. And then the third last line from the foot of the page, he then asked me to inform the board that he would like Colin Majila to act. So I went back to the board. And then over the page at 814, the third line, no, that was a subsequent conversation. And then at line 7, and so I went back to the board, and I informed the board, was unhappy, because flew in the face of a decision that we had made, and none of us as board members should be eligible to act in the position of chief executive. And of course, Mr. Machila was a board member at the time. And then at line 19, second last line from the foot of that page, did you ever say to him, but I consulted you on the board's contemplation to approach Mr. Lennon to be the acting chief executive officer, and you gave me your blessing. What has changed now? What is wrong? And he answers, I certainly did. I do not recall whether it was during the conversation or afterwards, but I certainly made the point to him, just to remind him that we had the conversation, and he gave his consent to Dr. Lennon acting, and I obviously was perplexed as to why this change of mind. Chairperson asks, did he give you an explanation what has changed? What had caused him to change his mind? Witness says, no, he did not give me an explanation. And then just a few other lines. Again, the second last line. He says, it was very embarrassing, and I felt in a way, I thought there was a sense of guilt or whatever, but I did go back to Steve and could not, in all good conscience, say to him what Gigaba told me. And at paragraph 11, already in the industry, the word was out that he was going to be acting. And at line 19, to that extent, Chair, Steve decided that as a result of that, he could no longer serving at Eskom. He felt that, his integrity was somehow affronted by all of this, and then requested to retire at the time. So it was a very unhappy ending for him. So that's the full version of Mr. Tsotsi. You want to comment on that?
Thank you, Chairperson. In the first instance, the appointment of CEO and acting CEO was the discretion of the minister. The board had no business interfering in that, because even in terms of especially making a recommendation on an acting CE, I had given them 3 months within which to appoint a new CE. And I was gonna appoint an acting CE, and I had said to them within 3 months they needed to have completed the process of appointing a new CE. And 3 months doesn't mean, or did not mean, the new CE must be appointed and be in office. It meant the process. Within 3 months, you need to submit a recommendation as to who will become the next CE, and then I take that name to cabinet. Now, it's quite crucial to note that Mr. Tsotsi, and he says I had a good working relationship with them, and I did. It's quite crucial to note that he forgot something quite important, as significant as a general election, and confuses a general election with a local government election. It's not trivial, because it speaks to the grasp of issues that are sitting in front of you. I mean, a general election is a general election. There will be a new president, not a mayor. There will be a new administration, not continuation, and so on. So it must be borne in mind. When he briefed me, it's not true that I consented. I said, I need to apply my mind. I need to apply my mind and see if I agree with what you are suggesting. And after applying my mind, I had a view that no, appoint Colin, because, it could very well happen that someone who says, I am not interested in being the CE, might, upon tasting the position, take a view that I now want to apply. They've already acted, you've created an expectation. What do you do? How do you remove the expectation? There was no angry outburst on my part. I'm not disposed towards angry outbursts, especially with adults. Mr. Tsotsi is a senior to me by far. I have the utmost respect for that, and I would not just burst out at him, not under any circumstances, no matter how angry I am. And he had not upset me in any possible way. And I've always taken a view that being a minister does not mean that I have a right to just burst out at people and talk to them anyhow. So I did not speak to him in the manner that he suggests, and he suggests elaborately at this angry outburst to a point where he said to me, "This is not you." Chairperson, I don't drink alcohol.
Well, well, I wanted to say that precisely was his point, but he didn't refer to alcohol. He said when he was giving evidence, if I recall correctly, he said, "I had known Minister Kigaba for a long time, from the time when he was leader of the ANC Youth League. I had a good relationship with him. We were working very well. But on this particular day, the way he spoke, it was uncharacteristic of him. Precisely what you are saying in a way, because you are also saying, I wouldn't talk to him like that. And I think you may be saying, I wouldn't talk to anybody like that. Maybe you wouldn't,
Yes.
you are not given to bursting out. So he said, I've known him for a long time. We had a good relationship. And I think he said, also as chairperson of the board, and you being the minister, you had worked very well. But this was just something that happened that he could not understand himself, you know, which is, I think, why he said, this is not you. You know.
Yes, Chairperson. And as I was saying, Chairperson, I don't drink alcohol, I don't smoke drugs, I don't have mood swings. I maintain the same posture and demeanor in my engagements, no matter how robust they may be. And so there was no possible way, there isn't, that I would have burst out and spoken to him in a manner which would make him to say to me, no, wait a minute, this is not you that I'm talking to. It's not possible. It never happened. When I called him and had a discussion with him, I said, look, I'm of a different view. I've applied my mind, I'm of a different view. I believe, on the one hand, that we need to stick to the path of transformation. And here you're talking about someone who is going to act for 3 months, it could be 4, it could be 5, until the new CE is ready to assume office. Let's stick to the path of transformation. Let's appoint Mr. Machila. He possesses the requisite skills to act in this position. But secondly, that the board thinks somebody in management might not, upon tasting the position, want to occupy it permanently. My view is, it's possible that they may. Having tasted the position, they may then apply and consider themselves to be front runners by acting and expect that we have created a reasonable expectation that they should occupy the position. And so my suggestion is that allow Mr. Machila to act, prevail on the board to understand this, and appoint the new CE timeously within the time limit I've given you. And this time limit, Chairperson, was also not random on my part. It's a time limit I had given SOEs back, I think, in 2011. I think in one of my previous submissions here, I indicated that I had told SOEs that if there's a vacancy arising, try to fill it up within 3 months, so that we don't sit with vacancies prolonged for too long. And that's what we discussed. I did not have an outburst with him. And I certainly, I did not know that I would be leaving after May 2014, but I expected that regardless of what would happen, they would comply with the time limit I had given them, and there would be a new CE in office in 4 to 5 months, they would be able to move on in that regard.
So is the position that you agree that he did suggest the name of Dr. Lennon or Mr. Lennon, I'm not sure which is the right title for him, or that he did say the board was considering having him appointed as an acting group CEO, but what you disagree with is that one, you said that's fine, and you disagree that you came back to him and you were angry and you changed. What you are saying is, yes, they did suggest or say or give Mr. Lennon's name. I said I wanted to apply my mind. I went away, applied my mind. I came back to him. I spoke to him in a normal way. I said we should continue with transformation and that Mr. Majila should be appointed. Is that a correct summary of what you say?
Yes, Chair.
Mr. Maida?
Have you got any sense then where Mr. Tutsi gets this story from?
I don't know where he gets the story from, because even after I had left Public Enterprises, I continued having a good relationship with them. Whenever we would meet, we would have cordial conversations.
And what about the fact that the board had decided that none of its members should act as the CEO in the intervening period?
The discretion lay with the minister, Chairperson. The discretion was the minister's discretion. And what the board sought to avoid in appointing an executive manager, director at Eskom, who in their opinion might have not wanted to apply for the position. Everybody knows, everybody knew that Dr. Lennon had ambition to be CEO of Eskom. Everybody knew that at the time. Don't know, Chairperson.
Well, I wanted you to finish before I ask you. Yeah.
Okay, thanks. Everybody knew he had ambition to be CEO of Eskom. I did not want to prejudice him by placing him in a position where he will now be said to be unavailable. He was certainly one of the most experienced executive directors at Eskom at the time. And I was of the view that it is possible that you might act in a position and upon acting, you then taste the position and you now want to apply. And then you are told that no, you can't apply because the condition for your appointment as an acting CE was that you are not going to be available. And then you could have long, protracted legal wrangles with somebody challenging the fact that there is no legal prescript preventing them from having to act and still apply to occupy the position permanently. That the board had no right to prevent anybody from applying for the position. And so it really was my discretion, and it's how I applied my mind and thought about the matters.
Mr. Maida?
I just wanted to ask you one other thing, and that is, I mean, isn't Ms. Tutsi's version borne out by the fact that he seems to have told Mr. Lennon that he was going to act, and that when he then had to go back and tell him that you had changed your mind, Mr. Lennon then resigned? Doesn't that sequence of events bear out Mr. Tutsi's version that you must have changed your mind?
No, what it bears out is that he had difficulty going back to Mr. Lennon because he had no right to assume my powers and go talk to Mr. Lennon and say to him, the minister has agreed when the minister had said they are applying their mind on the issue. Industry, word going out to the industry prior to my consent and announcement, because I would need to inform the board as the shareholder representative. That was an anomaly. And I think we must not take away the powers of the minister and allow the usurpation of those powers on the basis that people might have been informed that they are to act in positions. The power of the minister to take that decision must still vest with the minister, because in the end, as the shareholder representative, even though the appointment of acting CEs is not going to go to cabinet, doesn't go to cabinet, but the minister must still exercise that discretion to take that decision and then inform the board. The board shouldn't have gone out to inform anyone, including the industry, as to who was going to act when they had not received the final word from me.
But of course, Mr. Totsi's version is that you had agreed and you then changed your mind.
Of
But
course,
you take issue with that, I understand.
of course, my version is I had not agreed. I had said I'm going to apply my mind. And applying your mind must never ever be presumed to mean consent.
So how long did Mr. Machila act for?
I don't exactly know, because he was appointed, I think, was it in April 2014?
I think March, April, yeah.
Yeah. Then 1 month or 2 months later, I was appointed Minister of Public Enterprises and I left. Of Home Affairs. Thank you, Chair.
So do you
Well,
know, sorry,
Well, Mr. Matona was appointed with effect from, as Group Executive of Eskom, with effect from, I think, 1 October 2014, if not 1 November, but I think October. So I suspect that Mr. Machila must have acted until Mr. Matona assumed duty.
Yes, which would be slightly surprising, Chairperson, because to my understanding, by the time the general elections took place, the board had completed the recruitment process. I think what could have delayed the actual appointment was the appointment of a new minister.
It's the change of
The
ministers.
change of
Yeah.
ministers, which then
Yeah.
created the timeline.
Yeah, because I think he was the immediate acting group CEO before Mr. Matona assumed duties. Yeah. Mr. Maipek.
thank you. I just want to deal with a few isolated issues. Could I ask you please to go to bundle 7? And if you could please turn up page 996.101.
You are in a rush. 7A.
7A, yes.
Nine 996.
101.
I'm there.
So you would have seen this affidavit from Joanna Rousseau, Miss Rousseau.
Yes.
She says she's a bursar at a primary school, and
Chair, sorry, if I could just come in here.
Yeah.
I object to Mr. Myburgh dealing with this statement on 2 bases. One, we didn't receive a 3.3 notice in respect of Ms. Rousseau. But secondly, and more fundamentally, he has been very specific about which witnesses he's going to traverse with Mr. Gigaba, and Mrs. Rousseau is not one of them. So he's had no opportunity to deal with her evidence at all, and on the contrary, he would be taken by surprise in having to deal with her evidence when Mr. Myburgh specifically excluded her from the list of witnesses that Mr. Gigaba was expected to deal with.
Mr. Myburgh?
Mr. Chairperson, I mean, Mr. Gigaba, as we can see, is going to have to come back on another occasion. I have no difficulty to leave the matter over until then.
Well, what I want us to consider is whether you can't identify the areas where you were going to have questions on for him.
Yes.
And put questions to him in writing, and he'd be asked to respond by way of an affidavit to those questions.
Yes, sir.
Particularly if they relate to issues where maybe there is no current controversy, but maybe a controversy may develop, but that could be the start. And when those responses are received, then one can weigh them and see whether it's necessary to have him come back or not, where one can deal with them without any further oral evidence. Then we could look at doing it that way. What do you think of that? It may well be that in regard to some, it's important to have oral evidence, but I'm just raising this as a...
So where we are, Chairperson, now, is there are 15 3-3 notices and affidavits.
Yeah.
We've dealt with 12 of the 15, so we have 3 more to deal with.
Yes.
And those 3 are the 2 Alex Score gentlemen,
Yes.
Mr. Craythorne and Mr. Bishop.
Yes.
The issues are perhaps relatively narrow there.
Yeah.
And then we have Mr. Momiat from the Treasury.
Yes.
That's perhaps slightly more complicated. But what's then left really are these small issues. This affidavit,
Yeah.
a photograph, the 2 public protector reports.
Yes.
So yes, that is a possibility. But right now, if Mr. Gigaba is not comfortable dealing with this affidavit, I don't intend to deal with it. But if what you're proposing, and I see it's edging towards 4:30, if what you're proposing is that we should do that in respect of everything that's left, I'm happy to have a shot at that. And if I understand you correctly, he would then put up his answers. Hopefully that could be done in quite a short period of time, and then we could approach you perhaps as to whether it's necessary for Mr. Gigaba to be led on any specific issue, which would then presumably narrow down to an hour or 2. Is that what you have in mind?
Well, I certainly, what I have in mind is that maybe we could stop here, or maybe we could go for another 30 minutes. I'm not sure we can look at that, but certainly that whatever we haven't covered, it can then be put to him by way of questions. He responds by way of an affidavit. That's one scenario. But the other scenario, which I haven't mentioned, is this, that depending on how much time we might take, it may well be that on one of the mornings before the end of this week, if everybody is available, we could come together and maybe have an hour or an hour and a half or 2 hours, and at that stage just focus on what really requires oral evidence and questioning. That's another possibility. But I don't know to what extent that amount of time could assist.
Now, I think, Chairperson, that perhaps a hybrid would work.
Yes,
because if it will then give us an opportunity to focus our minds on, in respect of what is left, what is contentious.
Yeah,
I think if we could have a 2-hour slot,
Yeah.
we could probably knock off the contentious stuff.
Yeah.
There might then still be a need for an affidavit in
Yes.
respect of things like, for example, this affidavit is a
Yes,
simple
yeah.
question
yeah,
of is it admitted it's a half a page.
yeah.
So I would propose that we try and do both, and it might be sensible then to adjourn now so that we can reflect
Yeah,
on what is really left
yeah,
that's contentious. And I would have thought that we'll probably deal with the 3 of the 15 affidavits that remain.
Yes.
And as for these smaller issues, that can be dealt with by way of an affidavit.
okay, no, that's fine. Before we proceed, let me check whether Mr. Halley has arrived. He is to lead evidence with the next witnesses. Okay, no, are the witnesses available? Your witnesses? Okay, all right. Okay, all right. Mr. Solomon, you had the exchange between myself and Mr. Mybeck. Have you got any input to make?
Chair, only that we would welcome if we could dispense with Mr. Gigaba coming back, if it was possible. We'll cooperate in supplying answers to questions on affidavit, and then we can make the determination whether it's absolutely necessary to have him back.
Yeah. Of course, there is still the question of you cross-examining Ms. Ngoma.
Yes.
Now, Ms. Mzimela and Ms. Kutsi were scheduled to avail themselves for cross-examination by you this Wednesday, I think. This Wednesday.
Yes.
As I understand,
That's correct,
as I understand the position, Mr. Mybeck indicated, I think on Friday, that Ms. Mzimela will not be available, and you indicated that, if I recall correctly, you thought you would not need to cross-examine Ms. Kutsi. If that remains the
correct.
position, we could use the morning of Wednesday for the cross-examination of Ms. Ngoma. But it may well be that we could start earlier with Mr. Gigaba, because Ms. Ngoma could come in at 10. Maybe we could start earlier with Mr. Gigaba on Wednesday morning, and try and finish on the disputed areas or controversial areas or important areas. And thereafter, then you could cross-examine Ms. Ngoma. How does that sound to you?
That would be in order, Chair. Just a question of between now and Wednesday, been enough time to iron out the areas with Mr. Myberg.
Chairperson, if I could perhaps suggest this, I think what I would try my best to do is use, if we were to start at 8:30 and we had 1.5 hours, I'll try my best to focus on what I consider to be the contentious issues. And then we will rest with the rest of our questions being decided by way of affidavit. So we needn't necessarily engage with Mr. Solomon. What I haven't dealt with in that 1.5 hours, I would ask him to deal with in an affidavit.
You understand that, Mr. Solomon?
Yes, that's in order then, Chair.
Yes. Okay, Mr. Mybeck, do you know whether Ms. Mybeck, Ms. Ngoma would be available for Wednesday?
I don't know offhand, Chairperson, but I can certainly find out, I'm sure, in the next half an hour.
Okay, all right. Let's say you will try and find that out. But the plan is, and this can be confirmed maybe tomorrow, the plan therefore is that we would start at 8:30 with Mr. Gigaba. so that all the contentious issues could be covered. And after he has finished, whatever has not been covered will be dealt with by way of written questions and then an affidavit in response. And after Mr. Kigaba has finished giving evidence, then if Ms. Ngoma is available, she would then take the witness stand and be available for cross-examination. Okay, so that's our arrangement.
Thank you, Chairperson.
Okay, all right.
Thank you,
You
Chair.
understand, Mr. Kigaba? Yes, okay, all right. So we are going to then adjourn the proceedings relating to Mr. Kigaba now, and we'll resume on Wednesday morning. And then I'll adjourn for about 10, 15 minutes to enable the next work stream to set up. And then I will come back and then we'll continue.
Thank you.
We adjourn.
Good afternoon, what is it, Mr. Mzila? Mr. Mzila, good afternoon.
It looks like he's stepped out.
Stepped out.
There
okay.
he is.
And Ms. Ngubane?
Yes, hello.
Good afternoon, Ms. Ngubane.
Good afternoon.
How are you, ma'am?
Very well, thank you. How are you?
Good, thank you. We can hear you very loud and clear. We are about to start shortly.
Let's see if my camera is also working as clearly. Can you switch it on? Okay. Oops. Let's see.
Can you see?
Yes, I can.
There we go. We can also see you. Thank you.
Okay, perfect. Sawubona wetela.
Sawubona.
Kade kakucima.
Khona kunjani?
Saphila.
Sizosherisha noma kwenziwa njani?
Hello, Ms. Ngubane. Ms. Ngubane, are you there?
I am here, thank you.
Okay, tell me, ma'am, are you going to take the oath or affirmation?
I'll take the oath.
The oath, thank you.
Yes.
Good afternoon, Mr. Halley. Good afternoon, everybody.
Thank you, Mr. Chairperson.
Are you ready?
We are ready to proceed, Mr. Chair.
Yes.
Mr. Chair, we'll be hearing today in the evidence in respect of the law enforcement agency's work stream. And we'll be hearing the evidence of Ms. Ngubane, who I understand prefers to be called Ms. Zulu because she's actually married and now goes by the married name of Zulu.
I'm sorry, what was the married surname?
Her maiden surname is Ngubane.
Oh, okay. Yes, do you want to indicate what evidence will relate to for the benefit of the
Mr. Chair, you'll
public?
recall that there was testimony that had been given by Mr. Trevor White, who was a forensic auditor, some of which touched upon the evidence of Mr. Mabuyekulu, Mr. Michael Mabuyekulu. And in particular, there was a dispute between the testimony that had been provided by Mr. Trevor White and Mr. Mabuyekulu as to the circumstances relating to a donation of some 1,000,000/1.053 million rand that had been paid, that had apparently been given to Mr. Shabalala and the evidence was that Mr. Shabalala had handed it over to Mr. Mabuyekulu for onward transmission to the ANC as a donation. Now, there was some uncertainty as to the precise nature of Mr. Trevor White's affidavit. Mr. White has in fact provided a supplementary affidavit where he's clarified what his testimony has been. Mr. Mabuyekulu will come and testify during the course of tomorrow sometime. But in the meantime, we've managed to get an affidavit from Ms. Zulu, or Mrs. Zulu, who has explained the circumstances in which she obtained the evidence.
I guess we'll have to be consistent because her affidavit says Ngubane. Otherwise, whoever reads the transcript will think Miss Zulu is somebody else. But that's, we mean no disrespect to her in-laws. Good afternoon, Ms. Ngubane, Mrs. Zulu.
Good afternoon, Chair. I'll pass on the message to the in-laws.
I guess you need to make sure that they must know that you are protective of your new surname. Yes.
We'll do so, Chair. Thank you.
Yes, Mr. Halley.
Thank you, Mr. Chair. So, Mr. Chair, we'll just lead evidence on the circumstances in which the affidavit of Mr. Mzila was obtained. Ms. Ngubane was the attorney who was dealing with the matter at the time, and she was the person who prepared the draft affidavit on behalf of Mr. Mzila.
Yeah.
So if she can be sworn in.
Okay, all right. Please administer the oath of affirmation.
Please state your full names for the record.
Sibusisiwe Nkosinomusa Ngubane Zulu.
Do you have any objection to taking the prescribed oath?
No, I do not.
Do you consider the oath binding on your conscience?
Yes, I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you, Ms. Ngubane.
Thank you, Mr.
I think if we say Ngubane Zulu, that should be fine, because then at least Ngubane is there, that is in the affidavit. Okay, all right. That will cover the in-laws.
Thank you, Mr.
Okay, thank you for availing yourself, Ms. Ngubane Zulu, to give evidence in the commission and to assist us. Thank you for availing yourself.
Thank you.
Thank you, Chair.
Okay, Mr. Halley?
Ms. Ngubane Zulu, if you could be so kind as to turn with me to page 163. Mr. Chair, there should be a bundle which is marked LEA 27 before you. And if we could turn to page 163 of that bundle.
Yes.
Now, if you have that page, I would appreciate it if you could turn to that page.
Have you got that page, Ms. Ngubane Zulu?
I'm going to quickly go to it, Chair, maybe just to also request your indulgence, because this bundle, I'm looking at it electronically, so
Yeah.
I'm going to be scrolling on the same screen that I'm looking at.
Okay.
Yes. If Advocate Halley can just repeat the page number, please.
Page 163.
So you will look at the black numbers. If that has not been explained to you, they appear on the left-hand corner of each page. They will be written LEA-27-163, but when we refer to the pages, we won't mention LEA, we won't mention 27, we'll simply say 163.
Chair, the bundle in my possession is marked, and Advocate Halley, on the email that was sent to me this morning, reference was made to the page numbering that is in red, the RR4 TSW.
To be of assistance to the witness, Mr. Chair, there's two numbering systems, as you're aware, Mr. Chair, but they both, in this case, they're both identical. So if you could look at the top right-hand corner, it should be 163 anyway, Ms. Ngubane Zulu.
Thank you.
Well, basically, what we are looking for is for your affidavit.
Correct.
That is your affidavit that is at page 163. It is where it starts.
Thank you, Chair. So, Chair, in this bundle, it actually moves from RR4-TSW -0057, and then it goes straight to RR4-TSW 1358.
No, it looks like you have a completely different bundle.
You look at, if I might be,
Were you given one bundle or more than one?
you should
I
be,
was given more than one bundle, Chair.
The one that we are using at the beginning of it, if you have got the whole bundle, it's got exhibit RR7 written, and that is inside, not necessarily outside, and what it has got is Mr. Mabuya Kulu's application. You've got a notice of motion there, paragraphs, page 2 and 3. And then you have got his affidavit, that is Mr. Mabuyakulu at page 5. When I say page 5, I'm referring to the page that is marked LEA-27-005. But I just say page 5. Have you got a bundle that has got Mr. Mabuyakulu's affidavit at the beginning, or his application?
It's not an application. I've got the bundle that's got his affidavit, Chair. But if Advocate Halley can just indicate to me if which affidavit is referring to, because I'm quite familiar with the contents of the affidavit, especially the ones that we had discussed in our consultation.
It's the affidavit which of yours, Ms. Ngubane Kulu, which is dated the 17th of May of 2021. In other words, an
Thank you.
affidavit
I'm
that we
comfortable
posted
with
last
that.
month. Have you got it?
Yes, I'm comfortable with us going ahead, Chair.
Yeah, okay, all right.
Thank you, Mr. Chair. Now, I'd like you to turn to, if you could identify the document in the first place. So if you could turn to page 163 of that bundle and identify what that document is.
Do you have it, or you were saying you are comfortable to deal with it even if you are not looking at it?
Yes, Chair, I was saying I'm comfortable to
Yes.
deal with it even if I'm not looking at it.
Yes.
But I can certainly confirm that I did depose to an affidavit
That is on the 17th of May,
on the 17th of May.
2021
That's correct, Chair.
at Durban North in the police station, is that right? No,
That's
not
correct,
Commissioner
yeah.
of Oaths, Hyper by the Sea.
That's correct.
Is that correct? Okay, all right. It's an affidavit that has got 1, 2, 3 pages, and on the 4th page is just your signature as well as the commissioner's certificate. Is that correct?
That's correct, Chair.
That's
I can
correct.
confirm that that is my
Yes.
affidavit.
Thank you.
I think let's go ahead.
Thank you, Mr. Chair.
We'll accept that this is the one.
Now, according to your affidavit, you confirm here that you had been dealing with the matter, an investigation which...
Maybe we should just admit this affidavit.
Pardon me, Mr. Chair.
You confirm that the contents of that affidavit are, to the best of your knowledge, true and correct, Ms. Ngubane Zulu?
I do, Chair.
Yes. Mr. Halley, you would like me to admit it as
Please,
exhibit
it
what?
should be exhibit RR 7.6, Mr. Chair.
RR 7.6.
0.6. Thank you, Mr. Chair.
The affidavit of 17 May 2021 by Ms. Busisiwe Nkosinomu Ngubane, which starts at page 163, will be admitted as an exhibit and marked as exhibit RR 7.6. Yes, continue.
Thank you, Mr. Chair. Now, Ms. Ngubane Zulu, in the affidavit, you speak at paragraph 4 of the circumstances in which you came to deal with this matter. And you say, if I might read for your benefit, that in 2009, I was approached by Mr. Senzo Mkunu, who was the provincial secretary at the time.
Well, she might just want to tell us the story. Maybe
Yes.
you might just let her do that because she doesn't have the affidavit.
Thank you, Mr. Chair.
Maybe we can say, Ms. Ngubane Zulu, you are a practicing attorney, is that correct? Are you a practicing
Yes,
attorney?
I am.
From when have you been practicing as an attorney?
I have been in practice from 2007, if I'm not mistaken.
Okay. In 2009, in which law firm were you practicing as an attorney?
I was practicing at Ngubane Wills Incorporated.
Yes. Were you a partner in that firm at that stage?
That is correct, Chair.
Okay. You remained in that firm for up to when, or are you still in that firm?
I remained in that firm up to now,
Yes.
and I also work as a legal, yes.
Okay, all right. Mr.
Thank
Ehali,
you,
do you
Mr.
want
Chair.
to take it from there?
Thank you, Mr. Chair. Now, if I understand correctly, your firm represents the ANC KwaZulu-Natal, is that correct?
Yes, the firm at the time represented the ANC in KwaZulu-Natal.
And in 2009, you were approached by Mr. Senzo Mkunu in relation to an investigation that was being conducted by the SAPS relating to a donation, is that correct?
That's correct. At the time, I was dealing with other matters on behalf of the ANC, and Mr. Senzo Mkunu was the provincial secretary and approached our firm urgently to deal with an urgent request that had been received by the ANC from the SAPS who were investigating a certain matter.
Now, if I understand correctly from your affidavit, in fact, Mr. Wills was dealing with the matter as well.
That's correct. So maybe just to give clarity, Mr. Wills is the criminal law specialist, and I deal with a lot of, I had always dealt with this civil matters and all civil litigation. So in this instance, when we got the instructions, obviously the instructions were to the firm, and the bulk of the matters relating to this and further consultations and instructions were given directly to Mr. Wills. But at the time, I was asked by the client to confirm, a specific matter through the, the preparation of an affidavit.
Now, if I understand correctly, your law firm made contact with the investigating officer whose details had been provided to you by Mr. Mkunu. Is that correct?
Yes. The details of the investigator were provided at the time. And Chair, I must maybe also apologize and indicate to yourself that, this was obviously in 2008, 2009, and one may not have the exact recollection, but, all the details at the time. But between myself and Mr. Wills, the investigator was contacted, and he basically indicated that there was an ongoing investigation and they required confirmation that the ANC had in fact received a donation of 1 million rands from, at the time. So that was basically the inquiry. They were just looking for confirmation that 1 million rands had been received by the ANC.
Maybe let's put it this way so you can just tell the story as it happened, as you remember it, if that's fine. Mr. Hali.
Thank you, Mr. Chair.
Is it correct that in 2009, you handled a matter on behalf of the ANC, in the course of which you prepared an affidavit that was to be signed and was actually signed by Mr. Delani Mzila? You remember handling such a matter?
Yes, that is correct, Chair. I do remember the matter.
Can you tell me how that came about and what happened, and how it came about that Mr. Mzila signed that affidavit, and we know that he also signed another one later on, and you might not have been involved in the drafting of the second one. Can you just tell how the story happened?
Thank you, Chair. As I've indicated, I was contacted by Mr. Senzo Mkunu, who was the provincial secretary at the time for the African National Congress, who indicated that he had received a call from an investigator who was looking into a certain matter, and they required confirmation that an amount of 1 million rands had been donated to the African National Congress, the KwaZulu-Natal province. We then, together with my colleague, Mr. John Wills, reached out to the investigator. Once again, Chair, as I indicated, I could not recall the name of the investigator when I consulted with Mr. Halley, but he did indicate to me that the investigator was Colonel Deploy, and I accept that. And also, once we had spoken to him, we then obviously were able to go back to, I went back to Mr. Mkunu, the provincial secretary at the time, and informed him, of exactly what the issue was. He was then of the view that because the
Maybe
matter...
let's start by you to tell us what the investigating officer said. What information were you looking for, and what did he tell you? As you recall.
So as far as I can recall, Chair, the investigator, I can't remember all the details, but I can certainly confirm that the investigator was looking for confirmation from the ANC that an amount of 1 million rands had been received as a donation. So that was the crux of the matter and what the investigator was looking for. And he did indicate that there was an ongoing investigation. And Chair, I'd want to also indicate that, I have no recollection of the details of the investigation yes.
Yeah, continue.
But the issue was just the confirmation of receipt by the ANC KwaZulu-Natal of the R1 million donation.
Okay, continue. I interrupted you when you said after speaking to the investigator, you went back to Mr. Mkunu, and what happened?
Thank you, Chair. I then went back to Mr. Mkunu as the person who had basically sought our assistance, just to give him feedback that we had engaged with the investigator and he had clarified exactly what information he was looking for. He then indicated that because this related to fundraising issues, that is basically a matter that would be dealt with by the finance office through the provincial treasurer. And the provincial treasurer at the time was Mr. Mike Mabuyakulu.
Yes.
He then, obviously, I did brief him that the matter was urgent and the investigators were just looking for this confirmation, and therefore there needed to be cooperation, which he didn't have any difficulty with. And he immediately contacted Mr. Mike Mabuyakulu just to bring to his attention that there was this request which came from, the investigator. Mr. Mabuyakulu then said, it's fine, he will engage with myself and Mr. John Wills just to give us background and basically confirm if such monies were received. Chair, I do not remember if, once again, I need to clarify this, I do not remember if I then met with Mr. Mabuyakulu on the very same day, or the arrangement was made and then we engaged at some point. But I can confirm that we did engage, and it was a very brief engagement, because from what I understand is that further engagements were held with my colleague and partner, Mr. John Wills. But I can then, as stated in my affidavit, Mr. Mabuyakulu then did confirm that indeed the African National Congress, KwaZulu-Natal, had received a donation of 1 million rands, and that this was basically received as part of preparations for the ANC conference, provincial conference. And he also, Chair, I do not have full recollection, but if you look at the affidavit, because now having looked at it years later,
Yes.
You know, the affidavit has very, very specific, you know, statements that are there. Firstly, the affidavit
Which
states...
affidavit are you talking about?
The affidavit that Mr. Mzila deposed to.
Okay, all right. Continue.
I'm not sure, Chair, if Mr. Ali would want to admit that affidavit first.
We'll look at it later, but I just want you to tell what happened as naturally as you can.
Thank you, Chair. Then, because if you look at the content of the affidavit, it clearly states that firstly, the donation had been made by a certain Dr. Savoy, and secondly, that such a donation was received through Mr. Sipho Shabalala. Now that's contained in an affidavit, and obviously, as a you know a legal practitioner, those would be instructions that you receive from client, and then you know we would prepare an affidavit based on instructions that client has received. I then obviously inquired.
Oh, well,
as part of...
Before we go to the affidavit, your engagement with Mr. Mabuya Kulu, is it that engagement from which you indicated or you put in information in Mr. Mzila's affidavit that the donation that was spoken about came from Dr. Savoy? So in other words, where did who in the ANC told you about that?
Yeah, there were two people that were ANC representatives who gave information that is, or any content that is contained in that affidavit that I directly engaged with. It was Mr. Mabuya Kulu and Mr. Mzila. And I believe that the bulk of the content had been given to myself by Mr. Mabuya Kulu, because at a later stage, I then spoke to Mr. Mzila to basically, maybe Chair, if I can just continue from where I left off, but those are the two individuals that actually gave information that formed part of the content that's in the affidavit, Chair.
Yes, continue then. So you got the information from Mr. Mabuya Kulu, and what were your instructions in terms of what to do now that you had spoken to Mr. Mabuya Kulu?
Once I had spoken to Mr. Mabuya Kulu, he then, so I asked if, you know, there was proof or any documentation such as an acknowledgement letter or any element just confirming receipt of this donation. He then requested that I must actually engage with Mr. Mzila, who is responsible for the financial administration of the ANC office, provincial office. And he also indicated that because of Mr. Mzila's position, he was the one who was going to depose to the affidavit. And Chair, I must highlight that this was nothing unusual, because having done work for the ANC over the years, once you've consulted with them as client, they would then make a determination on who will depose to an affidavit. For example, if it's a matter that relates to eThekwini region, they will say the regional secretary will sign the affidavit. But this would follow various consultations. So it was nothing unusual, and we'd done that previously. And hence then I engaged with Mr. Mzila to basically now say to him, Mr. Mzila, these are the instructions that we've received, and this is the background. That is, they have been advised that you are going to depose to the affidavit by the provincial treasurer. And Mr. Mzila at the time appeared to me as someone who had full knowledge of the matter, because he did indicate that yes, indeed, the provincial treasurer had engaged him on the matter. I remembered certainly, Chair, that some of the information that I obtained from Mr. Mzila was just for completeness of the affidavit, was obviously his qualifications, and which he informed me that he possessed a BCom degree. And I also specifically, because in as much as I knew that he worked in the ANC office, I was not certain of his job title. He then gave that to me and advised that he was the finance manager. But throughout the discussion, so there was no other opposition or any other issues raised. We went through, as the chair would have seen, the affidavit is a simple 2-pager that basically confirms that the donation was received, that it had come from a certain Dr. Savoy, and it had been received through Mr. Sipho Shabalala, and that was basically the confirmation. And it was then emailed to Mr. Mzila, and Mr. Mzila, at the time, I was based in Pietermaritzburg, and the investigator was in Durban. So I then asked Mr. Mzila to go through the affidavit. In fact, telephonically we engaged on it because it was just a basic affidavit, and then completed it, and then I emailed it through to him, and he and I asked him to print it out and get it signed and commissioned and delivered to the investigator at the time, to which he agreed. So that was basically the events on my side, Chair.
Mr. Ngubane, thank you, Mr. Chair. Mr. Ngubane, Zulu, if you could look at bundle RR4 at page 1843.
If she would be able to see that one.
I believe she can see that one. At page 1843, for your benefit, Mr. Chair, it's bundle D in,
yes,
in the series.
I assume it's the second one that is here.
That is correct, Mr. Chair.
Yes. Did you get the page number, Ms. Ngubane Zulu?
Chair, I'm just scrolling down.
Basically, he's taking you to Mr. Mzila's first affidavit. Is that correct, Mr. Hali?
That is correct, Mr. Chair.
Sorry, Chair, I was told lawyers are not very good with technology, and I'm proving to be one of them. I am now on page 15.
Yes. The page is 1843, is that right? And this time we're looking at red numbers because there are no black numbers.
Correct, Mr. Chair.
Yes, have you got it? Have you got it?
Yes, I'm just scrolling down. I'm now on page 166.
Okay.
I'm almost there, Chair. Apologies for the delay. (1843).
That is correct.
Yeah.
Now, just to identify this document, it's got the words affidavit between the tram lines, and it purports to be an affidavit prepared by Mr. Delani Mzila. And if you look at page 1844, the following page, it's got the details of the deponent, and it's got the details of the Commission of Oaths on the following page. Now, you've spoken of a document.
Well, it's got the signature of the deponent and the details of the Commission of
The
Oaths.
signature.
Yeah.
Thank you, Mr. Chair. And of course, the details of the Commission of Oaths. Have you seen this document before, Mr. Ngubani Zulu?
I did see it when the signed version of it, Chair. I did see it when the commission emailed it to me.
And is this consistent with the document that you had emailed in a draft form to Mr. Mzila?
The content, it looks, it certainly looks consistent, but although I don't recall, but I doubt very much there would have been much of, changes on the document, because by the time I sent it to Mr. Mzila, we had basically fully discussed the content of the affidavit.
So is the position that after Mr. Mzila had signed the affidavit that you had sent to him, you didn't see it because you asked him to send it to the investigator?
That's correct, Chair.
And you didn't you didn't ask him to send you a signed copy?
No, Chair. I did not get a signed copy. I am not sure, Chair, if maybe a signed copy was at some point sent to my colleague, John Wills, but I did not receive the signed copy.
Okay, but you have had a chance to read this document, is that right?
Yes, I have, Chair.
Does it accord with the contents of the affidavit that you had prepared and sent to Mr. Mzila?
That's correct, Chair.
Okay, continue, Mr. Halley.
Thank you, Mr. Chair. Now, you had an opportunity to chat with Mr. Mzila about this affidavit subsequently, is that correct?
That's correct, Chair.
And could you tell us about the nature and the content of that discussion that the two of you had, and when it took place?
Yes, and when it took place.
So once again, Chair, I don't have the exact recollection when that discussion between myself and Mr. Mzila took place. Firstly, it was not a formal meeting where, he had arranged to meet with me or I had done the same. I was basically, attending to other work or in other instructions at the ANC office. And I saw Mr. Mzila, who basically indicated, and we had a very cordial relationship. We greet each other all the time, so we had bumped into each other, and he had indicated that he just wants to speak to me quickly. I must just come past when I'm done. Come past his office when I'm done with my other work. So that's exactly what I did. I went past his office, and Mr. Mzila then raised, an issue which was a bit surprising to me at the time, because he indicated that he had basically, he reminded me about the affidavit, that he had deposed to. And I said, yes, obviously I remember. And he said, you know what? He realizes that he shouldn't have done that. That's a highly complex matter. And he's been discussing it with even other, comrades. And he's been warned, because he doesn't have much of a background around matters arising therefrom, and does not have direct knowledge of what happened. And, Mr. Mzila is a very, he's a funny guy, so to speak. So, he just said, I almost got myself into trouble. And I said, what do you mean? He said, you almost got me, arrested, but obviously we were discussing this in isiZulu, chair, and he said, obviously this was just too much. He didn't understand. And I said, oh, okay. And he said, no. But he's resolved the matter, because I was quite concerned and I didn't have much of, background around what his concerns were and what the new developments were. So I then asked him, what had happened, and then he said, no, the matter has now been resolved. He has basically submitted another affidavit clarifying his position around the matter. And, I was quite relieved, and that was basically and I just assured him, obviously, not just as, someone that I knew within the ANC office, but also I had, the obligation as a legal representative that if the matter had been raised with me, I would have actually, insisted that we discuss it as I had been instructed by the ANC provincial leadership, and we would have discussed it. And that was the end of the matter. But at the time when we discussed it, he seemed to be quite comfortable because he felt that he had put on record, and given background or clarified certain issues that needed to be clarified.
Now, if I understand your testimony correctly, he had explained to you that he had prepared a subsequent affidavit in which he provided that clarity.
Yes, and he even informed me that he had done so independently in his personal capacity, and he did it because I was also quite interested. I think that's also important because I was just wondering if, the same matter had been given to, other lawyers had been instructed to deal with the matter. And he said, no, he had done so independently, and he secured the services of Mr. Kulu to help him put together, an affidavit clarifying, the issues that needed to be clarified.
And when you refer to Mr. Kulu that had assisted him in preparing that affidavit, are you referring to a legal representative?
Yes, that's correct.
And Mr. Kulu, according to your affidavit, was an attorney. Is that right?
That's what I understood. Yes, that's correct.
Now, so you yourself were not involved in any way in the preparation of the second affidavit, according to your testimony. Is that correct?
No, I wasn't, Chair.
And did you ever get to, did Mr. Mzila provide you with a copy of the second affidavit at all?
Not at all, Chair.
Thank you, Mr. Chair.
So, as I understand your position, you say one of the things that part of the information that you were given before preparing Mr. Mzila's first affidavit was that the donation that the ANC had received had been made by Dr. Savoy. Is that understanding of your evidence correct?
Chair, I am not sure at what point the name of Dr. Savoy and Mr. Shabalala, came up.
Yes.
Because I know when I saw the affidavit now, I had no recollection of, the discussion around, for example, Mr. Sipho Shabalala. But I was reminded by the affidavit. What I can confirm, Chair, is that firstly, the content of the affidavit was based on instructions that, you know, we had received from client and being the ANC KwaZulu-Natal, and the two individuals that I had personally engaged with in relation to the content of the affidavit were Mr. Mike Mabuyakulu and Mr. Delani Mzila. So the entire content came from the two individuals.
Yes. You say you could not remember the name of Mr. Shabalala being told to you. Is that correct? But you saw.
Yes,
it in the
now
affidavit.
obviously years later,
Yes.
I could not recall the, you know, the names, but when I looked at the affidavit, I'm quite certain, obviously, that that would have been based on instructions that we received at the time.
Or is what you are saying that prior to you seeing Mr. Mzila's affidavit that was supplied to you by the commission, you did not remember whether Mr. Shabalala featured in this thing, in this matter. But after you had seen it, you remembered that he had featured, or is the position that you just see it here in the affidavit, his name, but you have no recollection even now that it did feature there?
No, Chair, prior to being supplied with the affidavit, I did not have recollection. But after seeing the affidavit, I can certainly confirm that the content of the affidavit was based on instruction that came from client.
Yes. Now, between Mr. Mabuya Kulu and Mr. Mzila, who had told you that the donor or the donation had come from Dr. Savoy, if anybody did say that to you?
Chair, I would be lying. I don't have the exact recollection of who said what.
Yes.
You know, what I remembered, you know, even before looking at the affidavit, and what I'm certain of is that there was confirmation that the donation was received. And that was basically common cause, you know, between Mr. Mzila and Mr. Mabuyakulu at the time, because like I said earlier, when I engaged with Mr. Mzila, I remember he specifically said that, no, when I was trying to just give him the background to say why, you know, I'm making contact with him, and, you know, and he indicated that, yes, indeed, he had engaged with Mr. Mabuyakulu. So there was no dispute, in my view, around the content of the affidavit. But I cannot exactly say that this, you know, is what was said by this individual. But there were certainly instructions that I got from Mr. Mabuyakulu that caused for a draft confirming receipt of the amount of the donation to be done. And then the second discussion or engagement took place with Mr. Mzila, just confirming, you know, the content of the affidavit, or inserting whatever other detail that required to be inserted.
Well, I see that in your affidavit to the commission, in paragraph 5, you say the following in the first line. After I briefed Mr. Mabuyakulu about the request from the investigator, he confirmed to me that the ANC KZN had indeed received a donation of 1 million rand from a certain Dr. Savoy when they were preparing for one of the ANC conferences. I asked him if there was any proof of this donation being made or an acknowledgement sent to the donor. He advised that such administration would have been handled by Mr. Delani Mzila, who deals with day-to-day ANC finance matters. Mr. Mabuya Kulu then requested me to assist with drafting the affidavit confirming receipt of this donation, as he was certain that it had been received. He also advised that Mr. Delani Mzila would be the deponent and will accordingly sign the affidavit once he confirmed the details in his records regarding the receipt of the donation. So here you are specific that it was Mr. Mabuya Kulu who said that indeed the ANC KZN had received a donation of 1 million rand from a certain Dr. Savoy when they were preparing for one of the ANC conferences. Is that correct? Is that not correct? What is the position?
Chair, that affidavit was basically confirming the content of the affidavit that I had received from the commission that Mr. Mzila had deposed to. I want to be very cautious and not just apportion, the content of the affidavit for certain to any individual, because at the time there was no dispute around it. And I do also accept the content of Mr. Mzila's affidavit, the later one, which obviously I've now, because I do not have evidence of what was the understanding, his understanding at the time, save for the fact that I relied on the fact that he held a certain position within the ANC, and he basically confirmed with me that a discussion had taken place with Mr. Mabuya Kulu, and he understood basically, the content of the affidavit. But I don't want to basically say in this instance, this is what I was told by Mr. Mabuya Kulu or Mr. Mzila, but I want to confirm that jointly, after having consulted with Mr. Mabuya Kulu, the content was also confirmed by Mr. Mzila, who then deposed to the affidavit. So those were the instructions, in my view, that came from the ANC as a client.
Well, in this paragraph, you do not equivocate. You are not uncertain. Your sentence is quite clear. You say, after I briefed Mr. Mabuya Kulu about the request from the investigator, he confirmed to me that the ANC KZN had indeed received a donation of 1 million rand from a certain Dr. Savoy. Are you now saying that's not true?
Chair, I'm not saying that is not true. What I'm saying is that that confirmation, I am certain it had come from, maybe in the affidavit I specifically said it came from Mr. Mabuya Kulu. What I even informed the evidence leader was that I am certain that there was confirmation of the donation that was received. My memory was assisted by having sight of the actual affidavit by Mr. Delani Mzila, because then that's what put me in a position to actually confirm that. I would not want to, apportion specific information or allegations to, either one of them, but rather to say I had consulted with the one, and then I did consult with the second one, and the content of the affidavit was confirmed by both parties, and then it was deposed to by Mr. Mzila.
So how must I read this sentence of your affidavit then? Must I read it in a manner that says you don't know whether Mr. Mabuya Kulu was the one who said that the ANC had received a donation of 1 million rand from a certain Dr. Savoy? Must I read it on the basis that you don't know whether he said that, or how must I read it to me?
Chair, I would request that it be read as these were instructions that came from the ANC as a client, and the consultation or the information would have come from two parties, and that's what I can certainly confirm, that it was Mr. Mabuyakulu and Delani Mzila who basically gave the content of the affidavit, and it was put together as such. So the instructions, maybe what I should have said in the affidavit is that the ANC did indeed confirm that, you know, it had received the donation and that the donation had come from Dr. Savoy. Chair, you know, unfortunately, this was 2008, and I have tried, and I had this as the same engagement with the evidence leader, and I said, I can't, you know, outright say this is what Mr. Mabuyakulu said, this is what Mr. Mzila said. The only issue that I remembered certainly is that Mr. Kunu could not contribute any content because he said he does not have information in relation to this, and referred me to the relevant office, which was the finance office in this instance.
So is your position, as you give evidence, that it was one of two people who
That's
told
correct.
who told you that the donation had been received, a donation of 1 million rand had been received from a certain Dr. Savoy, and you are saying it was either Mr. Mabuyakulu or Mr. Mzila. Is that what you are saying?
That's correct, Chair.
Now, did you prepare the affidavit before speaking to Mr. Mzila or meeting with him, or did you prepare it only after you had met him?
So Mr. Mzila, I contacted the first engagement was with Mr. Mabuyakulu, Chair. Thereafter, a draft was prepared. And that is the point I'm trying to make, Chair, that I cannot exactly say that at the time of engaging with Mr. Mzila, paragraph A and B and C were already there. I can't confirm that. And hence I needed to then engage with Mr. Mzila and take him through the instructions that I had received at the time. And he appeared to be very much aware, and I got further information from him. What I have definite recollection of is that Mr. Mzila gave me obviously his educational background and his position at the ANC office at the time. But the discussion, there was nothing that was disputed at the time or contrary to, you know, basically there were no contradictions around the instructions at the time, because by the time I was explaining myself to Mr. Mzila, just saying that this is what has happened. We received the instructions. We had engaged with the provincial secretary. Thereafter, the provincial treasurer, he confirmed that he was aware of such an engagement.
Yes, I may be mistaken, but I understood Mr. Mzila's second affidavit to say that he did not have personal knowledge of the donation other than what he was told by Mr. Mabuyakulu. Is that your understanding as well of part of what his affidavit says?
That is the understanding, Chair, that I now have,
Yes.
having seen his second affidavit.
Yes,
And
yes.
because I do not have background, I have no reason to actually dispute, the content of, his affidavit.
Yes, yes. Okay, Mr. Halle, anything?
Thank you, Mr. Chair. Just one further point. The affidavit that you prepared on the 17th of May of 2021, that particular affidavit, Mr. Ngubane Zulu, did you prepare that affidavit? Did you consult with anybody before you prepared that affidavit?
I did not consult with anybody. What I did, Chair, and I think it's very important to mention this, that because these were instructions that came from, a client, I did alert the current provincial chairperson, Mr. Sihle Zigalala, that I have received a notice to appear before the commission, and that I would be dealing with matters relating to, the ANC and aid donation that was received. He then, accepted and indicated that it appears that they have, someone in the office, or I'm not sure if it was himself or someone else in the office had already received that notice. So that's confirmation I got from Mr. Sihle Zigalala.
And when you say that that when you had a consultation with the evidence leaders, you're referring to a consultation that took place this Saturday, is that correct?
That's correct.
But when you prepared this affidavit, did you have any consultation with the evidence leader when you were preparing this affidavit?
No, I didn't.
Are you talking about her affidavit to the commission?
Correct, Mr. Chair.
Okay.
No, Chair, the first contact that I made with the evidence leader was initially there were emails that were sent last week, and thereafter we confirmed my appearance for today, and we arranged for a consultation to take place on Saturday evening.
Thank you, Mr. Chair. I have no further questions.
Thank you very much, Ms. Ngubane Zulu. Thank you for having availed yourself. You are now excused.
Thank you, Chair.
Okay, all right. Do I need to adjourn for a few minutes before you can get Mr. Mzila?
Apparently it's on the screen already.
Okay, shall we just continue?
Thank you, Mr. Chair.
Okay.
Mr. Chair, I think we have sufficient context of what Mr. Mzila's evidence will be about.
Yes.
So
We should be quite short with you.
It should be short. If I could ask that you be sworn in. Mr.
Yes. Good afternoon, good evening, Mr. Mzila.
Good evening, Chairperson.
Yes, thank you for availing yourself to assist the commission. The registrar will administer an oath or affirmation to you now.
Okay, Mr. Chairperson.
Will you be taking?
Oh, sorry.
I'm not well vested with the terminology of lawyers.
Okay, all right. Are you legally represented or not? You are not legally represented?
Yes.
Okay, all right. Okay, she will administer the oath or affirmation to you. Okay, continue.
Will you be taking the oath or affirmation?
The oath.
Please state your full names for the record.
Delano Hopewell Mzila.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath binding on your conscience?
Yes.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Are you left-handed, Mr. Mzila?
No.
She said raise your right hand and you raised your left hand.
Okay. Okay. So help me God.
Okay, all right.
Mr. Chair, I know that Mr. Mzila had requested the opportunity to testify through an interpreter. I understand that one was arranged. It was understand that he's also going to be linking in virtually because Mr. Mzila is from KwaZulu-Natal. We understand that if we get an interpreter from Johannesburg, it often causes problems.
And the paperwork that needs to be done, has it been done?
It's the, understand that it's the-
Whenever there is an interpreter, we should have that
Yes.
done.
Understand that the interpreter has been sworn in. He was the gentleman that testified previously, that we used previously and whom you recommend or commended.
Well, where is the paperwork relating to him?
Understand that given the lateness of hours, because the request only came through, if I understand correctly, today, that the paperwork itself hadn't been prepared, but understand that the interpreter, the specific interpreter, has been sworn in previously by you, Mr. Chair.
Yeah, but I need to see
Yes.
whether that's factually true.
Could I ask that the matter stand down briefly, Mr. Chair, in order to sort out this?
What's his name? The interpreter?
We've got his details.
You don't have the name.
We'll provide you with his details in a moment, Mr. Chair.
I wanted
Because-
to see whether it's going to ring a bell. I know a certain interpreter that we used when Mr. Mhlongo, was it Mr. Mhlongo was
believe
giving
so.
evidence?
I believe so, Mr.
That
Chair.
would have been under your work stream.
That was under my work stream. I believe it's the same interpreter.
Yeah. That's going to delay us. Mr. Mzila, are you intimidated by the language that is used in this forum? You think you think you won't manage answering questions in English?
No, I will try, Chairperson.
Yeah?
And I will try, Mr. Chairperson.
But I don't want you to feel that you have to use English if you really wish to use isiZulu. But I'm just asking, sometimes people say, well, I do know English, it's just that maybe some terms, legal terms might give me problems.
Comrade Chairperson, because also a Zulu, you assist me.
I think, Mr. Mzila, you think you are in an ANC meeting now. You said Comrade Chairperson.
Oh, sorry.
Okay, so maybe let's stand down for 5 minutes.
Thank you, Mr.
Let's
Chair.
see if we can sort this out. Obviously, this should have been sorted out much earlier.
It ought to have. Mr.
Yeah.
Chair, I apologize for that.
Yeah.
Unfortunately, the request only came through today.
Yeah. Okay, I'll stand down for about 5 minutes.
As it pleases you, Mr.
If the documentation is not here. We might have to see how we are going to handle this. I don't want us to lose a lot of time.
Thank you, Mr. Chair.
We adjourn.
Guptas. I don't know if you can. Yeah.
Kulegani kunjani bafu? Kulegani? Mr. Mzoto. Mr. Mzoto, are you there? Mr. Mzoto, are you there? Can you hear me? Can you hear me?
Hearings venue, I can hear you. It looks like he's just stepped away. I've asked to unmute.
Can you try wait? Can you try to tap something from his screen? Just tap something for him to unmute.
He's dropped off.
Okay.
He's rejoining.
Is he back?
Almost.
Hello?
Yes, Mr. Mzoto, can you hear me now?
Yes, I can, sir.
All right, okay, thank you.
Mr. Mzoto, can you be here on Thursday? We're going to stand down the proceedings for today so that you can assist us on Thursday. Would that be in order?
On Thursday, you said?
That's correct, yes.
What day is it? Yeah, I'm sure arrangements can be made with my employer, and I can avail myself then.
Thank you very much, sir. We'll be in contact with you. We just want to sort out the paperwork.
All right. But should I stay live?
Stay live so that it'll be communicated to you by the DCJ.
All right.
Thank you very much. And then if we can get Mr. Mzila on the line as well. Be available.
He's available.
Good evening, Mr. Mzila. Mr. Mzila. Mr. Mzila, are you there? Hello, wait. Wait.
I am pinging him, asking to unmute.
Is he there?
He's trying.
Okay.
Yes, I'm here.
Welcome back, Mr. Mzila. Thank you.
Mr. Mzila, would you be available on Thursday, presumably Thursday morning, to be able to testify? Because we need to sort out the paperwork related to the interpreter. Would that be in order?
Yes, it's fine.
So Thursday at about 10 o'clock, but the chairperson will confirm with us in a moment. Is that okay?
Yeah, it's okay.
Thank you very much.
Thank you. Can I leave the meeting now?
Now, if you could just remain in, please.
Okay.
You have a report back for me, Mr. Halley?
Thank you, Mr. Chair. Mr. Chair, I've confirmed with both the interpreter, Mr. Kulekani Mzoto, as well as with the witness, Mr. Mzila, that they will be available for Thursday if we could sort out the paperwork in the interim.
Yes. Okay, Mr. Mzila, there is some paperwork that should have been ready with regard to the interpreter that
Yes.
might delay things now, whereas there is another witness that I must still hear. So I'm happy that you and the interpreter have agreed to be available at some stage on Thursday. The exact time you will be told, and then we can then have your evidence at that time. Once your evidence starts, it should not take long. It should be a short time. Is that fine?
Okay, thank you, Chairperson.
Okay, all right. And thank you to the interpreter as well. Thank you. You are both excused now.
Thank you, Mr. Chair.
Thank you, Chairperson.
Thank you. Okay. And then I can release you as well.
Thank you, Mr. Chair. I'll appreciate that.
Yes.
I can tender the apologies, of course, for the mishaps. But unfortunately, the request only came through this morning, Mr. Chair.
Yes. Okay. No, that's
As it
fine.
is.
That's fine. I'm going to adjourn for a short time to enable the Eskom workstream to set up before we proceed. We'll adjourn for 5 minutes. We adjourn. Good evening, Mr. Seleka. Good evening, everybody.
Evening, Chairperson.
Are you ready? We have had some delay, but let's start as soon as possible.
Yes, we are ready, Chairperson.
You are ready?
We are ready indeed. Mr. Fresh Govender is the next witness.
Yes.
Mr. Govender is represented by counsel and an attorney.
Yes.
Maybe they could place themselves on record before the affirmation or oath is taken.
Yes, they may do so from where they are if their microphones are working.
Thank you, Chair. Dani Dorfling is the name. I have appeared in front of you previously.
Yes.
I'm representing Mr. Governor on instruction of Messrs. Ilogran Niker attorneys,
Yes.
to the left of me.
Thank you. Thank you. Okay.
Mr. Chair, can I perhaps just to guide us in how we move forward with our business, and it may expedite the process,
Yes.
if I may.
Yes.
Mr. Chair, we were being handed large bundles of documents from about 2:45 yesterday afternoon until 9:15 last night.
Yes.
There was a comforting session between Mr. Govender and Mr. Seleka in the presence of my attorney around about 6 o'clock, where certain topical issues were identified. It is the understanding that Mr. Seleka will focus his attention on leading the evidence of Mr. Govender with reference to those topical issues. We are ready to address those. If issues arise that falls outside the ambit of those topical issues that was discussed last night, it may require some indulgence to allow Mr. Govender to address that. But we
Yes.
believe that we've sufficiently covered the aspects that this commission is interested in and that we can move on with our business.
Okay, no, that's fine. That's fine. Okay. Registrar, please administer the oath of affirmation.
Please state your full names for the record.
Purushottam Govender?
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you, Mr. Governor. And thank you for availing yourself, Mr. Governor, to assist the commission. Thank you.
Thank you, Chair.
Mr. Seleka.
Thank you, Chair.
Well, for the benefit of the public, I think you may just take a few minutes to say what areas Mr. Governor's evidence will cover.
Yes.
Yeah.
Thank you, Chair. Mr. Govender has submitted an affidavit that traverses matters beyond what we intend focusing this evening. The focus of this evening's evidence is on the McKinsey trillion transactions, in particular the corporate plan, and what has been referred to as the service level agreement. Both these transactions were being negotiated almost simultaneously in 2015. The one was concluded in December 2015, and the other one being the corporate plan, December 2015, and the service level agreement, or the master services agreement, purportedly concluded in 2016. Mr. Govender would testify before the commission about the role he played in respect of those two transactions, and also about other persons who would have played a role along with him, and outline to the chairperson the nature of that role.
Okay.
And in particular, the reasons why direct payments were made to Trillion.
Yeah. Okay, right.
Thank you, Chair.
You can go ahead.
Before we go ahead, let me do housekeeping issues. Mr. Governor's affidavit, Chairperson, is contained in Eskom Bundle 14, bracket D. And the affidavit is found on page 1333.
Yes.
Mr. Governor, you should follow as well. Page 1333.
I'm there, Chair.
Thank you. The affidavit starts on that page and it carries on until page 1354. If you please go there. 1354. Are you on that page, Mr. Governor?
I am, Chair.
Yeah. There's a signature there above deponent. Is that your signature?
That's correct, Chair.
You confirm this to be your affidavit?
I do, Chair.
You confirm the correctness of the contents of your affidavit?
I do.
Thank you. Chairperson, I beg leave to have the affidavit of Mr. Governor admitted as Exhibit 43.1 together with the annexures there too.
Is there a letter before 43?
40, Exhibit U 43.1. Thank you, Chair.
The affidavit of Mr. Rishothman, Governor, which starts at page 1333, is admitted as an exhibit and will be marked as Exhibit U 43.1.
Thank you, Chair.
Before you proceed, Mr. Seleka, last week when we sat in the evening, there was an issue that one staff member or technician would need to leave at 7:30 in order to make it home before the curfew. And I asked the question whether we would be able to continue in his or her absence with the others who would be able to stay maybe up to 8. There was nobody who could give an answer. I need to find out what constraints we have today. And it looks like the people who are supposed to be here, who should be able to tell me, are also not there now. And that's exactly what happened last time. So the people from the commission who are supposed to sit behind you, Mr. Seleka, Reverend Seleka, Reverend Stemela is not here today.
The investigator will look for.
We'll try and find out.
Yeah.
Okay, let's continue.
Yes.
So that we all are on the same page as to how much time we are going to be here.
Indeed.
Okay, all right.
Thank
Let's
you.
continue in the meantime.
Thank you, Chair. Mr. Governor, some extensive evidence has been laid on the Trillion McKinsey matter before the Commission. There are certain issues that the Commission would like you to clarify, and I'm going to ask you questions in relation to those issues, but feel free to explain to the chairperson if you need to elaborate, explain, clarify, relative to the questions I'll be asking you. So, I would like to start with the corporate plan, Mr. Governor, because you do say in your affidavit that you had been asked by Mr. Koko to put together a contract in regard to the corporate plan and to put together documentation for the approval of the appointment of McKinsey. You recall that?
I do, Chair.
Yeah. Just keep your microphone on. Just keep it on. Yes. Do you confirm that that is what happened? That you received instructions from Mr. Koko to do that?
That's correct, Chair.
Yeah. Did you put together the contract and the documentation for approval.
Chair, just to, maybe if I could elaborate a little bit. And I apologize, I should have been looking at you, Chair. The contract, there was a couple of things happening in that period of time. We were nearing the end of the negotiations on the Master Services Agreement. And if you would recall, that is the bigger contract. At the same time, during September, there was a request from Mr. Koko that I work with the procurement team, because I was engaging with McKinsey at the time as part of the negotiations on the MSA, that I work with the procurement team to put together this contract on a sole supplier basis to, on an urgent basis, complete the corporate plan work that needed to be done. So the acting commodity sources general manager was a gentleman by the name of Mr. Charles Kalema. Mr. Kalema assigned a procurement specialist to assist with the necessary documentation that needed to be put in place. I, in turn, had top engineers working with me on the negotiation process on the MSA. I assigned one of those top engineers to work with, and the lady must please forgive me, but it was Mokoleya. Maybe you can help me there, Advocate Seleka. First name was Siamo.
Well, let's find out what page you are on.
Chair, I'm on page 1347.
Yes, paragraph?
46.
What paragraph?
46, Chair.
Yes. And
somewhere in the middle of the paragraph, you'll see Mr. Kalema assigned Ms. Siamo.
It's Makulwani.
Makulwani. So Ms. Makulwani assisted with the documentation because they had the templates and knew exactly what information needed to be put in there. And the proposal sent by McKinsey, which is referenced on paragraph 45, was used by and large as the basis for the documentation that was prepared.
I may have missed this because we are going straight to the important issues, yes. But I think it's important for you to state what position you held at Eskom at that time.
Sure, Chair. At this particular time, I was project director in the group capital division and reported, my direct line of report was Mr. Abraham Masango.
Okay.
Yes, I've also seen in your affidavit that you referred to Mr. Mabelani as your direct reporting line.
Yes.
So could you clarify that position? I think it's in a paragraph that I'm looking for, on page 1338.
Well, he will remember it off by heart.
I do. I don't remember it off by heart, but I know what Advocate is talking about.
Yeah. When were you reporting to Mr. Mabelani? When were you reporting to Mr. Masango?
Chair, without taking the Commission's time, this is always long stories, but in 2014, Eskom was experiencing a crisis with diesel deliveries to our Ankelich and Chorikwa plants in Mossel Bay and Cape Town. At that time, I was project director within the group capital division, and I was requested by my boss, who was at that time Mr. Dan Morakane, to assist Mr. Koko in the space of commodity sourcing to, by and large, make sure those deliveries, and it was close to about 155 trucks that were delivered on a daily basis to the Ankelich site, for example, to assist with that process to make sure the necessary diesel deliveries get to the site. And I then held my role in Group Capital as project director and supported Mr. Koko as the acting general manager for commodity sourcing. That role continued. I think Mr. Koko was suspended early in 2015. Mr. Mabalani then acted in Mr. Koko's place as the Group Executive for Technology and Commercial. I continued to report to Mr. Mabalani. In and around the beginning of, or the end of July, beginning of August of 2015, I was asked to lead the McKinsey negotiations on the MSA. And then for me, it proved very difficult to manage the group capital work because I had a portfolio in group capital that I used to look after, lead the negotiations with McKinsey and run the commodity sourcing area from a procurement process perspective. So I asked Mr. Mabalani if he could, if I could not act in that role anymore as commodity sourcing GM and just focus on my work in group capital and then also negotiate the contract with McKinsey. And that was prudent as well because then the process issues get dealt with by the procurement specialists.
So in this position of General Manager Commodity Sourcing, prior to the suspension of Mr. Mutshela Koko, you were reporting to him?
For a very short period of time, Chair.
So then, okay, then he gets suspended.
Yes.
Then Mr. Edwin Mabelani acts in his position.
Correct.
And then you reported to Mr. Mabelani.
Correct.
So when Mr. Koko comes back from suspension, I think it's 20 July 2015.
Yes.
Were you now, had you relieved yourself from that position of General Manager Commodity Sourcing?
Sorry, Chair. I was in the process of engaging with Mr. Mabalani at that time, just before Mr. Koko came back. And Mr. Mabalani finally announced the decision of me where I would stop acting as the GM for commodity sourcing, I think around the 5th of August or something like that. I have it on record somewhere, but okay. I can furnish that to the commission.
Yeah.
If needs be.
And so that was to allow you to perform the function of is it a lead negotiator? To lead the negotiations in respect of the MSA contract or would-be contract with McKinsey?
Yes, just to clarify, in Eskom's terms, what happens is the board delegates authority to usually an ExCo member, so a group executive level member, to conduct negotiations with a said company. In this case, it was McKinsey, and that delegation of authority goes to the group executive that is the one that is responsible for or accountable for the negotiation process. The negotiation process then has a lead negotiator. In this case, on the MSA, it was me. And the team then that supports the lead negotiator also gets defined in the documentation that goes to the board. But ultimately, the lead negotiator and the team that supports him, we have to then report to the delegated authority, which is the group executive that the board has delegated.
So who was the group executive?
So it was initially when the mandate to negotiate, Chair, was approved by the board, it was Mr. Mabalani. And then Mr. Koko, I think, returned, and forgive me if I don't recall the dates, Mr. Koko...
It is 20 July 2015.
Yes. Mr. Koko returned, and I was then also required to report to Mr. Koko because he's now back in his role. But also, I have to say that Mr. Mabalani remained involved. So Mr. Mabelani went back to his old position, which I think was Senior General Manager in the Technology Division. And he would have also, and the Technology Division of Eskom is where the top engineers program sat in terms of its history in Eskom. And so Mr. Mabelani, I was also reporting to Mr. Mabelani. So I was reporting to Mr. Koko and Mr. Mabelani on the progress of the negotiations.
Well, let's first take Mr. Mabelani. During the time of the suspension of Mr. Koko, what role did he play in the negotiations for the MSA?
Mr. Mabelani, the MSA needed to be set up in terms of the approvals that needed to go to the board. And if you recall, at that time, I was the acting general manager for commodity sourcing. So, Mr. Mabelani, and if Chair, if I can go to the relevant advocate, sorry, Chair, if we can just jump around to the MSA, which is on page 1338. And specifically paragraph 20.5.
That is at 1339.
Yes, sorry, Chair, yes, 1339.
Yes, continue.
So whilst I was reporting to Mr. Mabelani as the acting GM for commodity sourcing, Mr. Mabelani presented me with, if you can see in paragraph 20.5, a memorandum that was approved by Mr. Brian Molefe with regards, and it was the approval to continue with the top engineers program on a self-funding basis. He then Mr. Mabelani requested me to prepare the necessary board paperwork that then went to the board and the mandate to negotiate was approved by, first it went to the Exco Procurement Committee and then it went to the board tender committee, the BTC, to acquire the mandate to negotiate. And I think that mandate to negotiate is, and I'm sure I've attached it somewhere, Chair, or if not, then the Commission should have it on record in terms of the approvals that was made by the board. Yes. And I think there's a date in there, or there's a date associated with the approval. I can't remember the date.
The meeting of the BTC.
The meeting of the BTC. So the BTC approves the mandate to negotiate, and there's a little bit of a period that lapses because McKinsey is getting ready for the negotiations. We formulating Dr. Weiss, who was the McKinsey's lead at that time in terms of the Eskom engagement. He was putting his team together. We were putting our team together. We were finding slots in our diaries to start the negotiation period. So there was not much interaction with Mr. Mabelani initially, but then the negotiations happened from July till about end of August, Chair, beginning of September. Let's call it middle of September. And in that period, there were various items that were negotiated as part of the MSA, various packages, and feedback then had to be provided to the group executive for commercial and technology, who then ultimately signed off the documentation that went to the board, the BTC in October, where the recommendation was to conclude the contract with McKinsey and Company.
Yes. So that resolution is of 6 July 2015 by the BTC.
Sorry, Chair, is that the mandate to negotiate?
Yeah, I think that is the mandate.
To negotiate, correct, yes.
Well, I'm going to do this for you so that you can see exactly the focus of where we are at this stage. So you, in respect of the MSA, the instructions you say you received them from Mr. Mabelani to prepare the documentation for submission. Is that correct?
That's correct, Chair.
And the documentation were prepared on the basis that the appointment will be made on a risk basis.
That's correct, Chair.
As opposed to a rate basis, a fee rate basis.
That's correct, Chair.
And can you tell the chairperson when about was this, Mr. Govender?
When about the documentation was prepared?
Yes.
In about June, July.
In July 2015.
15, yeah, just before, it would have been prepared before the board actually approved the mandate to negotiate.
Okay. Now, I've seen in your affidavit that the risk base option was a route taken against the backdrop of lack of funding. In the sense that you say this project had started in 2013, 2014, but it stopped because there was no funding. And so it was decided that let's do a risk-based self-funding model and proceed with the project. Is that correct?
That's correct, Chair.
So in which event, the requirement to budget for a transaction would not apply, would be avoided.
Chair, that's not entirely correct, because the board provided us with a mandate to negotiate on a risk basis or self-funding basis. Mm-hmm. When we went through the negotiations with McKinsey wanted, as part of that process, certain upfront payments to mobilize their teams and to actually set up operations and so forth and so on. And in the feedback to the board, we, as part of the negotiation process, also included where the negotiation team did not fully align with the board's mandate. And we were clear in the documentation to the board that one of the things that we didn't align on with McKinsey was the issue of them wanting some upfront payments. And that was fed back to the board. So as a company, you would say then, well, we now certainly have to budget, if the board approves that, we certainly have to budget for these upfront payments, because over time it will net off as McKinsey makes the savings.
Yeah, okay. I don't quite correctly follow that. I understand the down payment McKinsey sought, I think it was 460 million.
Yes.
But the contract was said to be of zero value because it was self-funding.
Correct.
And the main thing, as I think you indicate in your affidavit, was that this contract was pitched on the basis that it will be a self-funding contract. It will be risk-based.
Correct.
As you say.
Correct.
Because there was no funding in 2014 to carry on with it.
Mm-hmm.
So my question to you was, because there is a requirement in your policy to have the finance person approve that there is a budget or confirm that there is a budget for this transaction before you can do the transaction. If it is now a self-funding contract, that requirement would be avoided. That's what I'm saying to you, and I want to know from you whether is that correct or not.
If there was no upfront or 460 million rand of upfront payments that was required by the service provider, then there would not be a need for us to set up a budget.
Now, there's an issue. Well, before I get to that issue, can I ask you before I forget about whether Mr. Koko himself, I asked you about Mr. Mabelani in the negotiations, what role he played, if any. Let me ask you the same question in regard to Mr. Koko. Did he play any role in
Yes,
the
Chair.
negotiations?
When, and I can't recall the exact dates, but now offhand, but as we were proceeding with the negotiations, we were getting to the end, and if you recall, I mentioned September was when we were starting to reach the end of the negotiation process. I think it was end of August, Mr. Koko asked the team, led by myself, for an update as to where we are with the negotiation process. And he was particularly interested in obviously moving the program along and wanted to know where were we with everything. And the team then assisted me to pen Mr. Koko a letter, giving him a full account of everything and every aspect of the entire negotiation process. So that was one interaction. The other interaction with Mr. Koko is that I sent him the service level agreement, which we were also, Chair, progressing in parallel with the negotiation. So if you recall, the service level agreement became the eventual contract. So we were progressing, completing the service level agreement, and there was interaction between Eskom Legal and McKinsey's Legal in terms of progressing the SLA. That's the one, the other issue. And there's a couple of other engagements that I can't recall offhand, but I do have on record, which I can provide to the Commission if needs be.
Yes. Yeah, if you could please provide us with that, it will be appreciated. Are these emails or also reports?
Will do, Chair.
Yes. I was asking whether is it emails or reports as well.
Oh, sorry, Advocate. No, they are emails and attachments.
Thank you.
Okay, before we proceed, Mr. Selega, did you get an answer?
I got the answer, Chair, that yes, some persons will leave at 7:30, but we are, I understand, able to continue until 8:30.
Okay.
Yes.
Okay, no, that's fine. Thank you very much to the staff and the technicians for their cooperation. Okay, let's continue.
Thank you. Then, Mr. Governor, let me go to the issue. Would you have been familiar with the Eskom directive on cost containment? It's a July 2014 directive of Eskom that seeks to implement the National Treasury instruction of 1/2013/2014, in terms of which, let me go into it, in terms of which you could only appoint consultants on a fee basis and not on a risk basis. Were you familiar with that?
Chair, if you ask me, do I know it in detail? The answer is probably not, but that document was very topical at the time we were concluding the MSA, very topical. So I don't know the details of it because the procurement team were the practitioners that kept up to speed with all of those type of documents.
Can I take you back to the earlier topic that Mr. Selega asked you about, just for one question? Was Mr. Koko's involvement during the negotiations limited to what you have said, namely just asking for report backs reports from you.
Chair, that's why I say to you, I can't recall, but let me go back through my information and see what is the full extent.
Okay.
Yes, and that I can provide to you.
Okay.
Well, can I also ask you this question? Do you know whether or not he engaged with the regiment's employees in the negotiation process?
Chair, not to my knowledge. I don't have I wouldn't know. Yeah.
So is the answer that you don't know?
I don't know, Chair.
Okay.
Yeah.
As the lead negotiator, did you engage with McKinsey officials?
Correct.
Did you also engage with regiment's officials?
Correct.
Which ones?
So Chair, let me give you some background. We had negotiated all of the packages except one package, which was the balance sheet unlocking activities. And the balance sheet unlocking activities, we only started negotiating that with McKinsey in and around the beginning of November 2015. At the time, McKinsey introduced two individuals in particular. It was Mr. Wood and Ms. Motepu, right?
Yes.
Because McKinsey used, at the time, regiments, which was where Ms. Motepu and Mr. Wood initially came from. And McKinsey had explained to us as the negotiating team that a company called Trillion was being formed, and they would ultimately become McKinsey's subcontractor, and that people from, and I think there's a I can't remember now, in the Labor Relations Act, there's a particular section that deals with that, where you transfer employees.
Yes, the chairperson knows it.
The chairperson will know it. But
the council also knows it.
but on that basis, there were employees that were being transferred.
That's 197.
Correct. That was being transferred from regiments into the Trillion company. And that is how we started engaging with Ms. Motepu and Mr. Wood initially, and then we proceeded with the balance sheet unlocking package negotiations during the month of November.
Okay. That November 2015?
Correct, Chair.
Yes. So you say the directive was topical at that stage?
Yes.
Because you would recall that it had to do with National Treasury approval. That if you were deviating from the directive, and in this case the deviation being appointment on a risk basis as opposed to a fee-based basis, you then required National Treasury approval. You recall all that?
Correct, Chair.
Yeah. Mr. Koko has come and said that approval was not obtained.
The deviation?
Yeah, the approval to deviate.
Yes.
He said it was not obtained.
Sorry.
Do you agree?
Eskom,
approval
at
from
the end of
National
the
Treasury was not obtained to authorize the deviation. Is that your
a formal deviation approval was not acquired from National Treasury.
Was not acquired or required?
Not acquired.
Okay.
Yes.
Yeah. So you agree with Mr. Koko on that score?
Yes.
Okay.
Yeah, because to get an approval, you must do a request in writing. And in fact, the National Treasury instruction says to obtain the approval, they have to engage the presidency and receive the consent of the presidency for the deviation. Were you aware of that?
Yes, I was aware of that because Mr. Mablani explained it to me. Remember, at that time, when we were going through all of this processes, he, and I think it was in late 2015, there was a organizational change. So, group technology and commercial kind of like split, where the commercial part of it fell under a chief procurement officer who reported into the chief financial officer, and the technology division, my understanding was that it joined the generation. So Mr. Koko, I think, became the head of generation and technology, and then Mr. Mabalani became acting CPO, chief procurement officer, and then CPO. So
you have said that the National Treasury approval was not obtained, but what do you say about whether it was required, it should have been obtained?
Chair,
are you able to say that, to say whether it was a requirement or was it not a requirement?
Chair, let me give you my account of what was happening at the time regarding this whole process, and forgive me if I have limited knowledge in understanding all of
that's fine.
The National Treasury stuff, and but yeah. In the process of running the negotiations, and in my feedback report to Mr. Koko, the negotiation team was of the view that this deviation application would be required for the risk-based contract. And it's in the report to Mr. Koko as well. And as we went forward in terms of the process, and I'm trying to think about how do I shorten it for you, Chair, because it's quite a long story, and it's actually it's also covered in my affidavit to some extent.
Well, you in terms of my question, yes, you can just give your understanding whether your understanding was that it was compulsory to obtain the approval of National Treasury in order to have the deviation, or your understanding was that it was not compulsory to get it, or you don't know?
Chair, at the time when I submitted, or when I submitted the report to Mr. Koko, and even at the time when we fed back to the board, and I think that was in September 2015, in terms of the feedback from the report, my understanding was at that time that the deviation was required.
Okay, and did that change at some stage?
Yes, Chair, and I can explain that to you as well. Yeah, and maybe I'll wait for Mr. Seleka. I don't want to.
Okay, maybe to finalize this point, do you want to explain whether it changed and how it changed?
Yes, Chair. So basically, this issue kicked around because there was an understanding in Eskom from I think the compliance officer who worked in legal, that this deviation was being was required. McKinsey did some of their own research, submitted an opinion from themselves, then eventually in the beginning of December submitted an opinion from Ledwaba and Mazwai. Forgive me if I get the name wrong, Chair, where it said that this practice note, or there was a practice note, if I could recall it correctly, was that allowed for this risk-based contract, allowed Eskom to enter this risk-based contract, was valid. So you could, valid in terms of Treasury and National Treasury, and Eskom could actually enter this contract on a risk basis. What happened at the time was that Eskom wasn't happy with that view. Eskom legal.
That is, enter this contract without the approval of National Treasury.
Yes, because you can in terms of the other rules of National Treasury.
But what you are telling me now is what the McKinsey opinion was saying.
Correct, Chair.
You are not giving your own view?
No, no,
Yeah.
no, no,
Okay.
no.
All right, continue.
Eskom was not happy with that, obviously, and then Eskom Legal also suggested that we get a separate opinion. And I think the separate opinion came from Advocate Kennedy, if memory serves me correct. And in that opinion, there was some, my understanding from Mr. Mabalani, there was some uncertainty regarding whether the practice note that allows for the risk-based, for Eskom to enter to this risk-based contract was actually still in place or it was repealed. So eventually what happened was in and around the beginning of February of 2016, Mr. Mabalani sent to Mr. Kalema and Mr. Dave Gori, the two procurement practitioners, to National Treasury to ascertain whether this practice note that allowed Eskom to enter into a risk-based contract was still valid. And they came back with a view, firstly verbally, that this practice note was valid, and then I think Mr. Gori, I'm sure I put it into my affidavit. If I didn't, I'm sure I've got the information somewhere. Mr. Gori sent Mr. Chichangano, if memory serves me correct.
The head of legal.
No.
The head of the legal department.
No, Mr. Chichangano worked at National Treasury in the procurement. He was the chief director in the procurement department. And I think I know he asked Mr. Chichangano whether this practice note was valid, and Mr. Chichangano replied. Now, I then asked the guys, the procurement team, including Mr. Mabalani.
And he replied to say what?
It is still valid that Eskom can use risk-based contracting. Or a practice note was valid. Implicit in the practice note was one of the contracting methodologies was risk-based contracting.
So as you understood it, did Mr. Chichangano say Eskom could conclude this contract without obtaining National Treasury approval?
Chair.
Or did he say you still need National Treasury approval to conclude this kind of contract?
He didn't say that, you have
Yes,
maybe we can go to that.
Yes, the email.
Yes.
Well, the page.
You can proceed.
The page in the paragraph is 13, in the affidavit, I beg your pardon, 1340.
Page 1340, that's where I am.
Paragraph 20.13.
Yes, in early February 2016, Mr. Dave Gori, Senior Manager Commercial, and Mr. Charles Kalima, Acting General Manager of Commodities Sourcing, met with Mr. Soli Chichangano of the National Treasury. Mr. Gori has effected an electric mail to Mr. Chichangano on about 4 February 2016, inquiring as to whether Parties Note 3 of 2003, which deals with risk-based payment basis, is still valid and effective, and later that day received an electric mail from Mr. Chichangano confirming that the aforesaid practice note is still valid. Please see attached here too. That's what you wanted to.
Yes, I wanted to highlight to you. Yes, I wanted to highlight to you that issue.
Yeah, and so maybe we should go to those annexures.
Yeah,
Annexure
okay.
E and 7.
Yeah.
Which is page 1399. Is that where you are, Mr. Governor? So there are two emails on that page.
That's correct, Chair.
Is that right? The one in the middle of the page is from Mr. Dave Gori, Thursday, February 4, 2016, to Mr. Soli Chichangano, CC Charles Kalima. Subject is practice note number SCM 3 of 2003. The email reads, "Good afternoon, Soli. Thank you for your hospitality this morning. We look forward to further productive engagements in the future. As we discussed, please confirm for us that practice note number SCM 3 of 2003, entitled Appointment of Consultants, is currently valid and effective for public entities such as Eskom. We understand that this practice note and others will be incorporated into a new set of regulations once the review process has been completed." And he says, "Best regards, Dave Gorey." And the email above, I believe, is a reply from Mr. Sitangano, correct? Just remember to speak to the mic.
So, sorry, Chair. That's correct?
Yes. Which, it's a reply on the 4th of February, 1523. Dave Gorey is being replied to, and CC it is Charles Kalima, Pukani Ndaba, Sindile Mnyelwa. And he says, "Dear Dave, practice note 3 of 2003 is still applicable until replaced with new instructions after the promulgation of the new Treasury regulations. The retainer/contingency fee principles are not clearly outlined in the practice note. If you intend applying them, you need to do some further work to ensure that you do not compromise the principles of Section 217 of the Constitution and other legislation."
That's a name where you were saying Mnyelwa, Mr. Selega.
Yes,
it's
yes, Chair.
Mnyelwa. MXUNYELWA. Mnyelwa. When you say Mnyelwa, it means something completely different.
Oh.
It's another meaning.
Okay.
Fortunately for you, it's a nice meaning.
Thank you, Chair.
So you won't be sued. Okay, all right.
Thank you. Thanks. Mr. Governor,
Yes,
did you have sight of these emails at the time?
absolutely, Chair.
Did you understand what is meant by retainer/contingency fee principle?
I assumed at the time and checked with Mr. Gori what that meant, and his view was that aligned to the basis for the contract in terms of MSA that we were negotiating.
But did you understand it?
Yes. I understood it to be that.
Yes, to be what?
To be the contract, the type of contract we were negotiating with McKinsey.
That it is a contingency fee contract?
That it is a risk-based contract.
A risk-based contract?
Contract, yes.
Is it the same as contingency?
I'm not sure, Chair, but my view, when I asked Mr. Gori about this, he said to me that is the case.
Now, what was your understanding of a risk-based contract?
That my understanding of a risk-based contract is that you enter into a contract with a party that continues to work, generates value, and then based on whatever parameters you negotiate with that company in terms of a success fee, that portion gets paid off to that company.
Okay, so if there is no success, there is no fee.
Correct, Chair.
Yeah, and that is the risk.
Yes.
Okay.
Yes. Now, the practice note which is referred to there is of 3/2003.
Yes, Chair.
But Eskom by this time, this is now 2016, that's even before the approval, after the approval by BTC to conclude the contract. By this time, Eskom had adopted for implementation the National Treasury Instruction of 1/2013/2014, which comes much later after this practice note, which you say you were aware of. It's an Eskom document, How did Eskom deal with that aspect of the practice of that directive in relation to what they received from Mr. Soli here? Because in terms of the directive, cost containment, it's mandatory. You are required to contract on a fee rate basis, failing which, ask for a deviation from National Treasury. So how did you, as the lead negotiator, or even the team you were working with, deal with this aspect within Eskom?
Yes, Chair. Maybe I could explain. The issue of whether we proceed with the contract or seek the deviation was an issue that was dealt with by the procurement department and specifically Mr. Mabalani. When we received this feedback from Mr. Chingano, I don't know, Chingano.
He will be more in trouble than I was.
I'm sorry. I'm sorry if I offend anybody.
No, I'm saying you will be more in trouble than.
I discussed this specific issue with Mr. Mabalani, and I asked him, how does this now allow us to continue with the contract with McKinsey? If you recall, at this stage already.
In other words, were you saying, how does this 2003 practice note or instruction allow us to proceed with this contract in circumstances where we are aware of the 2013 directive?
Correct, Chair.
That was the question.
Correct, Chair.
Yeah.
Correct, correct. So, if you recall, by this stage, Mr. Mabalani had already signed in December 2015 a notice to proceed with McKinsey and Company on the MSA. And I do not recall the exact wording, but when he signed that notice to proceed, and I'm sure it's on record somewhere in the pack, we were still unsure about whether we could proceed on the risk basis or not. So, and maybe we must just find that, Chair, so that I could read it out to you. But basically, in that document or notice to proceed, he said that if we can't continue with this on this risk-based approach, we'll have to come back to the drawing board, and that's the basis he signed it. Now we fast forward and we go into February. There's this engagement at National Treasury. The team comes back with this email. I discuss it with Mr. Mabalani and say to him, how does this allow us to continue? Number one, as per your question, in light of the fact you still got this 2014 and National Treasury guidelines, 2013 directive instructions. And the second part was, what does Mr. T not to get myself into trouble, mean when he says
Mr. Chitangano.
Yes.
It's actually easy.
Chitangano.
Yes.
What does he mean with regards to further work in terms of not compromising Section 217 of the Constitution? Because I think that's in the PFMA, if I'm not making a mistake.
Yes.
So there was discussion between Mr. Mabalani, Mr. Gori, and Mr. Kalema. And then Mr. Mabalani came back to me and said, look, this practice note, the fact that it's valid, and it covers the risk-based contracting approach, and it's not been, in his view, not been superseded by the 2013-2014 guidelines or practice directive, that he is happy that we could go ahead with the contract. And I'm sure if Mr. Mabalani would be much more proficient at explaining this to you, Chair, than I am. But that was my understanding. So they were happy. And the second part they were happy with was that this issue of the Section 217 was dealt with. And I then asked the question, shouldn't we have gotten something more formal back from National Treasury, instead of an email? Shouldn't there be an actual approval? And the comment was, this is how they dealt with National Treasury, and they've dealt with a number of transactions where they've got feedback through emails on direction to follow with the procurement department in National Treasury, and they followed that.
Yeah, because you see his writing is also not particularly clear, and he says the retainer/contingency fee principles are not clearly outlined in the practice note. And then he goes on to tell you, if you apply them, you need to do some further work to ensure that you do not compromise the principles of Section 217 of the Constitution and other legislation. Now, when he says they are not clearly outlined in the practice note, did anybody go back to him and say, what do you mean?
I don't know, Chair. I don't know.
In regard to the principles of Section 217 of the Constitution, did you understand what he was referring to?
I merely asked the question in terms of what was the issue with the 217, and both Mr. Gori and Mr. Mabalani confirmed that that this was not an issue for us, the section. But I didn't fully understand what it meant.
You know, it's competitive tender process.
So what Mr. Selega is doing is just for your information to tell you what the gist of Section 217 is. You understand that it requires that every organ of state that seeks to acquire goods or services, that it should do so in a manner that is fair, that is cost effective, that is transparent, and there is a fourth requirement. So that's a competitive process that it requires. Okay. Mr. Selega.
And here, sole sourcing instead was the approach followed.
Correct, Chair.
Let me accelerate, Mr. Governor. I saw in the minutes, you were part of the steering committee.
Yes.
I saw in the minutes of the first meeting.
Yes.
And I can open to it if you can recall, were you giving feedback? Something to the effect that you told the steerco that you had received Treasury approval for the conclusion of the MSA.
Chair,
shall I open?
Yes, yes, can we go to that?
There's Eskom Bundle 14, bracket C. Page 875.33. .33 is the minute of the 9th of February 2016, minutes of the Top Consultants Program Steering Committee. So once you've found them, please go to page 875.36, paragraph 8.
I have it, Chair.
Okay. It says a high-level MSO overview. A high-level overview of MSA was given by Trish. Is that yourself?
That would be me, Chair.
He informed the committee a letter
That is at what paragraph
Uh,
of the minutes?
8. Paragraph 8, Chair. Well, Mr. Governor also speaks at paragraph 7, but we don't need to go to 7.
Oh, you are at 8, okay, now I can see 8.
Yes. So a high-level review of the MSA was given by Trish. He informed the committee a letter of acceptance was issued to McKinsey in November 2015. National Treasury approved confirmation of the contract methodology for the risk-based approach with the Chief Procurement Officer's office. That's the statement I'm referring to.
Yes, I do admit the English is not very precise, but this feedback that I provided was discussed with Mr. Mabalani before the steering committee. And you would see, Chair, that as part of the attendance, Mr. Mabalani was there, Mr. Gori was there, Mr. Kalima, who were the procurement officials that were looking after the process. And this is what we aligned on in terms of giving feedback to the steering committee, and that was accepted by the procurement officials as well, because this this confirmation of captured in that email that came from yes, was what was articulated in paragraph 8 of the minutes.
Yes, but there's a clash or contradiction in the two positions, isn't it? Because the way the team of Eskom interpreted Mr. Soli's email was to the effect that we don't need Treasury approval because Practice Note 3 of 2003 still applies. But your reporting says the opposite. It says we in fact have received, well, I'm adding my words there, we have received National Treasury approval for this methodology of a risk-based contract.
But not in terms of a deviation approval.
Yeah, that's what you need to explain, because we see your statement, I think, to put it mildly, cannot be correct. That reporting.
My understanding was, Chair, at the time, in engagement with the procurement people and Mr. Mabalani, is that we could, based on the email that Eskom received, we could go ahead and contract McKinsey on a risk-based approach. We could go ahead with that contract that was negotiated. And that is what I was trying to articulate here. I was not trying to suggest that Eskom went and acquired a deviation from National Treasury, and in fact, further to what I said previously, where I asked, why can't we get a letter from National Treasury? My understanding and what I presented here was that it was the opinion of the Treasury, it was opinion of the procurement practitioners that this contracting methodology was something that Eskom could go ahead with.
So, are you saying the statement was just not? Was just not nicely captured?
Well,
to reflect that in
the English across all of these things are not 100% accurate, but I'm telling the Chair what my understanding was and what I actually said to the committee. And if I was wrong in what I said, The procurement officials could have easily raised their hands and said, but, you know, to the chairman of the steering committee, what Mr. Governor is saying is not entirely correct. This is what really happened.
Is the position not that what was critical for everybody was to know whether you needed the approval of National Treasury or not before you could proceed to conclude the contract? Is that not what was in issue?
Before you could conclude the contract, Chair? The contract you're talking about was concluded in terms of the notice to proceed, was in December 2015. At that time, there was no approval or discussions with National Treasury up until that time.
So what was the issue? Why did you ask National Treasury then, in response to which they sent you this email?
My understanding is because we had these two...
What was the issue? Yeah, that's what I'm... Yeah.
Yes, we had the two conflicting legal opinions, the one from McKinsey,
yes,
and the one from Advocate Kennedy.
Yes.
Where my understanding was that Advocate Kennedy's, in his legal brief or his legal opinion, basically said it is, or alluded in his legal brief that he was not sure whether the practice note, which is SCM 2003, was actually superseded by the 2013-2014 instruction. And his view, when he concluded his legal opinion, his view was that Eskom should go and apply for a deviation to move ahead with the legal.
Yes.
So that conflict, because you had the Ledwabo and Mazwai opinion, and you had this other opinion, Mr. Mabalani then decided, well, in his mind, it was a conflict.
Yeah, but now, on your understanding, why was it important to get clarity on this issue in the light of the two opinions?
Because, Chair, remember we signed Mr. Mabalani signed the notice to proceed in December. And we were starting to kick off the contract with McKinsey.
Yes.
But this issue of uncertainty still remained.
Yes.
And if that was not resolved, as per the notice to proceed that Mr. Mabalani signed, we would have had to then go back to the drawing board with McKinsey.
So it was important to get clarity in order to decide whether to proceed or to go back to the drawing board.
Yes, Chair.
Yes. Now, you were seeking to do that after the letter of acceptance.
Correct, Chair.
Yes. Now, at that time, the clarity you were seeking, is it not true that the clarity you were seeking was whether, in the first place, this was a matter or an agreement that should have been preceded by obtaining an approval from the National Treasury that you could deviate? In other words, was that not the issue that was still troubling you? Namely, did we need the approval of National Treasury to deviate, to conclude this contract or not? Because as I understand it, that was what was troubling people, that we don't want to go on only to find that later on we are told we should have obtained approval from National Treasury to deviate. We want to have clarity on that.
That's correct, Chair.
That is what was.
That's correct,
Chair. Was the issue.
Yeah, the ideal thing to have done would have been to sort the clarity first before we moved ahead.
Yes.
Yeah.
But now, coming back then to what you told the steering committee in paragraph 8, is it not correct to understand you to have said to them, National Treasury had confirmed or approved that you could go ahead and conclude the contract you say here, approved confirmation of the contract methodology for the risk-based approach with the Chief Procurement Officer's office. If that was the issue that that everybody was concerned about, should we have obtained approval? Weren't you saying here, National Treasury actually did approve, we did obtain approval?
Chair, what I was saying here and to the steering committee is the interaction I explained with regards to the email that the procurement
from Mr. Chatangano.
Yes, and my follow-up discussion with Mr. Mabelani and Mr. Gori about what that email meant for Eskom. And can we now, my question to them directly was, can we now proceed with the contract as a risk-based contract? And their answer to me was yes. And that is the basis of what I said here.
So you were saying, based on your understanding, and your understanding being based on what Mr. Mabelani had said to you, you were saying proceeding with this contract has the approval of National Treasury.
Chair, I was saying that proceeding with the contract was in line with what was allowed by National Treasury.
Yeah. So there was nothing wrong with proceeding as far as you understood the position.
From the procurement team, yes.
Yeah.
Yes.
Okay. Mr. Seleka?
Yes, thank you, Chair. Mr. Governor, it would be difficult, I suppose, even for the people on SteerCo. The SteerCo is chaired by Mr. Singh.
Correct, Chair.
Mr. Koko was there.
Correct, Chair.
Mr. Mabelani was part of it.
Correct, Chair.
And he was the Chief Procurement Officer.
At that time, yes.
And so there's a directive of Eskom of 2014, which implements the cost containment of the National Treasury instruction. It is reviewed in 2015. And you have another, what they call a position paper by Mr. Machela Koko in August, which he signs the same National Treasury into law at Eskom. It's law anyway, because it's a National Treasury instruction which forms part of the Act, because the PFMA says it's comprised of the provisions of the Act and the instructions issued by the National Treasury. So it would be hard if you have those internal documents of Eskom to say, fairness to you, that your team was misled by that statement. They should have known.
Chair, firstly, it's news to me that there was a subsequent document in 2015, and then there was something that Mr. Koko signed into law.
Well, I'm using the phrase into law.
Because I was not aware of that, because I was not part of the procurement function. But there were a number of people in that committee that would have known exactly where, or exactly about what Advocate Seleka is talking about in terms of the documents he's referred to.
Yeah, because if National Treasury approval is required, as Mr. Koko has said, which I believe is correct. The failure to obtain it is fatal to the conclusion of the agreement. In other words, you can't conclude that agreement and it be a valid and standing agreement. You understand?
I do understand, Chair.
Yeah. So, because you ultimately, Steerco decides to terminate the MSA, and one of the reasons is that there's a growing concern within Eskom legal that you require National Treasury approval. You remember that? In one of the Steerco, you want to be refreshed?
Yes, Chair, because maybe I don't recall that because I suppose you're talking, sorry, Chair, I'm talking to Advocate Seleka, but I wanted to find out if Advocate is referring to the reasons for terminating the MSA.
Yes.
And what was presented to the board.
Yes.
In terms of the termination.
Correct, yes. As the reasons for terminating.
Can we have a look at that submission that went to the board?
Yes.
Yes.
The investigator.
Because I do recall, Chair, there was a concern with regards to National Treasury, but I don't recall whether there was a growing concern in the growing concern in Eskom legal. I can't remember.
Yes, no, it's one of the reasons. Thank you. So that is Eskom Bundle 14, bracket C.
Bracket
C.
How do we find that?
It's not the one we were using just now, eh?
I was said.
That has got the minutes.
Yes, I
It's
think
not
that's
that
the one,
one.
Chair.
It is the one.
It is the one. Bracket C, page 829.19.
Okay, you say where must we go? What page?
829.19.
Eight 29.2.
19.
92.
0.19.
Start afresh, please. Page
229.
229.
Yes. 0.19.
0.92.
0.19.
Okay.
829.19.
You swallowing in your words today, Mr. Seleka. Okay. No, it can't be this same bundle because this one doesn't have 229. It can't be the same bundle. This bundle starts somewhere at 600 and something.
I have the minutes.
So just repeat.
829.
Yeah, you see, this is bundle 14 that we were looking at, the 14C.
Yes, that's the one, Chair. 14C.
Okay.
Mr. Chair,
Eskom bundle 14C, page
829.
29.
Yeah, 829.
829.
Yes.
You are swallowing your.
Am I?
Yeah, 829. I thought you were saying 229.
No, 829.
Okay. No.
Mr. Chair, may I indicate, I've got a similar challenge to you, but at a
Yes.
different level. I've received these bundles electronically last night,
Yes.
and I have extreme difficulty locating the exact page we're referring to. I haven't got a hard copy available.
Oh, is that so?
Yeah, this is some 6,000 plus pages that we received electronically last night. So I've got it
Yes.
electronically, so it's very difficult and challenging to find the actual page.
Yes.
I believe Mr. Governor is possessed of it, but we can't, I mean, I can't follow and intelligently consider what is being put to the witness.
Yes.
On the electronic,
Is there a spare hard copy that can be given to his counsel, Mr. Governor's counsel?
Can I say what my electronic copy has? It's got an electronic pagination at the top. If I could have that page number, I'll find it. Mine is, for example, I've got 3,852 pages. If I could have the page number, I'll be able to get it.
yes, I know those page numbers are sometimes misaligned. The electronic copy is 3034.
3034.
Yes.
I'm indebted to
Oh, okay, all right. Is there somebody who could check the electronic pages each time we make a reference to the hard copy pages so that he can follow? Okay,
It would be very helpful.
all right. You said on the hard copy it's 829, Mr. Selega?
Yes, Chairperson.
And after 829 is point what?
0.19, 0.19.
Okay. Okay, this is a submission document.
Yeah.
Okay,
I think what I'm looking for maybe the reasons are there, Mr. Governor. There's one particular reason which I'm referring you to.
these are reasons for what? Just to,
For the, so this
Calculation.
document here is a submission document dated 9 June 2016. What is being sought here is a resolution from the BTC to cancel the McKinsey risk-based process or the contract.
okay,
And they give the reasons on the next page. In those bullet points on page 829.20. But I must have seen the reason I'm looking for somewhere else, Mr. Governor. Because the solid bullet points on page 829.20, Chair, solid bullet points, reads on 25 February 2016, McKinsey responded to Eskom's letter. It is Eskom's view that the letter did not fully address the concerns raised. Bearing in mind that, the next bullet point, bearing in mind that the McKinsey risk-based process was conducted via sole source, albeit permissible within the approved procurement procedures, such contracts attract a higher level of scrutiny. Next bullet point, one such contract with McKinsey that was awarded during the course of last year for the rapid finalization of the corporate plan and key inputs for National Treasury equity injection has been the source of an audit finding to which the necessary management response were provided. Furthermore, National Treasury has requested key information regarding contracts with McKinsey. What the picture I have in mind is, I might have read that in Mr. Mabelani's affidavit, but I'll have a look at it in a moment. Let me exhaust his reasons. The above bullets create a significant need for management intervention to formulate all of the responses and detracts from the delivery of key business objectives. Then you have the next bullet point. With this in mind, it may be prudent to terminate the contract finalization process for the McKinsey risk-based contract. It is management's view that McKinsey will have to be compensated for work carried out to date. Such costs will need to be negotiated and finalized with McKinsey. And the last bullet, it is penultimate. It is recommended the approval for the costs be presented to the appropriate tender committee for approval of payment. Then you have the last one, which doesn't address the issue I wanted to raise with you. But there is captured the National Treasury requiring information regarding the contract as one of the reasons why we would rather terminate the contract. And the contract was then terminated as a result of this submission.
Well, the board approved the termination process, yes.
So if you take the evidence of Mr. Koko, let me paint a picture for you. That the writing was on the wall, he uses those words, already in March, February, March 2016, that National Treasury approval was required. The contract could therefore not be concluded without National Treasury approval. So what follows thereafter, it's a purported conclusion of the agreement. So the parties purport to conclude the agreement. You understand what I'm saying? They act as if they conclude in the agreement when the agreement is in fact a nullity because of the lack of prior approval.
Yeah, I don't understand fully what.
Well, I'm thinking Mr. Selega may be expecting too much from
an engineer,
lawyer.
I'm sure you saw my qualifications. I'm just a humble engineer.
Okay, let's.
Let me ask this question.
Yes, Chair.
When was it that the board approved the cancellation?
In June, Chair.
In June?
Yes, Chair.
And that's the approval. And when did the actual cancellation happen, as far as you know?
So,
I mean, the board takes a resolution, but somebody must implement the resolution. So that's what I'm talking about. When was the implementation of that resolution of the board to say this must be cancelled?
So let me start with this submission that went to the board on the 9th. This submission was preceded by a steering committee meeting. I can't remember which number was it, but I think it was in early June.
Yes.
The steering committee.
Okay.
And then I think, Chair, if memory serves me correct, in that meeting there was an open session and a closed session. There was a closed session with only the main members of the steering committee, which was chaired by Mr. Singh. And then there was an open session that included McKinsey and Trillion staff. So the decision to cancel, and basically the reasons you see here for the cancellation was discussed and then was actually formulated into this feedback report that went to the board. So what happened thereafter was there was an implementation process based on the board's mandate, based on the board's decision to cancel the contract. And it was agreed in a subsequent steering committee that, I think it was in July, that the tracking tool that was used to capture the initiatives across the organization, over 1,600 initiatives, would be frozen as of that date in terms of all its approvals and governance approvals and so forth, so that you could do a calculation as to what the fees would be then due to McKinsey. Subsequent to that July meeting, there was another steering committee in August. And in that steering committee, there was payments or partial payments requested by McKinsey and Trillion. And that ended up going into a submission that went to the BTC in August. So effectively, what then happened was, post-August, the agreement with McKinsey was that they would remain on the ground so that the actual board decision of cancellating the contract and the subsequent work could be transitioned to another party. So that was the, how can I say to you, the sequence of events in terms of how the implementation of the board's decision happened.
But the actual termination or cancellation happened when? Are you able to remember that? In September, in October, in July, in August?
Oh, the
With
final
all of this?
termination agreement, Chair, happened in, I think it was February 2017. Was it 2016?
Well, I'm not sure that anybody has talked about.
No, they have. Mr. Govender also talks about it in his affidavit. But Mr. Govender, I think that's a very simple question. You need to tell the chairperson the date of termination of the letter, which you do mention the date in your affidavit, which is the letter of termination by Mr. Mabela.
Okay.
Yes.
Sorry. I now understand. No, sorry, Chair. Apologies. So after this decision was, the board had taken the decision. Mr. Mabelani penned a letter, Mr. Mabelani penned a letter to McKinsey informing them of the board decision of termination.
And that was when? Was it June,
It was June, Chair.
Yes.
Yes.
Okay.
Yeah, but there is a discrepancy there, because the termination was in fact made before the board, I think it was the BTC, before the BTC made the decision to terminate. So Mr. Babelane writes the letter on the 16th of June, 2016. 16 June 2016. That's the anniversary date. Terminating. But BTC only set on the 22nd of June to resolve to terminate.
Sorry, Chair, I was not aware of that. I was not aware of that because this submission that was prepared is dated the 9th of June, and you could see that I supported it based on the fact that it was prepared by myself and the project management team, and it was approved by Mr. Mabelani on the 6th of the 6th. So I was not aware that it only got to the board on the 22nd, Advocate.
Yeah. You see, I think you kind of dealt with that in your affidavit, which is Eskom Bundle 14D, page 1341. And you do give the date when Mr. Mabelane cancelled the MSA. Mr. Mabelane advised me that he formally notified McKinsey of the cancellation decision on 16 June 2015.
But in his letter, did he then go on to talk about what would, some transitional arrangements or what?
I don't think
provided for what Mr. Governor was saying happened in August and so on. In other words, that the board had said terminate. And then his letter said it's terminated.
Yes.
But we know that McKinsey continued, isn't it?
Correct.
To do some work.
Yes.
So was that based on something that he said in that letter? Because otherwise, one would have expected that if they say the contract is terminated, McKinsey would stop.
I can't recall offhand, but now I have the letter in front of me,
Yes,
which is dated 16 June 2016,
yeah.
addressed to Dr. Vice, termination of top consultants group MSA. This letter serves to officially notify McKinsey & Co. of a board decision taken on 9 June 2016 to terminate the McKinsey risk-based contract. You are hereby requested to engage with Mr. Prishgavanda to discuss the pertinent issue to give effect to the board resolution. In conclusion, Eskom will embark on a transparent procurement process to reallocate the activities under the risk-based contract. McKinsey & Company is welcome to participate in this process. And he signs it. For the record, I'm going to give the page number, and please look for it in the electronic, or he has it. The electronic is page 3222. In the hard copy is 877.26, and this is Eskom Bundle C.
So in the letter, it doesn't talk about what was to happen after the termination, other than that he said Dr. Vice should talk to Mr. Governor about the implementation of the termination resolution.
Correct.
Yes.
To give effect to the board resolution.
Yes.
That's correct, Chair.
Was it then in your discussion with Dr. Vice that this idea that McKinsey could continue doing some work that arose and was agreed, or what?
No.
Where did that come from?
So when Mr. Mabalani penned this letter to Dr. Vice, Dr. Vice and the project management team from Eskom, which was led by me, got together, and there was a McKinsey team that was with Dr. Vice. He wasn't on his own. And we were deciding how best to bring this process to a conclusion. And part of that conclusion process was a couple of key things that we had to take care of. One was the fact that there was work ongoing extensively across the organization, in many parts of the organization, and how best to bring that to close. This auditing wave tool that I discussed with you was an issue of how did we now terminate that. The third part of this equation was, you can't just draw a line in the sand and say McKinsey is off the ground because you lose a whole lot of value immediately. You need to transition it to a new vehicle, a new delivery vehicle, in the form of another contractor, or perhaps even back to the Eskom people to carry on. So those issues were discussed with Dr. Vice and myself and the teams. It was one part of that issue was how do we deal with the wave tool, was presented to the steering committee in July. And the steering committee accepted the fact that as of the 15th of July, we'll do what we call a true-up, basically freeze it and see, freeze the wave tool and see what's the implications in terms of all of the approvals. Then there was a steering committee in August, particularly to address how do we move the program aspects to other entities. And out of that steering committee in August, or in that steering committee in August, bearing in mind that we did not pay any down payments although we asked the board to approve it, and the board did approve it. The consultants in that committee, memory serves me correct, were complaining about the fact that they had worked already for 8 odd months, 9 odd months, and they had not received any payment at all from, even though value was created. And so that committee took a few decisions. Those decisions ended up to be part of an August submission that went to the BTC. And I'm sure that Advocate can point out the August submission, it's on file as well. And that August submission, if memory serves me correct, had mentioned a transition period. Yeah.
And that was, you say that was a resolution of the BTC?
Correct, Chair.
And it was in August?
Yes, it would be on file here.
Okay, no, that's fine. So in other words, are you saying that whatever work McKinsey did after they had been notified that the board had taken a resolution to terminate the contract, whatever work they did after that was at some stage in August given approval by the BTC to say there is a transitional period, and in effect gave a blessing to whatever you might have thought should be done, because you took the view that you couldn't just take a deadline and say,
yes,
this ends. You needed to think about what the implications would be, yes, and make some, yes, arrangements so that there would be some value to Eskom, yes, of the contract.
Correct, Chair. And the August board submission, the board approved some payments at that stage, and they approved this transition period. And McKinsey, as part of the discussions, the negotiations with them to bring this whole process to an end, wanted to get paid during that transition period as well. They wanted to get paid, not on a risk basis, they wanted to get paid on a fixed fee basis. And that actually went into the submission as well. And they actually did submit one invoice to us after they got paid in August for that period. And, but we didn't pay that invoice because Mr. Singh was very adamant that we should make sure that we properly bring this whole process to a conclusion, and he wanted certain things looked at. He wanted the value of the contract looked at, he wanted a legal review done, and he wanted the contract to be audited. So he didn't want to actually, he wanted to follow a proper process to get that done.
Yeah, well, that said, Mr. Governor, there is a minute of steerco. You know, just piggybacking on the chairperson's question. The minute of 15 July 2016, where key objectives are recorded, the page number is Eskom bundle, I think that's the one you have, bracket C, it's page 875.61. For the electronic page is 3187. 3187. It's a minute of 15 July 2016. So that's the beginning of the minute. You turn to the next page, paragraph 8, and you can explain this to the chairperson. Paragraph 8 deals with key objectives.
Sorry, Chair, just to confirm, are we looking at the 15th of July or the 4th of August?
15 July.
That's on 875.65.
No, 875.61.
Oh, sorry.
So there are key objectives on the next page, point 62, paragraph 8, and you can explain that to the chairperson. One of the key objectives, the penultimate, the second from the bottom, all MSA activities will, I think I got the spelling wrong, cease as of today till further notice as per steerco instruction from McKinsey management.
Yes. And that related to my comment to the chair insofar as freezing the wave tool. Yes.
So you address that?
Yes.
So it says all MSA activities here.
No, this wasn't
supposed to be to stop
immediately and walk out.
Yeah, no, they're going to spell
No,
it
no,
wrong.
The minute taker didn't know how to spell that.
Let me give you, I know that's probably, Chair, a lawyer's view, but let me give you the actual events that happened in a sense. This statement is in relation to the wave tool. So you freeze the wave tool, so you don't allow anybody to make any more approvals. So you don't allow the value because every time in a stream, I'm sorry to use the Commission's terminology now, but in a stream, for example, you had the claim stream, you had the generation stream, you had the procurement stream. Every time somebody in those streams, whoever the stream lead was, made an approval in the wave tool, you would have had an implementation level trigger that would then make Eskom liable to pay additional money to McKinsey. So the decision, what we talked about here was that wave tool needs to be frozen. But the actual activities that was ongoing could not all of a sudden, just you drop everything. If the guys were busy at some mine improving the operations at the mine, you just can't just drop it and leave. There had to be a logical transition period, a process undertaken.
Yeah.
And that actually, that thought process, Chair, like I described, went into the board submission in August and was approved.
You're keeping an eye on your time, Mr. Select.
Yes, that's what I was doing now, Chair.
Okay.
I see he's running away from us. Mr. Gavin, I'm going to do this because I was addressing the issue of the distinction between the date of the termination, actual termination, and the date of the resolution by BTC.
Yes.
It's still in that same document, the BTC decision you found on page 875.1. They will find the
Sorry, Chair, let me just get to that
electronic
space.
page for you. So it's an extract from the final minutes of Eskom Board Tender Committee.
871 point?
875.1. Electronic 3126.
875. Yes, I've got it. Thank you.
Yeah. Extract from the final minutes of Eskom Board Tender Committee held at Uvonkulu Boardroom on 21 June 2016. And you have the Board Tender Committee grant, it was resolved. They grant approval to cancel the McKinsey risk-based process. Allow all costs to be negotiated and finalized. So in his affidavit, Mr. Mabelani says, this is the date when the BTC resolved to cancel